ಹೇಳಿ.
ಪೇಜ್ ವೈಸ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕರಿತೀರಾ? ಪೇಜ್ ವೈಸ್ ಅಡ್ಜರ್ನ್ಮೆಂಟು ಫೈನಲ್ ಇಯರ್ ಹೆಂಗಿರೋದು ಕೊಡ್ತಾರಾ ಅಡ್ಜರ್ನ್ಮೆಂಟು?
ಕಳಿಸಿ. May I request for posting of a case for this reason, my lord. Under 138 proceedings, the petitioner is taken to custody and it is for the past 6 days he is in the custody. Therefore, there is urgency. There is, yes, ma'am. Please oblige.
Hardship kindly filed in, this honorable court has granted an interim stay to deposit the report within the period of 4 weeks. I have filed an application for extension of time.
ಆರ್ಡರ್ ಆಗಿರೋದು ಯಾವಾಗ
17 months.
17-1 ಆಯ್ತು ಕೊಡಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ನೋಡೋಣ ರೀಸನ್ಸ್ ಏನಿದೆ ನೋಡೋಣ.
My lord, for respondent, my lord, to withdraw the deposited amount.
ಅಯ್ಯ ಹಾಕಿದೀರಾ
Yes, my lord.
ಅಯ್ಯ ಹಾಕಿದಿರಿ
ಹೌದು.
ಆಯ್ತು ಕೊಡಿ.
My lord, I have filed an IA for stay of the impugn order passed by the session judge.
ಆಯ್ತು ಅರ್ಜೆನ್ಸಿ ಏನು
ಅದು 10 lakhs ಇದೆ my lord. Within 3 months ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ 6 months imprisonment ಹೋಗ್ಬೇಕಂತ.
ಆಯ್ತು ಕೊಡಿ ನೋಡೋಣ.
Lordship, one matter for tomorrow. This honorable court passed an order for suspending sentence under 138 case, and in the same cause of action before the execution case property ಎಲ್ಲ ವಾರಂಟ್ ಆಗಿ ಅವರು ಪಾರ್ಟ್ ಪೇಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಏನಾಗಿದೆ ಮಾಡಿದೀರಾ ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಿರಾ ಇಲ್ಲ?
ಅದ್ ನಾಳೆ 2 days ಗೆ ಎಕ್ಸ್ಪೈರ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ನಾನು ಐ ಹ್ಯಾವ್ ಟು
ಈಗ
ಪ್ರೊಡ್ಯೂಸ್.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಗೆ ಬಂದಿದ್ದೀರಾ?
ಹೌದು ಹೌದು
ಕೊಡಿ
ಸ್ವಾಮಿ.
ಕೊಡಿ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ. ಜಿನೇನ್ ರೀಸನ್ ಇದ್ರು ಕೊಡೋಣ.
ಮಚ್ಚ
ಲೈವ್ ಸ್ಟ್ರೀಮ್ ಆಯ್ತು.
Mentioning from page number 4, 30-31.
Serial number 31, my lords. Will be taken up next week, my lord. Senior is not.
My lord, I have an objection with regard to serial number 31, my lord.
Objection
They are not
assist ಮಾಡಿ ಕೋರ್ಟಿಗೆ ಅಷ್ಟೇ. I have read the papers, you assist the court.
they are not deposited also the.
Yes, I am not granting any adjournment. 21
Okay,
matters.
okay.
32 to 35, 36 to 42, 43 to 52,
44 ಏನಾಗಬೇಕು ಹೇಳಿ? ಏಕೆ why you want time? That cannot be a ground. ಏನ್ 30 months ಒಂದು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಫೆನ್ಸ್ ಇದೇನು ಇದ್ದಂಗಿದೆ 457 380 2 years ಅಪೀಲ್ ಅಲ್ಲಿ ಕಡಿಮೆ ಮಾಡಿದಾರಲ್ಲ. ಮತ್ತೆ ಪೂರ್ತಿ ಕಡಿಮೆ ಮಾಡ್ಬೇಕು ಇಲ್ಲೇ ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೋರ್ಟಿಗೆ. ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ನೋ ಐ ಹ್ಯಾವ್ ರೆಡ್ ದಿ ಪೇಪರ್ಸ್, ಯು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್. ಅಲ್ಲಿ 18 ತಿಂಗಳಿಗೆ ಇಳಿಸವ್ರೆ, 30 ತಿಂಗಳು ಇದ್ದಿದ್ದು 457 ಗೆ 380 ಗೆ 2 years ಇದ್ದದನ್ನ 1 ವರ್ಷಕ್ಕೆ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
46 connected matter.
46 ಏನಾಗ್ಬೇಕು ಹೇಳಿ?
May be posted along with 969 of 22, my 969 of 22.
22 ಅದರ್ ಸೈಡ್ ಇದೀರಾ? ಆಯ್ತು. ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್ ಅದರ್ ಪಿಟಿಷನ್ other revision petition 969 of 22 is also connected.
Yes,
connected.
yes, my
Connected, and counsel for the respondent also not disputes the same, and hence list both the same together. ಯಾವ date ಕೊಡಿ?
how date?
53.
Great.
Sir,
Serial number 48, my lord.
Serial number
48. Very short accommodation, my lord.
48.
Yes, my lord.
Other side ಇದರಾ?
ಇಲ್ಲ sir.
Intimate ಮಾಡಿದೀರಾ?
ಅವ್ರ ನಂಬರ್ ಸಿಗ್ಲಿಲ್ಲ sir.
ಅಂದ್ರೆ ಡೇಟ್ ಇಲ್ಲ.
ಫ್ಯಾಮಿಲಿ ಹೆಲ್ತ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಸ್ವಾಮಿ, ಅದಕ್ಕಾಗಿ.
ಏನೇ ಇದ್ರೂನು ಹೇಳ್ಬೇಕು ನೀವು. ಅದರ್ ಸೈಡ್ ಹೇಳಿ ತಗೊಳ್ಳಿ, ನಾ ಕೊಡ್ತೀನಿ. ಯಾಕೆಂದ್ರೆ ಅದರ್ ಸೈಡ್ ಆಬ್ಸೆನ್ಸ್ ಅಲ್ಲಿ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ. ನಮಗ್ ಇದ್ ಮಾಡೋದ್ ಬೇಡ.
Serial number 53, my lord.
ಸೀರಿಯಲ್ ನಂಬರ್
53 admission senior.
ಬಂದಿಲ್ಲ. 53 ಹೇಳಿ ಏನಾಗಬೇಕು?
Senior ಇಲ್ಲ my lord, convenience. ತುಮಕೂರ್ಗೆ ಹೋಗಿದ್ದಾರೆ senior admission. ತುಮಕೂರ್ಗೆ ಹೋಗಿದ್ದಾರೆ.
ತುಮಕೂರಿಗೆ ನೀವು ಇರಲ್ಲ ಸಾಕು. ನಿಮ್ ಸೀನಿಯರ್ ತುಮಕೂರಲ್ಲಿ ಇರ್ಲಿ, ನೀವು ಬೆಂಗಳೂರಲ್ಲಿ ಇದಿರಲ್ಲ ಸಾಕು. ಏನೋ ಡಿಲೇ ಇದೆ ಇದ್ರಲ್ಲಿ. ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಇದೆ ಅಲ್ವಾ ಮೇಡಮ್?
ಹೌದು sir.
ಆಯ್ತು. ಇಶ್ಯೂ ನೋಟಿಸ್ ಆನ್ IA number 1 of 24 and also on ಮೇನ್ ಪಿಟಿಷನ್ ಅಷ್ಟೇ. ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಲಿ. ನಿಮ್ ಸೀನಿಯರ್ ತುಮಕೂರಲ್ಲಿ ಇರ್ಲಿ.
Serial number 70, 2 weeks time maybe.
ಸೀರಿಯಲ್ ನಂಬರ್
7070.
Page
ನಿಮಿಷ ಇರ್ರಿ.
55 to 65.
55 to
65. Page number 24.
55 to 65. ಯಾರಿಲ್ವಾ?
66 to 76.
66, please, my lord. Serial number 66.
ಹೇಳಿ ಏನಾಗಬೇಕು? ಹೇಳಿ ಏನಾಗಬೇಕು? ಅದರ್ ಸೈಡಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದಿರಾ? Petitioner counsel seeks time and also submit that already intimated counsel R.B. Deshpande. Then list this matter on, ಯಾವಾಗ್ಲಾರ date ಕೊಡಿ madam.
ಮಲ್ಲ serial number 69 ಮಲ್ಲ
69, ಏನಾಗ್ಬೇಕು ಹೇಳಿ.
senior is out of station ಮಲ್ಲ 2 weeks time.
Out of station is not a ground counsel. Next,
66, please, Mila.
66 ಹೇಳಿ, ನಾರಾಯಣ ಸ್ವಾಮಿ KN.
Please, Mila.
ಹೇಳಿ, why you want time?
I am not feeling well.
Huh?
I am not feeling well. Please.
ಹೌದಾ, ಏನಾಗಿದೆ? ಕರೆಕ್ಟ್ ಆಗಿದ್ದೀರಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಜ್ವರ ಇದೆ.
ಜ್ವರ. Petitioner counsel seeks time and HCGP, third note ಕೊಡ್ರಿ HCGP. 66 ಅರ್ಜನ್ ಆಗ್ತಾ ಇದೆ. And HCGP also present. List this matter, date ಕೊಡಿ madam. 5/3.
Serial number 70, 2 weeks time may be granted.
17.
70.
ಯಾಕೆ why you want time?
I need certain instructions from the client.
Instructions ಗೆಲ್ಲ ಡೇಟ್ ಇಲ್ಲ.
2 weeks time may be.
Revisions ಅಲ್ಲೆಲ್ಲ instructions, want of instructions ಗೆಲ್ಲ dates ಇಲ್ಲ. Just come and assist the court.
2 weeks time may be granted. I need certain.
ಅರ್ಥ ಆಯ್ತಲ್ಲ ನಿಮ್ಗೆ? 3 times ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ರಿವಿಷನ್ಸ್ ಗೆಲ್ಲ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಏನ್ರಿ, ಫೈಲ್ ಓದ್ಬೇಕು, ಅಸಿಸ್ಟ್ ಮಾಡ್ಬೇಕು ಕೋರ್ಟ್ಗೆ ಅಷ್ಟೇ.
2 days.
7 and 78.
77 and 78.
Non-comprehensive first time, seal number 1.
Petitioner counsel absent, 2 weeks time granted.
Seal number 2.
Vijay Shetty, B.
2 weeks time may be
2 weeks time granted as sought.
3.
Rakshit R,
In this case, I'm
Ah.
for petitioner, my lords. I pray for a week time. my lords.
weeks time granted as sought.
Much obliged.
4.
Manjunath MR, 2 weeks time granted as sought.
5.
Ranjan Kumar K, absent, 2 weeks time granted. Second time, Jyoti B Kangokar.
Appearing for petitioner, my lord.
ಹೇಳಿ.
Kindly 2 weeks time.
ಎಷ್ಟು?
2 weeks, my lord.
2 weeks time granted as sought.
7.
Mahesh
Mahesh
KH, counsel absent, 2 weeks time granted.
8.
Milash Arol Narona.
Milords, I appear for the petition.
ಹೇಳಿ.
Because 3 objections have been raised. I've incidentally.
ಎಷ್ಟು ದಿವಸ
mentioned-
ಬೇಕು ಹೇಳ್ರಿ? ಸೆಕೆಂಡ್ ಟೈಮ್ ಕೊಟ್ಟಿದೀವಿ, ಎಷ್ಟು ದಿವಸ ಬೇಕು?
My lords can kindly indulge me for 2 minutes. Signaturally, the trial court, the first appellate court has made a mistake. Inadvertently by mentioning under the signature, the date 2022.
ಡೇಟ್ ಹಾಕುವಾಗ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆಯಾ?
Judge has signed.
ಆಯ್ತು, ಅದು ಓವರ್ ಆಲ್ ಮಾಡೋಣ. Next
Milords, and district and sessions judge ಅಂತ mention ಮಾಡಿದ್ದೀನಿ.
Memorandum of petition wherever necessary ಅಂತ ಎಲ್ಲ ಕಡೆ ನಾವು ಕರೆಕ್ಟ್ ಮಾಡಬೇಕು. Date ಅಂತ ಹೇಳಿದ್ರೆ
ಡೇಟ್ ಒಂದು ಮಿಸ್ಟೇಕ್ ಇದೆ, ಆಯ್ತು ಅದನ್ನ
ಅದರಲ್ಲಿ
ಆಯ್ತು. ದಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನಂಬರ್ 1.
ಅದರಲ್ಲಿ district and sessions ಅಂತ mention ಮಾಡ್ಬಿಟ್ಟು.
February 24. ಯಾವ್ದು ಓವರ್ ರೂಲ್ ಆಗ್ಬೇಕು? ಏನದು?
Judgment passed in total appeal. Mentioned in preamble portion differs with the date mentioned at the page number 27.
27.
Milords is 40 Milords.
23rd, 1 second, 23rd October 2024 ಅಂತಿದೆ. Only one date, ಇಲ್ಲ 23rd ಇದೆ. 23rd. 24 ಏನೇ ಕರೆಕ್ಟ್? ಇಲ್ಲೂ ಕರೆಕ್ಟ್ ಇದೆ. 27. ಓ ಇಲ್ಲೇ ಒಂದ್ ಸರಿ ಇದೆಯಲ್ಲ ಮೇಡಮ್, 27 ಅಲ್ಲೂ ಇದೆಯಲ್ಲ. ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ 97 of 24 ಅಂತಲೇ ಇದೆ.
Page number 27 would differ on the
ಪ್ರಿಯಾಂಬಲ್ ಆಫ್ ದಿ ಅಪೀಲ್. ಪ್ರಿಯಾಂಬಲ್ ಅಂದ್ರೆ ಪ್ರಿಯಾಂಬಲ್ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ 23 97 of 2024. 23rd day of October 24 ಅಂತಲೇ ಇದೆ. ಏನ್ ಚೇಂಜ್ ಇದೆ?
If I may, Milords, page number 40, if my lords peruse.
In page number 40.
Page number 40 is the corresponding page number 27. There's a slight mistake. My lords can see
Page
the
number 27.
of the
ink page
first
number
appellate court
40.
judgment. Milords. The signature may be perused of the learned presiding
So
officer.
judge while mentioning the.
Yes, that is the
Third.
objection raised.
Inadvertently, judge has mentioned the year as 22 instead of 24 while putting the date, and hence the office objection is overruled. Remaining office objection.
Serial number 1 ಅಲ್ಲಿ the
ಎರಡರಲ್ಲಿ ಇದೆ, ಅದ್ ನೀವೆಲ್ಲ ಕಡೆ ಜಡ್ಜ್ ಕೋರ್ಟ್ ಹೆಸರು ಸರಿಯಾಗಿ ಹಾಕಿಲ್ಲ, ಪ್ರೇಯರ್ ಸರಿ ಇಲ್ಲ.
additional district and sessions judge ಅಂತ ಹಾಕಿದ್ದೀನಿ.
ಅದ್ನೇ
ಅದೊಂದು rectify ಮಾಡಿ.
ಆಯ್ತು. ಎಷ್ಟು ದಿವಸ ಬೇಕು?
A week's Milords, a week's
Time
time.
granted to comply with other office objections.
Grateful.
Babu,
9.
Counsel is absent, 2 weeks time granted. Third time,
Third time non-compliance, 10, SPP,
state. 1 week time granted finally to comply the same.
11.
Avinash V. Avinash V. Illa,
Yes.
counsel absent, 2 weeks granted finally.
12.
Yes, Bhimaiah.
Grant 1 week time.
1 week time granted as sought finally.
Much.
Audit matters, 13.
Furnishing of PF and petition copy to issue
Petitioner,
notice to the
today morning
respondent.
furnish the PF.
ಆಯ್ತು, ಯಾವಾಗ ಆಗಿದ್ದ ಆರ್ಡರ್?
ಇವತ್ತು ಆಗಿದೆ ಸರ್.
ಆಗಿರೋದು 13/4/23 ನಲ್ಲಿ.
ಹಾ.
ಅವಾಗಿಂದ
PF ಕೊಟ್ಟಿಲ್ವಾ?
ಟುಡೇ ಮಾರ್ನಿಂಗ್
ಡಿಸ್ಮಿಸ್ಡ್ ತಗೊಳ್ಳಿ.
ಫರ್ನಿಶ್ ಮಾಡಿದೆ ಸರ್ ಇವತ್ತು ಮಾರ್ನಿಂಗ್.
ಇವಾಗ ಏನ್ ಮಾಡಿರಿ? 1.5 ವರ್ಷದಿಂದ ಹಿಂದೆ ಮಾಡಿಲ್ಲ ನೀವು, ಕೊಡಿ. ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಆಗಿದೆಯಾ? ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಮಾಡಿದೀರಾ?
I have no.
ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಮಾಡಿದೀರಾ?
Kindly pass sir.
13/4/23 50% ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ. ಈ ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಮಾಡಿದೀರಾ?
Kindly pass sir. ಕೇಳ್ಕೊಂಡ್ರಿ.
ಅವಾಗಿಂದ PF ಕೊಟ್ಟಿಲ್ಲ, ಕಂಪ್ಲೈನ್ಸ್ ಇಲ್ವಾ? 1.5 ವರ್ಷದಿಂದ PF ಕೊಟ್ಟಿಲ್ಲ. 1.5 2 ವರ್ಷ ಆಯ್ತು.
ಇವತ್ತು ಕೊಟ್ಟಿದ್ರಿ ಸರ್.
ಇವತ್ತು ಕೊಟ್ಟಿರೋ ಉಪಯೋಗ ಬರಲ್ಲ. ನೀವು ಸ್ಟೇ ತಗೋಬಿಟ್ಟು ನೋಟಿಸ್ ಕೊಡದವ್ರೆ ಅದರ್ ಸೈಡ್ಗೆ. ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ನೋಡಿ ಆರ್ಡರ್ನ.
ಪ್ಲೀಸ್.
ಕಂಪ್ಲೈನ್ಸ್ ಇದ್ರೆ ಬಂದಿದೆಯಾ ರೆಕಾರ್ಡ್? ಕೊಡಿ. 13/4/23 ಇದು ಯಾವಾಗ ಬಂದಿರೋದು? 17/7/23 ನೀವು ಕಟ್ಟಿಲ್ಲ ಅಲ್ರಿ? ದುಡ್ಡೇ ಕಟ್ಟಿಲ್ಲ.
Kindly pass sir. I seek.
ರೆಕಾರ್ಡ್ಸ್ ಇದೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಪೇಮೆಂಟ್ ಮಾಡಿದಕ್ಕೆ ಏನು ಇಲ್ಲ. ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೀನಿ ನೋಡಿ. ದುಡ್ಡು ಕಟ್ಟಿದ್ರೆ ಉಳಿಯುತ್ತೆ ಫೈಲ್, ಇದ್ದವ್ರಿಲ್ಲ. ಬರೋದು ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಮಾಡಿಸ್ಕೊಳ್ಳೋದು, PF ಕೊಡಂಗಿಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಂಗಿಲ್ಲ. ಪಾಸ್ ಓವರ್. ಸುಭಾಷ್ ಚಂದ್ರ ಬೋಸ್.
Seek for 1 week time.
ಅರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್. ಯಾವಾಗ ಆಗಿರೋದು ನೋಟಿಸ್?
ಬರೀ ನೋಟಿಸ್ ಆಗಿರೋದು.
ಬರೀ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸಾ? ಯಾವ ಡಿಸೆಂಬರ್? 24 ಡಿಸೆಂಬರ್. ವೈ ಯು ನಾಟ್ ಪೇಡ್ ದಿ PF?
Will pay it.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ.
Much.
PF ಕೊಡಿ ಫಸ್ಟ್.
Much.
SPP awaiting report in respect of notice issued. ಇದ್ಯಾವ್ದ್ರಿ? ಇದ್ರದ್ದಲ್ರಿ? ಕನೆಕ್ಟೆಡ್? ಏನಾಗಿದೆ? ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿರೋದು? ಸರ್ವ್ ಮಾಡಿಸಿದ್ರ ಇಲ್ಲ? ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳ್ದೆ ನಾನು ನಿಮ್ಗೆ, ಎಲ್ಲಾನು ಒಟ್ಟಿಗೆ ತಗೋಬೇಕು ಅಂದ್ರೆ ಸರ್ವ್ ಮಾಡಿಸ್ಬೇಕು ಅಂತ. ಮಾಡಿಸಿದ್ರ ಇಲ್ಲ?
They were received personally.
ಪರ್ಸನಲಿ ರಿಸೀವ್ ಆಗಿರುತ್ತಲ್ಲ. ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇದೆಯಾ? ಆಮೇಲೆ ನೋಡೋಣ ಒಟ್ಟಿಗೆ. ಆಮೇಲೆ ನೀವು ಮನೆ ಓಡೋಗ್ಬಿಟ್ರಿ, ಅಸಿಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ ಕೋರ್ಟ್ಗೆ. ಬೇರೆದ್ರಲ್ಲಿ ಯಾವ್ದಾದ್ರಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿದೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಹೇಳಿಲ್ಲ.
I'll assist the court.
ಪಾಸ್ ಓವರ್.
16.
Furnishing of correct address of respondent
Petitioner in
issue
this case, my
notice.
lord. We have taken steps.
ಯಾವಾಗ?
18th Feb. 18th Feb, my lords.
18 ಫೆಬ್ರವರಿ.
ಹೌದು.
ಇದೆಯಾ ಮೇಡಮ್? PF ಇದೆಯಾ ನೋಡಿ, ಕೊಟ್ಟಿದಾರ? February yesterday, day before
The day
yesterday.
before yesterday.
Totally. The council submits that PF is paid on 18/2, and if PF paid, issue notice as ordered earlier.
70.
Next idu adena pass over.
Same, my lord.
Pass over.
19 also, my lord.
18 petition copy ಹೇಳ್ರಿ ಏನು?
Needful is done, my lords.
ಮಾಡಿದಿರಾ? ಕಂಪ್ಲೈ ಮಾಡಿದಿರಾ?
Yes, my lords.
ಸಸ್ಪೆನ್ಷನ್ ಆರ್ಡರ್ ಕಂಪ್ಲೈ ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
ಕೊಡಿ, ಏನಾದ್ರು ದಾಖಲೆ ಇದೆಯಾ?
ಇದೆ ಮ್ಯಾಮ್.
PF ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ?
ಆಗಿದೆ.
ಸಸ್ಪೆನ್ಷನ್ ಮಾಡಿಸ್ಕೊಂಡು ಇವತ್ತು ಕೊಟ್ಟಿದಿರ್ರಿ, ಬಟ್ ಹಿಂದಿಂದ ಹೇಳ್ರಿ. ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಯಾಕೆ PF ಕೊಡ್ಲಿಲ್ಲ? ಯಾವಾಗ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್? ಆಗಿಲ್ವಾ? ಬರೀ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅಷ್ಟೇ. 6/2/25 ಅಲ್ಲಿ. 6/2/25 ಅಲ್ಲಿ ನಾವೇ ಮಾಡಿದ್ವಿ ಇಶ್ಯೂ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್.
ಆಗಿದೆ.
ಯಾವಾಗ? ಇವತ್ತು ಮಾಡಿದ್ರಾ? ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಟ್ ದಟ್ he has paid the PF today, hence issue emergent notice. Pass over next. 19 pass over, 20 pass over.
2021, my lord.
ಎಲ್ಲ pass over.
Yes, my lord.
Pass over. Srinivasan MOI. Awaiting service of notice in respect of respondent. ಯಾವಾಗ ಇಶ್ಯೂ ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್? 11 days in filing. Postal track item on hold. ಏನ್ on hold? Insufficient address.
ಇನ್ಸಫಿಷಿಯಂಟ್ ಅಡ್ರೆಸ್ ಅಂತ ಬಂದಿದೆ ಅದು.
ತೊಗೊಳ್ಳಿ.
Item on hold.
Sorry, the notice issued against the respondent was not served and the same is returned with an endorsement insufficient address and hence petitioner counsel is directed to pay PF and furnish the correct address within 1 week, within 2 weeks. If 22 only service ಆಗಿಲ್ಲ insufficient address ಅಂತ ವಾಪಸ್ ಬಂದಿದೆ, ascertain ಮಾಡಿ correct address ಕೊಡಿ.
Interim order.
Within 2 weeks.
Yes, interim order.
If paid, issue notice. If not paid within 2 weeks, list the matter, date ಕೊಡಿ madam.
ಅಲ್ಲಿ ಎರಡು ಕೋರ್ಟ್ ನಲ್ಲೂ ಅದೇ ಅಡ್ರೆಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Ascertain ಮಾಡಿ ಈಗ 6-3. Interim order granted earlier is extended till next date of hearing.
I will take my notice appear on the advocate.
And also counsel is permitted to serve the copy of this revision petition on the counsel who appeared on behalf of the respondent before the trial court.
Yeah, sir. Interim order.
Suspension order ಇಲ್ವಾ? Suspension ಆಗ್ಲೇ
Suspension ಆಗಿದೆ.
continuation ಆಗ್ಲಿ ಬರುತ್ತೆ.
Till next date.
Petition to the hence notice on so and so. Heard on A2 of 25 for suspension of sentence, the sentence of the petitioner is suspended till disposal of the revision petition. Since the sentence is questioned with regard to the imprisonment is
ಅಷ್ಟೇ,
concerned.
only
ಅಷ್ಟೇ.
imprisonment.
Extension ಏನ್ ಬರೋದಿಲ್ಲ ಮತ್ತೆ.
Please.
Hearing on IA 20.
M. Subramani. Bringing LRs of deceased respondent filed by the petitioner counsel.
IA 1 regarding LRs.
I issue notice on IA number 1 of 24. Against the LRs of respondent.
24. Prashant PM.
24 Prashant PN. ಏನಕ್ಕಿದೆ ನೋಡಿ?
IA for stay sir.
A for stay na.
ಸೊ ಅದು ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಹಾಕೊಂಡಿದ್ವಿ, ವಾಸ್ ಕನ್ವಿಕ್ಷನ್ ವಾರಂಟ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ. ಅವಾಗ ಹಾಕುವಾಗ ಒಟ್ಟಿಗೆ ಹಾಕಿದ್ವಿ. ಸೊ ಕನ್ವಿಕ್ಷನ್ ವಾರಂಟ್
ಈಗೇನ್ ಆಗ್ಬೇಕಿದು?
ಅಡ್ಮಿಷನ್ ಆಗ್ಬೇಕು, TCR ಬರ್ಬೇಕು, LCR ಬರ್ಬೇಕು ಸ್ವಾಮಿ, TCR ಬರ್ಬೇಕು.
LCR ಆರ್ಡರ್ ಆಗಿದೆ ನೋಡಿ?
ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಸರ್.
ಈಗೇನ್ ಸ್ಟೇ ಆಯ್ತಾ? ಏನಾಯ್ತು ಆರ್ಡರ್?
ಅದು ಕನ್ವಿಕ್ಷನ್ ಆರ್ಡರ್ ಆಯ್ತು. It was released on bail on payment of rupees 1 lakh, deposit of 1,50,000. ಈಗ ಅದು TCR
release
ಆಗಿದೆ. ಪ್ಲೀಸ್ ಮನೋಡ್, ರಿಲೀಸ್ ಆಯ್ತು.
ಆಯ್ತು. Release is directed to get the records of TCR and SCR.
Grateful bonds.
And list the matter as soon as the records are received.
Grateful.
A 1 of 25 for release of amount filed by the
For the
respondent counsel.
petitioner.
Ah.
I appear for the respondent. My lords, I have oral instructions. I'll address my oral arguments, my lords. Just
really?
2 short points. My lords, first is that no prejudice has been pleaded in the affidavit supporting the application, my lords. In fact, I will be put to grave prejudice because they have deposited, 1, a security check, 2, allegedly received when the dispute had already commenced. Second, my lords, is that there is no pleading in the affidavit which says that they are undertaking and willing to comply with the requirements of
If no
148(3).
pleading, I will pass an order. That's all. If no pleading also, I will pass an order.
No, I understand that, my lord. There's no pleading that they'll comply with the directions of
Heard on
148(3).
IA number 1 of 25 for release of the amount which is in deposit filed by the counsel for respondent and counsel for the petitioner opposes orally before this court and having considered the reasons assigned in the application as well as submission of the counsel for the petitioner, order to release the amount subject to redepositing of the amount within 4 weeks from the date of if from the date of if the petitioner succeeds in this revision petition.
My lords, the Deeply other, appreciated. the proviso also say with the interest at bank rate published by RBI. It says, provided that the appellant is acquitted, the court shall direct the complainant to repay the appellant the amount released with interest at bank rate. That may also kindly be recorded.
ನೀವು ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ತೀರಾ ಈಗ?
My lords, I have already deposited. My
ಕೋರ್ಟ್
lords.
ಆರ್ಡರ್ ಮೇಲೆ ಈಗ ನೀವು ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡ್ತೀರಾ ಅಂತ ಕೇಳಿದೆ. ಈಗ ರಿವಿಷನ್ ಬಂದಿದೆ.
My lords, fine has already been ordered for me to pay, my lords. A fine has already been ordered for me to pay, which is the 50% that I've already.
50%.
Please, my lords.
I will direct him to pay the along with interest. If you
Interest.
fails to succeed in this revision, you are also liable to pay the interest on the amount. Shall I
My lord,
pass
but-
such an order?
That's not the direction. issued by
ಅದ್ ನಿಮ್ಗೂ ಅಪ್ಲೈ ಆಗುತ್ತ್ರಿ. ಅವ್ರೊಬ್ರಿಗೆ ಮಾತ್ರ ಅಲ್ಲ, ನಿಮ್ಗೂ ಅಪ್ಲೈ ಆಗುತ್ತದ ಅಲ್ವಾ?
Please,
ಮತ್ತೆ
that is the requirement of 148. I was just.
there cannot be 2 yardstick.
Please,
ಹೌದಿಲ್ಲ? I will pass such an order.
please, ma'am.
If you are unsuccessful in the revision, then you have to pay the
With
interest on.
full amount. My lords, but the provision only talks about.
ಅತಿ ಬುದ್ಧಿವಂತಿಕೆ ತೋರಿಸಬಾರ್ದು. ಗೊತ್ತಾಯ್ತಲ್ಲ? ಎಲ್ಲರಿಗೂ ಒಂದೇ.
Please.
ನಾ ಮಾಡಿದೀನಿ ಆರ್ಡರ್, ನಿಮ್ ಇಂಟ್ರೆಸ್ಟ್ ಸೇಫ್ ಗಾರ್ಡ್ ಮಾಡಕ್ಕೆ ದುಡ್ಡು ವಾಪಸ್ ಕೊಡ್ಬೇಕು ವಿತಿನ್ 4 weeks ಅಲ್ಲಿ ಅಂತ ಹೇಳಿದೀನಿ ಅಲ್ವಾ?
Deeply obliged.
26.
ಇದು ಪಾಸ್ ಅವರ
In this case, my lord, service is complete, my lord, only IA has to be considered.
ಆಯ್ತು, ಅದ್ರ ಜೊತೆ ಕನ್ಸಿಡರ್
Yes, my
ಮಾಡಿ.
lord, please.
27.
And also 28, my lord, 3
26.
matters.
26, 27,
And
28.
28.
All the three.
All the 3 pass over.
ಆಯ್ತು, ಪಾಸ್ ಅವರ್.
29.
ಅದ್ರ ಮೂರು ಒಟ್ಟಿಗೆ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಅದ್ರ ಜೊತೆಲೆ.
29.
29 GR Mohan. Further orders regarding IA 1
only request is that your lordship, as submitted last occasion, the 3 lakh amount which is in deposit before the trial court, with observation, the petition can be disposed of. Our objection ಹಾಕಿದ್ದಾರೆ, ಅದು ಎಲ್ಲೂ ಲೆಕ್ಕಕ್ಕೆ ಬಂದಿಲ್ಲ. Tomorrow again I cannot be, ನಾನು 3 ಲಕ್ಷ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ರೆ, that is only prayer your lordship.
petitioner. ಏನ್
prayer.
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು?
ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ ಅವರು.
ಏನಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್?
ಅವರು ಇಲ್ಲ ಚೆಕ್ ಕೊಟ್ಟಿರೋದು ಡಿಸಾನರ್ ಆಗಿದೆ ಅಂತ. ಅದು ರಿವಿಷನ್ ಪೆಟಿಷನ್ ಇಸ್ ಪೆಂಡಿಂಗ್ ಬಿಫೋರ್ ದಿಸ್ ಅಪೀಲ್ ಇಸ್ ಪೆಂಡಿಂಗ್ ಬಿಫೋರ್ ದಿಸ್ ಆರ್ಡರ್. ಮಗ 6 ಲಕ್ಷ ಚೆಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು 12 lakhಗೆ ಆರ್ಡರ್ ಆಗಿದೆ.
ಯಾವ ಕನ್ಸಿಡರೇಷನ್?
Only now limited price 3 lakh amount which is in trial court as directed by this honorable court. The order copy last time I produced it, your High Court order, which is at
ಯಾರು ಅದರ್ ಸೈಡ್ ಇದಾರೇನ್ರಿ? ಯಾರು?
page number 9. Page number 9 ಅಲ್ಲೇ ಇದೆ.
ಸಂತ ಕುಮಾರಿ.
Ink page 9 you know.
Ink page?
Ink page 9, the earlier order. In that, not in that, separately.
Page 9 verifying.
separate ಕೊಟ್ಟಿದ್ದು.
ಹಾಕಿದ್ದೀರಾ? ಆರ್ಡರ್ ಕಾಪಿ.
Last time ಕೊಟ್ಟಿದ್ದೆ.
ಏನ್ ಇಲ್ವಲ್ರಿ? ನೀವೇನ್ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಸರಿ ಇದೆ.
ಏನು?
As director of this court, I have deposited the amount.
Petition is allowed in part. The order
Page
dated
number
25 past by is extended until disposal of the 34 of the act.
Page number operative portion. The amount in deposit before the district court, if not already deposited before National Bank, shall be deposited. So earlier in that, your lordship may kindly see paragraph 2, para 2, your lordship. On 29th, when this writ petition was listed for order, the learned counsel, para 2, your lordship, submitted the petitioner who deposits also before the AS number so. Hence, this court granted interim stay of the operation. The pursuant to such order, the petitioner has deposited such sum of rupees before this district court. Other trial court ali avaru, while dismissing my appeal, they are not observed amount ಲೆಕ್ಕಕ್ಕೆ ತಗೊಂಡ್ರೆ it can be ಮಾಡಬಹುದು. To that extent, it can be reduced ಅಷ್ಟೇನೆ. The remaining thing our proceed ಆಗಲಿ, there is no problem about it.
ಆಯ್ತು, ಬರ್ಲಿ ನೋಡೋಣ.
ಬಂದಿಲ್ಲ last time our
ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೀನಿ. ಬರ್ಲಿ ಅದರ್ ಸೈಡ್.
kindly pass over, I'll inform him, please. Please.
Matter 30. Excess 11.
7 lakh ಇಲ್ವಾ? ಇಬ್ರು ಇಲ್ಲ ಪಾಸ್ ಓವರ್. ಬಂದಿಲ್ಲ ಪಾಸ್ ಓವರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 31. ಮುರಳೀಧರ್ HM ಶ್ರೀನಿವಾಸ್. ಹೇಳ್ರಿ ಏನ ಕೇಳ್ತಿಲ್ಲ?
My lords, may be taken up next week, my lord. Senior ಹುಷಾರಿಲ್ಲ, so next week
ಯಾರಿಗೆ ಹುಷಾರಿಲ್ಲ?
Senior ಗೆ so.
ನೀವು ಓದಿದ್ರಿಲ್ಲ?
Just
Senior
glance
ಹುಷಾರಿಲ್ಲ,
ಮಾಡಿದ್ದೀನಿ.
ನೀವು ಓದಿದ್ರಿಲ್ಲ?
Glance ಮಾಡಿದ್ದೀನಿ so.
ಗ್ಲಾನ್ಸ್ ಮಾಡಿದಿರಿ. ಆಯ್ತು, ಏನ್ ಹೇಳಿ ಅದೇ ಗ್ಲಾನ್ಸ್. I will hear your glance. ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನ್ ಹೇಳಿ?
My lords, this is regarding
1,50,000 ಮಾಡಿದ್ದಾರೆ.
ಸ್ವಾಮಿ, ಅದು ನಾವು ಸೆಕ್ಯೂರಿಟಿ
ನಾನ್
ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ.
ಫೈಲಿಂಗ್ ಆಫ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಫ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ 30/11/2020 ಪಾಸ್ಟ್ ಇನ್ CC ಬೈ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್. ನಿಮ್ ಸೀನಿಯರ್ ಬೇಕಾ ಇದಕ್ಕೆ? ಇದನ್ನ ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೋದಲ್ಲ? ವಿಡ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ 8/2/21, 8/2/21 ಒಂದು ಆರ್ಡರ್ ಇದೆ. ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ 30/11 ಅಂತ ಇದೆಯಲ್ಲ ಮೇಡಮ್, ಇಲ್ಲೇನು 30/11 ಕಾಪಿ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ? CC ಇದೆ, ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಇದೆ.
2 ಸೆಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
CC ನಲ್ಲಿ ಏನಾಗಿದೆ 30/11? CC ಡಿಸ್ಪೋಸಲ್ ಆದ್ಮೇಲೆ ಏನೋ ಒಂದು ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಹಾಕೊಂಡಿದ್ವಿ.
ಅದರ್ ಸೈಡ್ ಶ್ರೀನಿವಾಸ್ ಇಲ್ವಾ? ಇಲ್ಲೊಂದು ಡೈರೆಕ್ಷನ್ ಇದೆ ನೋಡ್ರಿ. ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಫ್ ಆರ್ಡರ್ ಡೇಟೆಡ್ 30/11/2020
ಫೈಲ್ ಮಾಡಿದ್ವಿ
CC.
we have filed.
ಏನ್ ಫೈಲ್ಡ್?
ಇಲ್ಲಿ
ಕೊಡಿ, ಯಾವಾಗ?
30/11/2020 ಅಲ್ಲ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 12 ಅಲ್ಲಿ.
ಅದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ರೀ, ಇದು ಅಪೀಲ್ ಅಲ್ಲಿ, ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಇದು. ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. CC ನಲ್ಲಿ ಏನೋ ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ. ಅದನ್ನ ಹಾಕಿಲ್ವಲ್ಲ ನೀವು? ತಗೊಳ್ಳಿ. ಆಯ್ತು. ಹಾ ಇದೆಯಾ? ಕೊಡಿ ನೋಡಿ ಏನಿದೆ ನೋಡಿ. 30/11 ಟ್ರಯಲ್ ಕೋರ್ಟ್ CC ರೆಕಾರ್ಡ್ ಕೊಡಿ. ಏನಿದೆ ಅಲ್ಲಿ? ನಮ್ಮ ಕೋರ್ಟ್ ನಲ್ಲಿ ಏನೋ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ನೋಡಿ 8/2 ನಲ್ಲಿ. ಇದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಇಷ್ಟು. ಏನ್ ಆರ್ಡರ್ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ? CC ನಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಆಗಿದೆ? ಏನೋ ಇದೆಯಾ ಕೊಡಿ. 8/2 ನಲ್ಲಿ. Keeping in view the reasons stated in the application, I number 1 allowed and production of certified copy of the order in CC number dated 29/1/2019 is dispensed with for the present. Produce the certified copy of the order in 29/1 after obtaining the same from the trial court in due course. ಯಾವ್ದು ಇಲ್ವಲ್ರಿ ಇಲ್ಲಿ? 30/11/21 ಇನ್ನೊಂದು CC ಇದೆಯಾ?
203.
ಹಾ 350. ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಗೊತ್ತಾಗುತ್ತೆ, ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆಯಾ ಅಂತ. ಯಾವ್ದು ಇಲ್ವಲ್ರಿ 30/11 ಅಂತ. 8/2/21 ಅಲ್ಲಿ 30/11 ಆರ್ಡರ್ ಹಾಕಿ ಅಂತ ಎಲ್ಲೂ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ. 11/2021 ಬರೀತಾರೆ. ಈ ಆರ್ಡರ್ ಯಾವ್ದು ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ? Criminal appeal 475 and the said appeal was dismissed by order dated 30/11/2020 confirming the judgment ಅಂತ ಆಯ್ತು. ರಾಂಗ್ ಹಾಕಿದಾರ್ರಿ, ಅದೇನಿದೆ ಆ ತರದೇನು ಆರ್ಡರ್ ಇಲ್ವಲ್ಲ 8/2/21. ತೋರ್ಸ್. Having perused the order dated 8/2/21, there is no any direction to produce the certified copy of the order dated 30/11/2020. Passed in CC number 2350 of 2011. And counsel for the petitioner seeks time and hence list these matters and the other on date ಕೊಡಿ. 5/3. Counsel for respondent is absent ಅಂತ ಹಾಕಿ.
ಮಚ್ಚೂರಿ.
32.
32.
Lokesh A. Shankrappa S.
Your Lordships, we have issued no objection for the respondent, Your Lordship.
You are appearing for respondent.
How's Your Lordship? No objection ಕೊಟ್ಟಿದೆ, Your Lordship.
No objection ಕೊಟ್ರೆ ದಾಖಲೆ ಕೊಡಿ ಮೇಡಮ್, ಬ್ರೀಫ್ ಕೊಟ್ಟಿರ್ತಿರಲ್ಲ ಅವ್ರಿಗೆ. ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಕೊಟ್ರೆ ನೀವು ರಿಟೈರ್ಮೆಂಟ್ ಮೆಮೊ ಹಾಕ್ಬೇಕು, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಹಾಕ್ಬೇಕು. ಯಾವಾಗ ಕೊಟ್ಟಿರೋದು ನೀವು?
Your Lordship,
ಯಾವಾಗ ಕೊಟ್ಟಿರೋದು?
first week of February ಕೊಟ್ರಿ, Your Lordship.
ಕೊಡಿ, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಕೊಡಿ.
Your Lordship, pass
ಬ್ರೀಫ್
over.
ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿರೋದು. ಪಾಸ್ ಓವರ್ ಆಯ್ತು.
33.
Revision petitioner.
Ah.
Lord, check amount is 2,90,000.
3,50,000 ಮಾಡಿದ್ದಾರೆ.
3,50,000 ಮಾಡಿದ್ದಾರೆ. Concurrent judgment. Lord, the defense that was as before.
Records ಬಂದಿಲ್ವಾ? Call for records. Records ಬರ್ಲಿ.
But. Great.
Call for records from both courts.
Please.
34.
List this matter as soon as records are received.
34.
Kumara KG. S Nagaraj, ಇದ್ರಲ್ಲೂ records ಬಂದಿಲ್ಲ ಮೇಡಮ್.
ಬಂದಿಲ್ಲ.
Call for records of both the courts. List this matter as soon as records are received. 35 settlement ಏನಾಯ್ತ್ರಿ? Dilip Kumar IS Venkatesh BC. Yes madam.
Time for R2. I am only a formal party, your lords. The company is under liquidation. This
Last
is-
time they made submission that they are going to
Yes, your lords.
report the
the-
settlement, pass over. Pass over.
ಏನ್ ರಾಧಾಕೃಷ್ಣ?
Pass over.
37. It's Ramachandra.
Hmm. Hmm. ಹ್ಮ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಮೇಡಮ್ ಇದರಲ್ಲಿ ಇದೆಯಲ್ಲ ಹೇಳಿ 4,50,000 3 months with 2,000
For MT, your lordship, turn to the cross examination. So the admitted. It was cross examination was commenced on 5/12/2020.
ಏನೋ ಚೀಟಿ
Yes.
ಅಂತ ಏನೋ ಡಿಫೆನ್ಸ್ ತಗೊಂಡಿದ್ದೀರಿ ನೀವು
2000, he says according to the, he says that 2015.
ಆಯ್ತು ನಿಮ್ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
Yes, it's true, but however,
ಅಡ್ಮಿಷನ್ ವಾಟ್ ಅಡ್ಮಿಷನ್ಸ್ ಯು ಹಾವ್ ಗಿವನ್
even he says that he say income taxes.
ಆರೋಪಿಯ ಜಮಾ ಮಾಡಿರುವಂತ ಬ್ಯಾಂಕ್ ಖಾತೆಯ ನಂಬರ್ ಸೋಣ ಆಗಿದ್ದು ಅದು ನನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆ ಆಗಿರ್ತದೆ ಸರಿಯಲ್ಲ. ಈಗ ಹೇಳಲಾದ 10,000 ರೂಪಾಯಿಗಳನ್ನು ನನ್ನ ನಿರ್ದೇಶನಂತೆ ಆರೋಪಿಯು 1 ತಿಂಗಳ ಚೀಟಿ ಹಣವನ್ನು ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಜಮಾ ಮಾಡಿರ್ತಾರೆ ಎಂದು ಸರಿಯಲ್ಲ. ಸದರಿ ಬ್ಯಾಂಕ್ ಖಾತೆಯ ಕುರಿತಂತೆ ಪರಿಶೀಲನೆ ಮಾಡಲು ನನ್ನ ತಕರಾರು ಇರುವುದಿಲ್ಲ.
Cross examination ಕೈಲಿ taken.
ಅದು ಚಿಟ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅಂತ
Yes.
ಡಿಫೆನ್ಸ್
2015. He says that he paid the amount, my lord. May I read out the class? For
ಯಾರೋ DW2 ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರಿ ಅವನು ಆಲ್ಸೋ
ಅಲ್ಲ,
ಏನು ಇಲ್ಲ.
but over, no, even he says that income taxes, he says income taxes, that is his contention, your lordship.
ಚಿಟ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್
Chit
ಸಂಬಂಧಪಟ್ಟ
transaction, that is the.
Is your defense.
Yes, ma'am. But however, he has not explained even the 1 lakh check amount paid to him through his bank. That earlier was, it denied those suggestion, but however, the bank, the statement was produced by the accused. There it establishes that 1 lakh has been paid to him. In addition to that, he has not disclosed. 2015, he says that he advanced the check, but check was issued during the, after 2017. How he could able to accept that 2017 check when he has paid 4 lakhs? And he says that he has nobody was there in his house. On the contrary, 4 lakhs was available in his house. That is the contention, madam. May I read out the cross section? So that.
ನಿಮ್ ಕ್ರಾಸ್ ನಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ ಬಟ್ ಇದು ಇಲ್ಲಿ ಬೇಕಾದ ಏನ್ ಬೇಕಾದ
PW1 ಏನಾರು ಎಲಿಸಿಟ್ ಮಾಡಿಸಿದ್ರೆ ಹೇಳಿ.
ಹೇಳ್ತೀನಿ. ಮೇ ರೀಡ್ ಔಟ್ ಮೇಡಮ್. ಫಿರ್ಯಾದಿ ರಿವ್ಯೂ ನನಗೆ ಸಾರಿ DW ಬಂದಿದೆ. 4/2/22 ಗಮನಿಸಿಲ್ಲ. ನಾನು ಕಾರ್ಪೆಂಟರ್ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೇನೆ. ನಾನು 7ನೇ ತರಗತಿವರೆಗೆ
ಆ ಪ್ಯಾರ ಓದಾಯ್ತು ನಾನು.
ಆಯ್ತು.
ನೆಕ್ಸ್ಟ್ 2ನೇ ಪ್ಯಾರಕ್ಕೆ ಹೋಗಿ.
ಎಸ್. ಆರೋಪಿ ಜಮೀನಲ್ಲಿ ವ್ಯವಸಾಯದ ಕೆಲಸವನ್ನು ಮಾಡುತ್ತಿದ್ದಾರೆ. ಆರೋಪಿ ಜಲ್ಲಿ ಮತ್ತು ಮರಳು ಸಾಗಾಟ ಲಾರಿಯನ್ನು ಕೊಂಡಿದ್ದು ಅದರಿಂದ ಅವರಿಗೆ ಆದಾಯ ಬರುತ್ತಿದೆ ಎಂದರೆ ಸರಿ. ವ್ಯವಸಾಯದಿಂದಲೂ ಸಹ ಅವರಿಗೆ ಆದಾಯ ಬರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಆರೋಪಿ ಮನೆಯಲ್ಲಿ ಹಣಕಾಸಿನ ಸ್ಥಿತಿ ಉತ್ತಮವಾಗಿತ್ತು. ನಾನು ಕಾರ್ಪೆಂಟರ್ ಆಗಿ ಸುಮಾರು 5 ವರ್ಷದಿಂದ ದಿನಗೂಲಿ ಕೆಲಸ ಮಾಡುತ್ತೇನೆ. ಆ ನಂತರ ಗುತ್ತಿಗೆ ಮೇಲೆ ಕಾರ್ಪೆಂಟರ್ ಕೆಲಸವನ್ನು ಮಾಡುತ್ತಿದ್ದೇನೆ. ನನ್ನ ಕಾರ್ಪೆಂಟರ್ ಕೆಲಸದಿಂದ ಎಲ್ಲ ಖರ್ಚು ಕಳೆದ ವಾರಕ್ಕೆ 5ರಿಂದ 6,000 ರೂಪಾಯಿ ಆದಾಯ ಬರುತ್ತದೆ. ನಾವು ವಾಸವಾಗಿರುವಂತಹ ಮನೆ 5,000 ಬಾಡಿಗೆ ಕೊಡುತ್ತೇವೆ. ನನಗೆ ಉಳಿಯುವಂತ 5,000 ರೂಪಾಯಿಗಳಲ್ಲಿ ಮನೆ ಖರ್ಚು ಹಾಗೂ ಮಕ್ಕಳ ವಿದ್ಯಾಭ್ಯಾಸ ಹಾಗೂ ಮನೆ ಬಾಡಿಗೆ ಕಟ್ಟಬೇಕಾಗುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿ ಸ್ವತಃ ಈ ರೀತಿ ಎಲ್ಲ ಖರ್ಚುಗಳನ್ನು ಕಳೆದು ತನಗೆ 5-6 ಸಾವಿರ ರೂಪಾಯಿ ಉಳಿತದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆ ಒಂದು ಬ್ಯಾಂಕ್ನಲ್ಲಿ ಇರುತ್ತದೆ. ನಾನು ಆದಾಯ ತೆರಿಗೆ ಪಾವತಿದಾರನಾಗಿರ್ತೇನೆ. ಎಷ್ಟು ವರ್ಷಗಳಿಂದ ಆದಾಯ ತೆರಿಗೆ ಪಾವತಿ ವಿವರವನ್ನು ನಿಲ್ಲಿಸುತ್ತಿದ್ದೀರಾ ಎಂದರೆ 5-6 ವರ್ಷಗಳಿಂದ ಸಲ್ಲಿಸುತ್ತಿದ್ದೇನೆ. ನಾವು ಸಲ್ಲಿಸುವಂತಹ ಆದಾಯ ತೆರಿಗೆ ಪಾವತಿಯಲ್ಲಿ ವಿರುದ್ಧ ಬೇರೆಯವರಿಗೆ ಸಾಲ ಕೊಟ್ಟ ಕುರಿತಂತೆ ಯಾವುದೇ ಮಾಹಿತಿ ತಿಳಿಸಿರುವುದಿಲ್ಲ. ಆರೋಪಿಗೆ ನಾನು 4 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಸಾಲವಾಗಿ ಕೊಟ್ಟಿರುವ ಕುರಿತಂತೆ ನಮ್ಮ ಆದಾಯ ತೆರಿಗೆ ಪಾವತಿ ವಿವರದಲ್ಲಿ ತಿಳಿಸಿರುವುದಿಲ್ಲ. ನಾನು ಆರೋಪಿಗೆ ಹಣವನ್ನು ಕೊಡುವಾಗ ಬೇರೆ ಯಾರೂ ಇದ್ದಿರಲಿಲ್ಲ. ಆರೋಪಿ ಮತ್ತು ನಾನು ಮಾತ್ರ ಇದ್ದೆವು. ಆ ಹಣವನ್ನು ನಾನು ಬೆಂಗಳೂರಿನ ನಮ್ಮ ಮನೆಯ ಹತ್ತಿರ ಕೊಟ್ಟಿರುತ್ತೇನೆ. ನಾನು ಹಣವನ್ನು ಕೊಟ್ಟಂತ ನಿರ್ದಿಷ್ಟ ದಿನಾಂಕ ನೆನಪಿರಲಿಲ್ಲ. ಆದರೆ 2017 ಆಗಸ್ಟ್ ತಿಂಗಳಲ್ಲಿ ಆರೋಪಿ ತಾನು ಪಡೆದುಕೊಂಡಿದ್ದ ಹಣವನ್ನು 6 ತಿಂಗಳಲ್ಲಿ ವಾಪಸ್ ಕೊಡ್ತೇನೆ ಎಂದು ಹೇಳಿದ್ದರು ಮತ್ತು ಹಣದ ಮೇಲೆ ಯಾವುದೇ ಬಡ್ಡಿ ಕೊಡಲು ಮಾತುಕತೆ ಆಗಿಲ್ಲ. ಆರೋಪಿ ತಾನು ಹೇಳಿದಂತೆ 6-7 ತಿಂಗಳಲ್ಲಿ ಹಣವನ್ನು ವಾಪಸ್ ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ನಂತರ ಸುಮಾರು 1 ವರ್ಷದ ಮೇಲೆ ಕೇಳುತ್ತೇನೆ. ಆರೋಪಿ ಕೊಟ್ಟಂತ ಹಣವನ್ನು ಹೇಗೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಎಂದರೆ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಇಟ್ಟುಕೊಂಡಿದ್ದಂಥ ಹಣವನ್ನು ಕೊಟ್ಟಿರ್ತೇನೆ. 2017ರಲ್ಲಿ ನನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆ ಇತ್ತು. 2017ರಲ್ಲಿ ನನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆಯಲ್ಲಿ ಯಾವುದೇ ಹಣ ಇದ್ದಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಆರೋಪಿಗೆ ಕೊಟ್ಟಿರುತ್ತೇನೆ ಎನ್ನಲಾದ 4 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಮನೆಯಲ್ಲಿ ಇಟ್ಟುಕೊಳ್ಳುವ ಬದಲಿಗೆ ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಹಾಕಲು ತೊಂದರೆ ಇದ್ದಿರಲಿಲ್ಲ. ಆರೋಪಿ ನನಗಿಂತ ಸ್ವಲ್ಪ ವಯಸ್ಸಿನ ದೊಡ್ಡವರು ಇರಬಹುದು. ನಾನು ಚೀಟಿ ವ್ಯವಹಾರ ಮಾಡಿಸುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಮ್ಮ ಕಾರ್ಪೆಂಟರ್ ಅಂಗಡಿಯಲ್ಲಿ ಒಟ್ಟು 20 ಜನ ಸೇರಿಕೊಂಡು ತಲಾ 10 ಸಾವಿರಗಳಂತೆ 2 ಲಕ್ಷ ರೂಪಾಯಿಗಳಿಗೆ ಚೀಟಿ ವ್ಯವಹಾರ ನಡೆಸುತ್ತಿದ್ದೆವು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ನಾನು ನಡೆಸುತ್ತಿದ್ದ ಚೀಟಿ ವ್ಯವಹಾರದಲ್ಲಿ 10 ಸಾವಿರ ರೂಪಾಯಿ ಒಂದು ಚೀಟಿಯನ್ನು 2 ಲಕ್ಷ ರೂಪಾಯಿಗಳೇ ಹಾಕಿದ್ದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿ ಸ್ವತಃ ನಾವು ಚೀಟಿ ವ್ಯವಹಾರ ನಡೆಸುತ್ತಿರಲಿಲ್ಲ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. ಚೀಟಿದಾರರು ಚೀಟಿ ಹಣವನ್ನು ಕೊಡುವುದಕ್ಕೂ ಕೂಗಿದಾಗ ಚೀಟಿ ಹಣದ ಭದ್ರತೆಗಾಗಿ ಅವರಿಂದ ಸಹಿ ಮಾಡಿದ 2 ಖಾಲಿ ಚೆಕ್ಗಳನ್ನು ಪಡೆದುಕೊಳ್ಳುತ್ತಿದ್ದೇವೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಚೀಟಿದಾರರಿಂದ ಪಡೆದುಕೊಂಡಿದ್ದ ಆ ಖಾಲಿ ಚೆಕ್ಗಳನ್ನು 20 ತಿಂಗಳು ಚೀಟಿ ವ್ಯವಹಾರ ಮುಗಿದ ನಂತರ ಅವುಗಳನ್ನು ವಾಪಸ್ಸು ಚೀಟಿದಾರರಿಗೆ ಕೊಡುವ ಬುದ್ಧಿ ಇಟ್ಟುಕೊಂಡಿದ್ದೇನು ಎಂದರೆ ನಾನು ಚೀಟಿ ವ್ಯವಹಾರ ಮಾಡಿಸುತ್ತಿರಲಿಲ್ಲ. ಆರೋಪಿ ನನ್ನ ಹತ್ರ ಚೀಟಿ ಕೂಗಿದಾಗ ಚೀಟಿ ಹಣವನ್ನು ಪಡೆದುಕೊಳ್ಳುವ ಸಮಯದಲ್ಲಿ ಅವರಿಂದ ನಾನು ಈ ಪ್ರಮಾಣದ ಹಾಜರುಪಡಿಸಲಾದಂಥ ಚೆಕ್ಕನ್ನು ನಮ್ಮ ಮತ್ತೊಂದು ಚೆಕ್ಕನ್ನು ಭದ್ರತೆಗೆ ಪಡೆದುಕೊಂಡಿದ್ದೇನು ಸರಿಯಿಲ್ಲ. 2017ರಲ್ಲಿ ಚೀಟಿಯ ಅವಧಿ ಮುಗಿದ ನಂತರ ಆರೋಪಿಯಿಂದ ಪಡೆದುಕೊಂಡಿದ್ದ 2 ಚೆಕ್ಗಳನ್ನು ನಾನು ವಾಪಸ್ಸು ಕೊಟ್ಟಿರುವುದೆಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ತನ್ನ ಚೆಕ್ಗಳನ್ನು ವಾಪಸ್ಸು ಕೊಡಿ ಎಂದು ಕೇಳಿದಾಗ ಆ ಚೆಕ್ಕುಗಳನ್ನು ಮನೆಯಲ್ಲಿ ಎಲ್ಲೋ ಇಟ್ಟಿದ್ದೇನೆ, ಸಿಕ್ಕ ನಂತರ ಕೊಡುತ್ತೇನೆ ಎಂದು ಹೇಳಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಹೇಳಲಾದಂಥ ಚೆಕ್ಕನ್ನು ಬ್ಯಾಂಕ್ಗೆ ಹಾಜರುಪಡಿಸುವುದಕ್ಕಿಂತ ಪೂರ್ವದಲ್ಲಿ ಆರೋಪಿ 1 ಲಕ್ಷಗಳಿಗೆ ಕೊಟ್ಟಂತ ಮತ್ತೊಂದು ಚೆಕ್ಕನ್ನು ನಾನು ಬ್ಯಾಂಕಿಗೆ ಹಾಜರುಪಡಿಸಿದ್ದೇನು. ಆ ಚೆಕ್ಕನ್ನು ಸಹ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಹೇಳಲಾದಂಥ ಹಣಕಾಸಿನ ವ್ಯವಹಾರಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಕೊಟ್ಟಿದ್ದು ಆಗಿರ್ತದೆ. ಆದರೆ ಅದು ಅಮಾನ್ಯಗೊಂಡಿರ್ತದೆ. ಆ ಚೆಕ್ ಅಮಾನ್ಯಗೊಂಡ ನಂತರ ನಾನು ವಕೀಲರ ಮೂಲಕ ನೋಟಿಸ್ ಕೊಡಿಸಿರುವುದಿಲ್ಲ. ಆದರೆ ಅದರ ಬದಲಿಗೆ ಈ ಪ್ರಕರಣಕ್ಕೆ ಹೇಳಲಾದ ಚೆಕ್ ಅನ್ನು ಕೊಟ್ಟುತ್ತೇನೆ. ಆರೋಪಿ ಈ ಹಿಂದೆ ನನಗೆ 1 ಲಕ್ಷ ರೂಪಾಯಿಗೆ ಚೆಕ್ ಅನ್ನು ಕೊಟ್ಟಿರುವ ಕುರಿತಂತೆ ಮತ್ತು ಅದು ಅಮಾನ್ಯಗೊಂಡಿರುವ ಕುರಿತಂತೆ ಹಾಗೂ ನಂತರ ಅದರ ಬದಲಾಗಿ 4 ಲಕ್ಷ ರೂಪಾಯಿಗಳ ಚೆಕ್ ಅನ್ನು ಕೊಟ್ಟಿರ್ತಾರೆ ಎಂದು ನಮ್ಮ ನೋಟಿಸ್ನಲ್ಲಾಗಲಿ ಅಥವಾ ನನ್ನ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಹೇಳಿಕೊಂಡಿರುವುದಿಲ್ಲ. ಈ ಹಿಂದೆ 1 ಲಕ್ಷ ರೂಪಾಯಿ ಹಣಕ್ಕೆ ಚೆಕ್ ಅನ್ನು ಕೊಟ್ಟಿರುವ ಕುರಿತಂತೆ ಮತ್ತು ಅದು ಅಮಾನ್ಯಗೊಂಡಿರುವ ಕುರಿತಂತೆ ನೋಟಿಸಲ್ಲಾಗಲಿ ಅಥವಾ ದೂರಿನಲ್ಲಾಗಲಿ ಅಥವಾ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಹೇಳಿಕೊಳ್ಳಲು ಯಾವುದೇ ತೊಂದರೆ ಇದ್ದಿರಲಿಲ್ಲ ಎಂದರೆ ನನಗೆ ಆ ಕುರಿತು ಮರೆತು ಹೋಗಿತ್ತು. ಅಮಾನ್ಯಗೊಂಡಂತ 1 ಲಕ್ಷ ರೂಪಾಯಿ ಚೆಕ್ ನನ್ನ ಹತ್ತಿರ ಇರ್ತದೆ. ಅಮಾನ್ಯಗೊಂಡಂತ ಚೆಕ್ ಅನ್ನು ಆರೋಪಿ ವಾಪಸ್ಸು ಕೊಡಬಹುದಾಗಿತ್ತು ಎಂದ್ರೆ ಅವರು ಕೇಳಿರುವುದಿಲ್ಲ ಎಂದು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. 1 ಲಕ್ಷ ರೂಪಾಯಿ ಚೆಕ್ ಅನ್ನು ಬ್ಯಾಂಕ್ಗೆ ಹಾಜರುಪಡಿಸಿದಾಗ ನಮ್ಮ ಊರಿನಲ್ಲಿ ಚೀಟಿ ವ್ಯವಹಾರ ಕುರಿತು ಪಂಚಾಯಿತಿ ಮಾಡಿಸಿದಾಗ ನಾನು ಆ ಚೆಕ್ಕಿನ ಕುರಿತು ಯಾವುದೇ ಕ್ರಮ ತೆಗೆದುಕೊಂಡಿರುವುದಿಲ್ಲ ಅಂದರೆ ಸರಿ. ನನ್ನ ಊರಿನಲ್ಲಿ ನಮ್ಮ ಅಣ್ಣ ಒಬ್ಬರು ಟೈಲರಿಂಗ್ ಕೆಲಸವನ್ನು ಮಾಡುತ್ತಿದ್ದಾರೆ ಎಂದರೆ ಸರಿ. ಅವರು ಮತ್ತು ನನ್ನ ಮಧ್ಯೆ ಸಂಬಂಧ ಚೆನ್ನಾಗಿರ್ತದೆ ಎಂದು ಸರಿ. ನಮ್ಮ ಅಣ್ಣ ಮತ್ತು ಆರೋಪಿ ಮಧ್ಯೆ ಸಣ್ಣ ಪುಟ್ಟ ವಿಚಾರದಲ್ಲಿ ಮನಸ್ತಾಪ ಉಂಟಾಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಿಲ್ಲ. ಈ ರೀತಿ ಮನಸ್ತಾಪ ಇದ್ದರೆ ನಮ್ಮ ಅಣ್ಣ ಚಿತಾವೆ ಮೇರೆಗೆ ಹಾಗೂ ನಾನು ದುರ್ಲಾಭ ಬದ್ಧತೆಗೆ ಪಡೆದುಕೊಂಡಿದ್ದ ಚೆಕ್ಕನ್ನು ಆರೋಪಿ ವಿರುದ್ಧ ಸುಳ್ಳು ಲಾಭ ಪಡೆಯಲು ಚೆಕ್ಕನ್ನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡಿದ್ದೇನೆಂದು ಸರಿಯಿಲ್ಲ. ಚೆಕ್ಕನ್ನು ಯಾರು ಬರೆದು ಕೊಟ್ಟಿರ್ತಾರೆ ಅಂದರೆ ಆರೋಪಿ ಹೊಸೂರಿನಲ್ಲಿ ಬರೆದು ಕೊಟ್ಟಿರ್ತಾರೆ. ನಾನು ಪಡಿಸಿರುವಂತ ಚೆಕ್ಕಿನ ಮೇಲೆ ಇರುವ ಸಹಿ ಮತ್ತು ಇತರ ಬರವಣಿಗೆಗಳ ಬಗ್ಗೆ ಬೇರೆ ಬೇರೆ ಇಂಕ್ನಲ್ಲಿ ಪೆನ್ನಲ್ಲಿ ಬರೆದಾಗಿರ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಭದ್ರತೆಗಾಗಿ ಕೊಟ್ಟಂತ ಚೆಕ್ಕನ್ನು ಆರೋಪಿಯಿಂದ ಯಾವುದೇ ಹಣೆ ಬರುವುದು ಇಲ್ಲದಿದ್ದರೂ ನಾನೇ ಬರೆದುಕೊಂಡು ಬ್ಯಾಂಕ್ಗೆ ಹಾಜರುಪಡಿಸುತ್ತೇನೆ, ಸರಿಯಲ್ಲ. ದೆನ್ ಅಗೇನ್ ಇಟ್ ಕಂಟಿನ್ಯೂಡ್ ಆನ್ 14/2/2020. ನನ್ನ ಫೆಡರಲ್ ಬ್ಯಾಂಕ್ ಖಾತೆ ನಂಬರ್
ಏನ್ ಅಡ್ಮಿಷನ್ ಏನಿದೆ ಹೇಳ್ರಿ.
ನೆಕ್ಸ್ಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಬ್ಯಾಂಕ್ ಬ್ಯಾಲೆನ್ಸ್, ಈ ಬ್ಯಾಂಕ್ ಬಗ್ಗೆ 1 ಲಕ್ಷ ಬ್ಯಾಂಕ್ ಡೆಪಾಸಿಟೆಡ್ ಅಮೌಂಟ್ ದಟ್ ಹ್ಯಾಸ್ ಕ್ರೆಡಿಟೆಡ್ ಟು
ಏನ್ ಅಡ್ಮಿಷನ್ ಇದೆ
ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ನನ್ನ ಫೆಡರಲ್ ಬ್ಯಾಂಕ್ ಖಾತೆ ನಂಬರ್ ಈಗ ನಾನು
ನೀವೆಲ್ಲ ಓದ್ತಾ ಇದೀರಿ ಡಿಪೋಸಿಷನ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಇದು ಅಡ್ಮಿಷನ್ ಏನಿದೆ ಅದನ್ನ ಹೇಳಿ.
ಅದನ್ನೇ ನೆಕ್ಸ್ಟ್ ಓನ್ಲಿ ಫ್ಯೂ ಲೈನ್ಸ್ ಆದ ಮೇಲೆ ನನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ 1,10,000 ರೂಪಾಯಿಗಳನ್ನು ಪಾವತಿ ಮಾಡುತ್ತಾರೆ ಎಂದು ಸರಿಯಿಲ್ಲ. ಆರೋಪಿಯ ಜಮಾ ಮಾಡಿರುವಂತ ಬ್ಯಾಂಕ್ ಖಾತೆ ನಂಬರು ಆಗಿದ್ದು ಅದು ನನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆ ಆಗಿರುತ್ತದೆ ಅಂದರೆ ಸರಿಯಿಲ್ಲ. ಈಗ ಹೇಳಲಾದ 10,000 ರೂಪಾಯಿಗಳನ್ನು ನನ್ನ ನಿರ್ದೇಶನಂತೆ ಆರೋಪಿ ಒಂದು ತಿಂಗಳ ಚೀಟಿ ಹಣವನ್ನು ಬ್ಯಾಂಕ್ ಖಾತೆಗೆ ಜಮಾ ಮಾಡುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸದರಿ ಬ್ಯಾಂಕ್ ಖಾತೆ ಕುರಿತಂತೆ ಪರಿಶೀಲನೆ ಮಾಡಲು ನನ್ನ ತಕರಾರು ಇರುವುದಿಲ್ಲ. 1 ಲಕ್ಷ ರೂಪಾಯಿ ಚೆಕ್ಕನ್ನು ಆಗಸ್ಟ್ 2015ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದರು. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಹಾಜರುಪಡಿಸಿದ ಚೆಕ್ಕನ್ನು 2017 ಜನವರಿ ತಿಂಗಳಿಗೆ ಕೊಟ್ಟಿದ್ದು ದಿನಾಂಕ ನನಗೆ ನೆನಪಿರುವುದಿಲ್ಲ. ಆರೋಪಿ 2015 ಆಗಸ್ಟ್ನಲ್ಲಿ 1 ಲಕ್ಷ ರೂಪಾಯಿ ಚೆಕ್ಕನ್ನು ಕೊಟ್ಟಿರುವ ಕುರಿತಂತೆ ನನ್ನ ದೂರಿನಲ್ಲಿ ಅಥವಾ ಆಗಲೇ ನನ್ನ ಸಾಕ್ಷಿ ಪ್ರಮಾಣದಲ್ಲಿ ಕೊಂಡ್ರಿ 2015 ಕೊಟ್ಟಂತ ಚೆಕ್ಕನ್ನು ಆರೋಪಿ ಬರೆದು ಕೊಟ್ಟಿದ್ದರು. ಆ ಚೆಕ್ಕಿನ ದಿನಾಂಕ ನನಗೆ ನೆನಪಿರುವುದಿಲ್ಲ. ಸಾಲ ಕೊಟ್ಟ ಕುರಿತಂತೆ ಆದಾಯ ತೆರಿಗೆ ಪಾವತಿ ವಿವರದಲ್ಲಿ ಇದ್ದರೆ ತೊಂದರೆ ಇಲ್ಲ ಎಂದರೆ ಆ ಕುರಿತು ನನಗೆ ಗೊತ್ತಿರಲಿಲ್ಲ. ಆರೋಪಿಗೆ ಸಾಲದ ಹಣವನ್ನು ಕೊಟ್ಟ ಕುರಿತಂತೆ ಯಾವುದ ಕರಾರು ಪತ್ರವನ್ನು ಹೊರಡಿಸಿಕೊಂಡಿದ್ದು ಸಾಮಾನ್ಯವಾಗಿ 1 ಲಕ್ಷ ರೂಪಾಯಿಗಿಂತ ಹೆಚ್ಚು ಹಣವನ್ನು ಸಾಲವಾಗಿ ಕೊಟ್ಟಾಗ ಈ ಕುರಿತಂತೆ ದಾಖಲೆಯನ್ನು ಬರೆಸಿಕೊಳ್ಳಲಾಗಿದೆ ಎಂದರೆ ಆರೋಪಿಯು ಸ್ನೇಹಿತನಾಗಿದ್ದು. ಹಾಗೆ 2015ರಂದು ಆರೋಪಿಯು ಕೊಟ್ಟಿದ್ದರು ಎಂದು ಹೇಳಲಾದ 1 ಲಕ್ಷ ರೂಪಾಯಿಗಳು ಚೆಕ್ಕಿನ ನಂಬರ್ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಹೇಳಲಾದಂತ ಚೆಕ್ಕಿನ ನಂಬರಿನ ನಂತರ ನಂಬರು ಆಗಿತ್ತಂದರೆ ಸರಿಯಿಲ್ಲ. 2016 ಫೆಬ್ರವರಿ ತಿಂಗಳು ನಂತರದಲ್ಲಿ ಆರೋಪಿ ತನ್ನ ಹೊಸೂರು ಫೆಡರಲ್ ಬ್ಯಾಂಕ್ ಖಾತೆಯಿಂದ ವಿಜ್ಞಾನನಗರದ ಫೆಡರಲ್ ಬ್ಯಾಂಕ್ ಖಾತೆಯ ನನ್ನ ಖಾತೆಗೆ 20,000 ರೂಪಾಯಿ ಜಮಾ ಮಾಡುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಈ ರೀತಿ ಆರೋಪಿ 2 ಬಾರಿ ಹಣವನ್ನು ಜಮಾ ಮಾಡಿಲ್ಲ ಎಂದು ನಾನು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. 2016 ನನ್ನ ಬ್ಯಾಂಕ್ ಖಾತೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅನ್ನು ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇಲ್ಲ. ನಾನು ಕಾರ್ಪೆಂಟರ್ ಗುತ್ತಿಗೆ ಕೆಲಸ ಮಾಡಲು ಪರವಾನಗಿಯನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದು ನಾನು ಗುತ್ತಿಗೆ ಆಧಾರದ ಮೇಲೆ ಕಾರ್ಪೆಂಟರ್ ಕೆಲಸ ಮಾಡುತ್ತಿರುವುದು ಕುರಿತಂತೆ ನನ್ನ ಹತ್ರ ದಾಖಲೆಗಳು ಇರುವುದಿಲ್ಲ. ಸಾಮಾನ್ಯವಾಗಿ ಕಾರ್ಪೆಂಟರ್ ಗುತ್ತಿಗೆ ಕೆಲಸ ಮಾಡುವಾಗ ಕರಾರು ಪತ್ರಗಳು ಬರೆದು ಕೊಡಲಾಗುತ್ತೆ ಅಂದರೆ ನಾನು ಈ ರೀತಿ ದೊಡ್ಡ ಗುತ್ತಿಗೆ ಕೆಲಸ ಮಾಡುತ್ತಿಲ್ಲ, ಸಣ್ಣ ಗುತ್ತಿಗೆ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೆ. ನನ್ನ ಹತ್ರ ಕಾರ್ಪೆಂಟರ್ ಕೆಲಸ ಮಾಡುವಂತ ಕೆಲಸಗಾರರು ಇರ್ತಾರೆ. ಅಂಗಡಿ ಬಾಡಿಗೆ, ವಿದ್ಯುತ್ ಶಕ್ತಿ ಬಿಲ್ಲುಗಳು, ಕೆಲಸಗಾರರಿಗೆ ಸಂಬಂಧ ಕೊಟ್ಟ ನಂತರದಲ್ಲಿ ನನಗೆ ವರಮಾನ ಉಳಿಯುತ್ತಿತ್ತು ಅಂದರೆ ಸರಿ. ಆ ರೀತಿ ಎಲ್ಲಾ ಖರ್ಚನ್ನು ಕಳೆದು ನನಗೆ ವಾರಕ್ಕೆ 5,000 ಉಳಿಯುತ್ತಿಲ್ಲ, ಕೇವಲ 2,000 ರಿಂದ 3,000 ಉಳಿಯುತ್ತಿತ್ತು ಅಂದರೆ ಸರಿಯಿಲ್ಲ. ನಿಗದಿತ ಅವಧಿ ಎಷ್ಟು ಆಗಿತ್ತು ಎಂದರೆ ಆರೋಪಿ 1 ತಿಂಗಳಲ್ಲಿ ಹಣವನ್ನು ಕೊಡುತ್ತೇನೆ ಎಂದು ಹೇಳಿದ್ದರು. 2015 ಆಗಸ್ಟ್ ತಿಂಗಳಲ್ಲಿ 4 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಆರೋಪಿ ಕೊಡುವಂತ ಶಕ್ತಿ ನನ್ನ ಹತ್ರ ಇರಿದ್ದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಿಲ್ಲ. ನಾನು ಮಾಡುತ್ತಿದ್ದಂತ ಕಾರ್ಪೆಂಟರ್ ಕೆಲಸದಲ್ಲಿ ಬರುವಂತ ಆದಾಯವು ನಮ್ಮ ಕುಟುಂಬದ ಖರ್ಚು ವೆಚ್ಚಗಳಿಗೆ ಸಾಕಾಗುತ್ತಿತ್ತು ಅಂದರೆ ಅದರಲ್ಲಿ ಯಾವುದೇ ಹಣ ಉಳಿಯುತ್ತಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. 2015 ಆಗಸ್ಟ್ ತಿಂಗಳಲ್ಲಿ ನನಗೆ 4 ಲಕ್ಷ ಕೊಡುವಂತ ಶಕ್ತಿ ಇದ್ದಿರಲಿಲ್ಲ. ಆದ್ದರಿಂದ ಈ ಕುರಿತಂತೆ ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸುವುದಿಲ್ಲ, ಸರಿಯಲ್ಲ. ನಾನು ಆರೋಪಿಗೆ ಯಾವುದೇ ರೀತಿಯ ಸಾಲದ ಹಣವನ್ನು ಕೊಡದೇ ಇರುವುದನ್ನು ನನ್ನ ಆದಾಯ ತೆರಿಗೆ ಪಾವತಿಯಲ್ಲಿ ವಿವರದಲ್ಲಿ ನನಗೆ ತೋರಿಸಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಿಲ್ಲ. ಆರೋಪಿ ಮಾಡಿಕೊಳ್ಳದ ಚೀಟಿ ವ್ಯವಹಾರದಲ್ಲಿ ಬದ್ಧತೆಗಾಗಿ ಪಡೆದುಕೊಂಡಿದ್ದ ಖಾಲಿ ಚೆಕ್ಕನ್ನು ದುರ್ಲಾಭ ಪಡೆಯಲು ದುರುಪಯೋಗಿಸಲು ಆರೋಪಿ ವಿರುದ್ಧ ಸುಳ್ಳು ಪ್ರಕರಣ ದಾಖಲೆ ಮಾಡುತ್ತೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ವಕೀಲರ ಮೂಲಕ ನೋಟಿಸ್ ಕಳಿಸಿದ ನಂತರ ಆರೋಪಿ ಮತ್ತು ನನ್ನ ಸ್ನೇಹಿತರು ಬಂದು ನನ್ನ ಹತ್ತಿರ ಈ ಕುರಿತು ಕೇಳಿಕೊಂಡಾಗ ನಾನು ಆ ನೋಟಿಸಿನ ಮೇಲೆ ಮುಂದುವರಿಯುವುದಿಲ್ಲ, ಚೆಕ್ಕನ್ನು ವಾಪಸ್ ಕೊಡ್ತೇನೆ ಎಂದು ಹೇಳಿಕೊಂಡಿದ್ದೇನೆ ಅಂದರೆ ಸರಿಯಿಲ್ಲ. ನಾನು ಈ ರೀತಿ ಒಪ್ಪಿಕೊಂಡಿದ್ದರಿಂದ ಆರೋಪಿ ನಾನು ಕೊಡಿಸಿದಂತೆ ನೋಟಿಸ್ಗೆ ಯಾವುದೇ ಉತ್ತರವನ್ನು ಕೊಡಿಸಿರುವುದಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಹಿಂದೆ ಒಂದು ಚೆಕ್ ಬೌನ್ಸ್ ಆದ ನಂತರ ಯಾವುದೇ ಕ್ರಮ ಕೊಳ್ಳದೆ ಇದ್ದುದರಿಂದ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಹಾಜರುಪಡಿಸಲಾದ ಚೆಕ್ಕಿನ ಮೇಲೂ ಸಹ ನಾನು ಯಾವುದೇ ಕ್ರಮ ಕೊಳ್ಳುವುದಿಲ್ಲ ಎಂದು ತಿಳಿದು ಆರೋಪಿ ನನ್ನ ವಿರುದ್ಧ ಯಾವುದೇ ಕ್ರಮ ತೆಗೆದುಕೊಂಡಿದ್ದರೆ ಸರಿಯಿಲ್ಲ. ಆರೋಪಿ ನನ್ನಿಂದ ಯಾವುದೇ ರೀತಿಯ ಸಾಲವನ್ನು ಪಡೆದಿದ್ದರೂ ಸಹ ಆ ವಿರುದ್ಧ ಚೆಕ್ಕನ್ನು ದುರ್ಬಳಕೆ ಮಾಡಿಕೊಂಡು ಸುಳ್ಳು ದಿಸ್ ಇಸ್ ಫಾರ್ ಎ ಮೂಮೆಂಟ್ ಯುವರ್ ಆರ್ಶಿಪ್ ರಿಗಾರ್ಡಿಂಗ್ ದಿ ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್. ಅದರಲ್ಲಿ yes, produce the bank statement. May I read out the defense order? Even according to me, he has paid the 4 lakhs in the year 2002.
ನಿಮ್ ಜೊತೆ ಯಾರು ಚೀಟಿ ನಡೆಸ್ತಾ ಇದ್ರು ಅಂದ್ರೆ ಅವ್ರು ಚೀಟಿ ನಡೆಸ್ತಾ ಇದ್ದಾರೆ ಒಬ್ರದ್ದು ಬೇರೆ ಮೆಂಬರ್ಸ್ ಒಬ್ರದ್ದು ಹೆಸರು ಕೂಡ ಗೊತ್ತಿಲ್ಲ ನಿಮ್ಗೆ. ನೀವು ಚೀಟಿ ಅಂತ ಡಿಫೆನ್ಸ್ ತಗೋತೀರಾ.
But our even otherwise also he has not explained about even he has.
ನಿಮ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೋಗ್ಲಿ.
ನಾನು ಕ್ರಾಸ್
ಪ್ಯಾರಾ 2 ನಲ್ಲಿ ಓದೋದ್ ಬೇಡ, ನಾನು ಓದಾಯ್ತು.
ಡಿಫೆನ್ಸ್ ಮೇಲೆ
ನಾನು ಹೇಳುವಂತೆ ಫಿರ್ಯಾದಿದಾರ ಚೀಟಿ ಅವರನ್ನು ಎಲ್ಲಿ ಮಾಡುತ್ತಿದ್ದರು ಎಂದರೆ HCL ಹತ್ತಿರ ಇದ್ದ ಮರದ ಅಂಗಡಿಯ ಹತ್ತಿರ ನಡೆಸುತ್ತಿದ್ದರು.
ಎಸ್,
ಮರದ ಅಂಗಡಿ ಹತ್ರ ಫಿರ್ಯಾದಿದಾರ ಹತ್ತಿರ ಚೀಟಿ ವ್ಯವಹಾರ ಮಾಡುತ್ತಿದ್ದರು ಎನ್ನಲಾದ ಬೇರೆ ವ್ಯಕ್ತಿಗಳ ಹೆಸರುಗಳನ್ನು ನನಗೆ ಹೇಳಲು ಆಗುವುದಿಲ್ಲ.
ಎಸ್ ಸರ್.
ನಿಮ್ಗೆ ಯಾರು ಅದರ್ ಸಬ್ಸ್ಕ್ರೈಬರ್ ಮೆಂಬರ್ ಆದವ್ರದ್ದು ಹೆಸರು ಗೊತ್ತಿಲ್ಲ. ಸಾಮಾನ್ಯ ಚೀಟಿ ವ್ಯವಹಾರದಲ್ಲಿ ಚೀಟಿ ಹಣ ಪಡೆದುಕೊಂಡಾಗ ಸದಸ್ಯರಾಗಿದ್ದ ವ್ಯಕ್ತಿಗಳ ಪೈಕಿ ಒಬ್ಬರನ್ನು ಜಾಮೀನುದಾರರಾಗಿ ಕೊಡಬೇಕಾಗಿರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ನಾನು ಡಿಸೆಂಬರ್ ತಿಂಗಳಿನಲ್ಲಿ 40,000 ಬಿಡ್ ಹಣವನ್ನು ಪಡೆದುಕೊಳ್ಳುವಾಗ ಯಾವುದೇ ಜಾಮೀನುದಾರರನ್ನು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ.
ಸಂಬಂಧಪಟ್ಟಂತೆ
ಚೀಟಿ ವ್ಯವಹಾರಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಫಿರ್ಯಾದಿ ನನ್ನಿಂದ 2 ಖಾಲಿ ಚೆಕ್ ತೆಗೆದುಕೊಂಡು ಎನ್ನುವ ಸಮಯದಲ್ಲಿ ಯಾರಾದರೂ ಸಾಕ್ಷಿದಾರರು ಇದ್ದರೆ ಎಂದರು. ಅವರು ಯಾರು ಎಂದರೆ ನಮ್ಮ ಪಕ್ಕದ ಊರಿನವರದ ಮುನಿಚಂದ್ರಪ್ಪ ಆಗಿರುತ್ತಾರೆ. ಅವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರೆ ಹೋಗ್ಲಿ. ನಾನು ಹೇಳುವಂತ ಮುನಿಚಂದ್ರಪ್ಪ ಅವರು ಚೀಟಿ ವ್ಯವಹಾರದಲ್ಲಿ ಸದಸ್ಯರಾಗಿರುವುದಿಲ್ಲ. ಫಿರ್ಯಾದಿದಾರರು ಚೀಟಿ ವ್ಯವಹಾರ ನಡೆಸುತ್ತಿದ್ದರು ಎನ್ನುವ ಕುರಿತಂತೆ ತೋರಿಸಲು ನಾನು ಯಾವುದೇ ದಾಖಲಾತಿಗಳನ್ನು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿರುವುದು ಎಂದರೆ ಸರಿ. ಆಮೇಲೆ ಚೆಕ್ ಪಡ್ಕೊಂಡಿದ್ಕೆ ನಂತರದಲ್ಲಿ ವಾಪಸ್ ಕೊಡದೇ ಇದ್ದಾಗ ಏನಾದ್ರು ಕ್ರಮ ಕೈಗೊಂಡ್ರ ಅಂದ್ರೆ ಏನೂ ಇಲ್ಲ.
ಅಲ್ಲ, ಬಟ್ ಆಫ್ ಕೋರ್ಸ್ earlier one check
ಅವುಗಳನ್ನು ನಗದೀಕರಣ ಮಾಡದಂತೆ ಕೇಳಿ ಬ್ಯಾಂಕ್ನವರಿಗೆ ನಾನು ಯಾವುದೇ ಪತ್ರವನ್ನು ಕೊಟ್ಟಿರುವುದಿಲ್ಲ. ಫಿರ್ಯಾದಿದಾರರು ಪಡೆದುಕೊಂಡಿದ್ದ 2 ಚೆಕ್ಗಳನ್ನು ವಾಪಸ್ ಕೊಡದೇ ಇರುವ ಕುರಿತು ಅವರ ವಿರುದ್ಧ ಪೊಲೀಸ್ನವರಿಗೆ ದೂರನ್ನು ಕೊಡಲು ಮತ್ತು ವಕೀಲರ ಮೂಲಕ ನೋಟಿಸ್ ಅನ್ನು ಕೊಡಲು ನನಗೆ ತೊಂದರೆ ಇದ್ದಿರಲಿಲ್ಲ. These are the admissions. You are admitting the exhibit P1 check.
No, earlier one check was 1 lakh check was given, madam. That he has not taken any initiative, he has not initiated any action. ಅದರಿಂದ ಈ ಚೆಕ್ ನನಗೆ because it is 2000 according to even him also he says that 2015 madam he paid, but how could he take a check of the year 2000?
ಹೇಳಿದಂತ 1 ಲಕ್ಷ ರೂಪಾಯಿಗಳ ಚೆಕ್ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ ನಗದೀಕರಣವಾಗದೆ ಅಮಾನ್ಯಗೊಂಡಿತ್ತು ಎಂದರೆ ಸರಿ. ಸದರಿ ಚೆಕ್ ಅಮಾನ್ಯಗೊಂಡ ನಂತರ ಫಿರ್ಯಾದಿದಾರ ನನ್ನ ಹತ್ತಿರ ಬಂದು ಕೇಳಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಸಾಕ್ಷಿ ಸ್ವತಃ ನಾನೇ ಕೇಳಿರುತ್ತೇನೆ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. ಆ ರೀತಿ ಕೇಳುವಾಗ ಮತ್ತೊಂದು ಚೆಕ್ ಅನ್ನು ವಾಪಸ್ ಕೊಡುವಂತೆ ಕೇಳಲು ಏನಾದರೂ ತೊಂದರೆ ಇತ್ತಾ ಎಂದರೆ ಕೇಳಿರುತ್ತೇನೆ, ಕೊಡುತ್ತೇನೆ ಎಂದು ಹೇಳಿದರು. ವಾಪಸ್ ಕೊಡದೇ ಇದ್ದಾಗ ಆ ಪ್ರಕರಣದಲ್ಲಿ ಹಾಜರುಪಡಿಸಿದ ಚೆಕ್ ಅನ್ನು ನಗದೀಕರಣಕ್ಕೆ ಹಾಕಿದಾಗ ನಗದೀಕರಣ ಮಾಡದಂತೆ ಬ್ಯಾಂಕ್ನವರಿಗೆ ಕೇಳಲು ತೊಂದರೆ ಇದ್ದಿರಲಿಲ್ಲ.
Regarding deposit amount, the exhibit D1 and bank statement he has produced, madam. That he has totally denied, madam.
ಇವನ್ ನೋಟಿಸ್ಗೂ ರಿಪ್ಲೈ ಕೊಟ್ಟಿಲ್ಲ ನೀವು.
ಕೊಟ್ಟಿಲ್ಲ, that is too much. ಯಾಕಂದ್ರೆ ನಾನು I will not initiate any action ಅಂತಂದಿದ್ದು after issuance of notice he went to the complaint matter. ಈಗ ಮಾಡೋದಿಲ್ಲ, ನಂಗೇನು ಮಾಡೋದಿಲ್ಲ ಅಂತ ಏನೋ ಹೇಳಿ.
W2 ಏನ್ ಮಾಡಿದಾರೆ ನೋಡ. ಏನಿಲ್ಲ, he is also not the subscriber. Third.
Citation code.
Hmm.
Income tax.
ಕೊಡಿ. ಏನ್ ಹೇಳಿ, ಯಾವ ಪರ?
ಅದೇ head note ಇವ್ರ.
Head note.
Decision object, presumption regarding negotiation, negotiable instrument, allegation that the check issued by accused for repayment of the loan was dishonored, while complaint claimed that the check was issued as security at the time of the advancing the loan. In class exam, he deposed that the same was given when alleged demand for repayment of loan amount was raised before accused after period of 6 months of advancement. Financial capacity or acknowledgement of the by complainant due to the effect having advanced a loan to accused was not indicated in the cross income tax return. Complaint failed to prove when the said loan was advanced and to explain as to how a check issued by accused allegedly in favor of another person came to his hands. Complainant not able to.
That is not your case.
Here also no income tax.
Given to somebody else and.
But here, no, only check purpose it is the amount was given, that is the contention taken by the accused. Even he says that he is an income tax assessee, but he has not disclosed in the income tax assessee. He says that for the past 5 to 6 years I am the filing the income return anತಾರೆ, but ಅದಕ್ಕೆ ಅದ್ರ ಬಗ್ಗೆ ಏನೂ ಇಲ್ಲ.
Sorry, third. Heard the petitioner counsel and this matter is listed for admission and records are also received and hence consider the matter on merits. The respondent counsel is absent and in the previous occasion, this court made it clear that if respondent counsel doesn't appear in the state of hearing, matter will be heard in his absence. This revision petition is filed against the conviction and sentence passed by the trial court under section 138 of NI Act, wherein 3 months simple imprisonment as well as fine of rupees 2,000 is imposed. And also directed to pay compensation amount of rupees 4,50,000, failing which liberty to recover the said amount as per section 421 of CRPC. And the same is confirmed in the criminal appeal number 25023 of 2021. The factual matrix of case of complainant before the trial court is that accused is his friend. Due to financial difficulties, the accused has approached him for hand loan of rupees 4 lakh in the month of first week of August 2015 and promised to pay the same within a month. The complainant has approached the accused and demanded to repay the amount, but he did not repay the same and hence he issued the check for rupees 4 lakh on 17/1/2017, and when the same was presented, dishonored with an endorsement funds insufficient. The same was communicated to him and also legal notice was issued and the same was served and no reply was given. And he did not comply the demand. Hence filed a private complaint and trial court also taken the cognizance and secured him and he did not plead guilty and hence the complainant examined himself as PW1 and got marked the document exhibit P1 to P5. That is check, bank endorsement, legal notice, postal receipt and postal endorsement. On the other hand, the accused also examined himself as DW1 and also examined one witness as DW2 and got documents of exhibit D1 to 3. The trial court, having considered the evidence of complainant and documentary evidence, comes to the conclusion that defense was taken in the cross examination that the complainant was running the chit transaction, and in that connection, he has issued the check as security. But during the course of cross-examination, nothing is elicited, and when the DW1 also examined, he did not place any material regarding the chit transaction. And also, though examined DW2, he is also not the member of the said chit transaction, and hence not accepted the defense theory of the accused and convicted and sentenced. Being agreed by the said order, an appeal is filed, and appellate court also having reassessed both oral and documentary evidence, even extracted the evidence of PW1 and DW1 and DW2, and having reassessed the material on record, comes to the conclusion that even though defense was taken that there was a chit transaction, nothing is placed on record. None of the others subscriber of the chit also examined before the court, and hence not accepted the defense theory and confirmed the judgment of the trial court. Being agreed by the said concurrent finding, the present revision is filed before this court. The main contention of the counsel that there is an admission with regard to the payment of rupees 10,000 is considered by the complainant, and in spite of he was elaborately cross-examined and answers are elicited regarding earlier transaction, and subscribing of the chit also questions was put to him, but he has not admitted, but it is a clear case of checks are misused which have been given in connection with the chit transaction, and the same is not accepted by the trial court as well as the appellate court. The counsel also, in support of his argument, he relies upon the judgment reported in the AR 2024 Supreme Court 4103, wherein with regard to the contention is concerned, financial capacity or acknowledgement by complainant to the effect of having advanced a loan to accused was not indicated in the income tax returns. Complainant failed to prove when the said loan was advanced and to explain as to how a check issued by accused allegedly in favor of another person came to his hands. Complainant was not able to plead even a valid existence of legally recoverable debt. The accused had inscribed his signature on agreement drawn on a white paper and not on a stamp paper. The accused has rebutted the presumption under section 139, and hence apex court held that acquittal is valid. The counsel referring this judgment would contend that in the case on hand also the complainant not declared the same in his income tax returns, and hence it requires interference. Having heard the petitioner counsel and also the principles laid down in the judgment and also the reasons assigned by the trial court, the point that would arise for the consideration of this court are whether both the courts committed an error in coming to the conclusion that complainant has issued the check exhibit P1 and the same is a legal liability, committed an error in not accepting the defense theory, whether it requires interference of this court exercising the revisional jurisdiction, and whether the order of the trial court and appellate court suffers from its legality and correctness. What order? Having heard the petitioner counsel and also on perusal of material, it is the specific case of complainant that this petitioner was having acquaintance with the complainant since both of them are friends, and he had approached for availing loan of rupees 4 lakh in the first week of August 2015, and he promised to repay the same, but he did not repay the same, and on demand he had issued the subject matter of check dated 17/1/2017. It is not in dispute that check was issued and the signature in exhibit P1 also admitted, and also when the same was presented and the same was also dishonored is not in dispute. It is also not in dispute that notice was issued and the same was served and no reply was given. However, it is the specific defense of the petitioner that complainant was running the cheat transaction. And in order to prove the factum of the complainant was running the cheat is concerned, nothing is placed on record before the trial court. Even did not examine any of the other subscriber of the cheat, and only he had examined the witness DW2. And though he says that in connection with cheat transaction, checks are given, but he was not the subscriber of the cheat. And also petitioner categorically admits that if any cheat transaction, if any bid was made, normally insist the other subscriber to become a guarantor. And also DW1 categorically admits that he did not offer any guarantor of any of the other subscriber of the cheat. And with regard to the cheat transaction is concerned, nothing is placed on record. And the defense remains as defense only. And no doubt counsel for the petitioner brought to notice of this court that the petitioner was a carpenter. And also suggestion was made that he was not saving any money, but he categorically says that he was saving 3,000 to 4,000 every week, though he claims 6,000 every week he used to save the same. Having considered the principles laid down in the judgment referred, no doubt in the case on hand also complainant has not declared the same his income tax returns. And the fact that he was an income tax assessee, nothing is placed on record. And apart from that, in the decision of the apex court relied upon by the counsel for the petitioner, wherein the check belongs to the check given to the other person, gone to the hands of the complainant, and hence the apex court comes to the conclusion that no reason was assigned how he got the check. And having considered the principle laid down in the judgment is concerned, and reasoning given is not applicable to the facts of the case on hand. In the said case also, signature was found on the agreement, and rebuttal evidence also led by the accused. And counsel and apex court comes to the conclusion that rebuttal evidence is placed before the court. But in the case on hand, there is no any rebuttal evidence except the defense of the complainant was running the cheat. And with regard to the cheat transaction is concerned, and on account of the said cheat transaction, he has given the checks also. Same is not substantiated by placing any plausible evidence before the trial court. And court can accept the defense only if any answer is elicited from the mouth of PW1. And instead of answers elicited from the mouth of DW1 and DW2 is very clear that nothing is placed on record that there was a cheat transaction between the complainant and accused. And nothing is placed on record even by examining any of the other cheat subscriber, and also no document is placed that there was a cheat transaction between them. And once he admits the check bears his signature, he has to rebut the same by leading present evidence. No doubt, section 139 of NI Act is a rebuttable presumption and not absolute presumption. And unless presumption is rebutted, the question of coming to the other conclusion doesn't arise. Having reassessed the material of by the appellate court also even extracted the each and admission of PW1 and DW1 while considering the matter on merits. And both the trial court as well as the appellate court not committed any error in appreciating the evidence. The scope of revision is also very limited. Only if finding given by the trial court is suffers from any perversity, and if any lacking of legal evidence, and if the same is suffers from legal infirmity, and then only court can exercise the revisional jurisdiction. And the said situation is not warranted in the case on hand to enforce, to invoke the revisional jurisdiction. And hence, I do not find any merit in the petition to comes to a other conclusion. And hence I answer the point as negative. In view of the discussions made up, I pass the following order. Revision petition is dismissed. Netravati Samir Sen, 498.
Responder one.
Yes, my lord. In this,
Records ಬಂದಿದೆಯಾ? ಬೇಕಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಲ್ಲ
ಕಾಲ್ ಫಾರ್
ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ಯಾ
ಇಲ್ಲ ಬಂದಿಲ್ಲ, ಕಾಲ್ ಆಗಿದೆ.
ಕಾಲ್ ಆಗಿದೆ. Registry is directed to issue reminder to send the records and list the matter as soon as records are received. 39 Jayanti R. Suspension of sentence. ಒಂದ್ಸಲ ಬರ್ತಾ ಇಲ್ವಾ ನೋಡಿ, ಲಾಸ್ಟ್ ಟೈಮ್ ಏನಾಗಿದೆ ನೋಡಿ. 22 ಇಂದ ಇವನ್ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಗೆ ಇದೆಯಾ? Though this petition is filed in 2022 till date, the council not pressed the petition for suspension of sentence and matter was last listed on 13/7/22 and thereafter not listed. However, in the interest of justice, one more opportunity is given to the petitioner counsel and list this matter on the other date kodi. 5/3. Shekarappa HC.
For petition. Memo for withdrawal.
Withdrawal.
Matter is settled.
The counsel for the petitioner files memo
Is closed.
seeking permission of this court to withdraw the petition since the matter was compromised and hence permitted to withdraw.
Please.
41 Girish D. Baladare. 6 months for 425,000. ಹೇಳಿ.
ರೆಕಾರ್ಡ್ ಬಂದಿಲ್ಲ ಸರ್.
ರೆಕಾರ್ಡ್ ಬಂದಿಲ್ಲ ನೋಡಿ ಮೇಡಮ್, ಕಾಲ್ ಫಾರ್ ಆಗಿದೆ ನೋಡಿ. ಅದರ್ ಸೈಡ್ ಸರ್ವ್ಡ್ ಅಲ್ಲ,
ಸರ್ವ್ಡ್ ಅನ್ರೆಪ್ರೆಸೆಂಟೆಡ್.
ಅಲೆ ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ ಸರ್, ಕಾಲ್
ಆಯ್ತು. Registry is directed to get the records from both the courts and list this matter as soon as records are received.
42 ಕಿಶೋರ್ ಕುಮಾರ್.
ಕಿಶೋರ್ ಕುಮಾರ್ AS. ಇಲ್ವಾ? ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ನೋಡಿ, ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಆಗಿದೆಯಾ ನೋಡಿ. ಯಾಕಂದ್ರೆ IAS ಅದು ಹಾಕಿಲ್ಲ, IAS ತೋರಿಸಿಲ್ಲ. ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ?
ಏನೇ ಇಲ್ಲ
ಏನೇ ಇಲ್ಲ.
ಆರ್ಡರ್
ಇರುತ್ತೆ ಮೇಡಮ್, ಏನೇ ಆಕ್ಟ್ IML ಆರ್ಡರ್ಸ್ ಆಗಿಲ್ವಾ? ಯಾಕೆ ತೋರಿಸಿಲ್ಲ ಅವರು? Dismissed as not pressed. Not pressed ಅಂದ್ರೆ ಮತ್ತೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಪಿಟಿಷನ್. This matter was last listed on 28/10/22 and thereafter not listed and council also not pressed. Number 1 of 22 and the same also dismissed. And it appears that the petitioner is not pursuing the matter. The petitioner is expected to deposit 50% of the fine amount, inclusive of the amount already deposited before the trial court by the state of hearing ಅಂತ ಏನು ಆರ್ಡರ್ ಇದೆ ಇಲ್ಲಿ. ರೆಕಾರ್ಡ್ ಬಂದಿದೆಯಾ ನೋಡಿ? ಬಂದಿಲ್ಲ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಆಗಿಲ್ವಾ? ಅಪ್ಲೈ ಆಗಿದೆಯಾ ಏನು ಯಾರು ಗೊತ್ತಾಗ್ತಿಲ್ಲ. 21/9/22. ಬಟ್ ಒಂದೇ ಒಂದು ನಾಟ್ ಪ್ರೆಸ್ಟ್ ಅಂತಂದ್ರೆ ಈ ಆರ್ಡರ್ ಯಾವ್ದ್ರ ಮೇಲೆ ಆಯ್ತು? ಏನು ಇಲ್ಲ ಇಲ್ಲಿ. ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಏನ ಮತ್ತೆ ಇಲ್ಲಿ ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಪರ್ಮಿಟೆಡ್ ಟು ಡೆಪಾಸಿಟ್ ಅಂತ. ನೋಡಿ ಏನೋ the matter was last listed on 28/10/22 and thereafter not pursued the matter. However, in the interest of justice, one more opportunity is given. List this matter on 5/3/2025.
43
Guruswami K. Samuel.
Petitioner madam.
Dandin.
Interim
records ಬಂದಿದೆ 22,45,000.
Appellate court reduce ಮಾಡಿದೆ. ಚೆಕ್ ಅಮೌಂಟ್ 15 lakhs ಇದೆ ಸರ್.
15 lakh.
15 lakhs. ಚೆಕ್ ಅಮೌಂಟ್ 15 lakhs. ಟ್ರಯಲ್ ಕೋರ್ಟ್ 22 lakhs ಕನ್ವಿಕ್ಷನ್ ಮಾಡಿದ್ರು. ಮಾಡಿಫೈ ಮಾಡಿದ್ದಾರೆ 15 lakhs ಕನ್ವಿಕ್ಷನ್. ಎಂಟ್ರಿ ಮಾಡಿ ಕಂಪ್ಲೈ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ, ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ವಿ 50% ಮಾಡಿದ್ವಿ.
ಆಯ್ತು ಹೇಳಿ ಏನಿದೆ
ಮೆರಿಟ್ ಮೇಲೆ
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಲ್ಲ.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ. ಕಂಪ್ನಿ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಯ್ತು ಮಾಡಿಲ್ಲ. ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್.
Compensation of rupees 15 lakh instead of 22 lakh 45,000.
ಹೌದು ಚೆಕ್ ಬಿಲಾಂಗ್ಸ್ ಟು ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್. ಚೆಕ್ ಬಿಲಾಂಗ್ಸ್ ಟು ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್ ಮೇಲೆ ನಮ್ಮನ್ನ ಪಾರ್ಟಿ ಇಂಡಿವಿಜುವಲ್ ಪಾರ್ಟಿ ಮಾಡಿ
ಅದರ್ ಸೈಡ್ ಯಾರು ಇಲ್ವಾ? ಶ್ಯಾಮೆ ಇಲ್ಲ.
ಯಾರು
ನಿಮಗೆ ಟೈಮ್ ಬೇಕಾ? Petitioner counsel seeks time. And counsel for respondent is absent. This matter on 5-3.
much of less.
44. Shankar Narayan Bhatt. State. HCGP 2 years, 1 year, 18 months. 457, 380. ಏನ್ habitual offender?
ಅಲ್ಲ.
ಏನಾದ್ರು ಕೇಸಸ್ ಇದೆಯಾ ಅವನ ಮೇಲೆ?
ಬೇರೆ ಇಲ್ಲ.
ಇದೊಂದೇನಾ?
ಹಾ.
ಯಾರು ಸ್ಟೇಟ್ ಅಪಿಯರ್ ಆಗೋದು ನೀವೇನ್ರಿ? ಏನಾರು ಇದೆಯಾ habitual offender ಅಥವಾ ಒಂದೇ ಒಂದು ಕೇಸ?
ಒಂದೇ ಕೇಸ್. That's observation to that effect. ಅದರ observation ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ ವರ್ಡನಲ್ಲಿ.
ಮಾಡಿದಾರಾ?
ಹೌದು.
Appellate court ಅಲ್ಲಿ.
ಹೌದು. He is not in.
3 years for the offense, Presumption sessions also 3 years and offense also. Being agreed by the orders on. The evidence.
Out of 3 accused, 1 is absconding, and against 2.
Please?
But out of 3 accused, 1 is absconding, and against 2 the proceedings took place and 2 are.
ಏನಾದನ್ರಿ abscond ಆದವನು ಏನಾದನ್ರಿ? ಸಿಕ್ಕಿದ್ನ ಇಲ್ಲ. ಎಲ್ಲ ರಿಕವರಿ ಎಲ್ಲ ನಿಮ್ಮಿಂದಲೇ ಆಗಿದ್ರಿ.
Recovery ಅದು as per the
missing links in this chain have been clearly established which a peculiar.
Because that is second accused who is absconding, he is the main person behind it. And even this per the statement also, you're probably at the most maybe abettors to the said offense. Like that, in the statement also, the second accused who is absconding, he is the main person who was responsible for the theft. Statement record nalla ಇವರನ್ನು ನೀ ಅಲ್ಲಿ ನೋಡು ಇಲ್ಲಿ ನೋಡು ಅಂತೇಳಿ ಅವನು ಹೋಗಿ broke open the door lock and committed theft. ಅವರ statement ಅಲ್ಲಿ ಆ ತರ ಇದೆ statement. ಅಲ್ಲಿ ಯಾರು ಬರ್ತಾರ ನೋಡು, ನೀ ಕಾಯ್ತಾ ಇರ ಅಲ್ಲಿ ನೋಡು ಅಂತ ಹೇಳಿ ದಿ ಸೆಕೆಂಡ್ accused has committed that offense.
Recovery witnesses ಯಾರು?
Yeah.
Recovery witness.
Because the PWs, three, 2, 3,
No, no, PW2.
PW2. Shivananda, Ashwinarayana.
ಏನ್ರಿ ಕೇಸು ನಿಮ್ದು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕೇಸು? ರಿಕವರಿಗೆ ಯಾರು ಫಸ್ಟ್ ತೋರಿಸ್ತಾರ ಯಾರು ಎಲ್ಲಿದೆ ಅಂತ ಕರ್ಕೊಂಡು ಹೋದಾರ ಯಾರು? ಅದ್ರ ಬಗ್ಗೆ ಏನು ಎವಿಡೆನ್ಸ್ ಕಾಣ್ತಾ ಇಲ್ಲ, ನೋಡ್ತಾ ಇದೀನಿ ನಾನು. ಡಿಸ್ಕವರಿ ಏನಾರು ಇದೆಯಾ ಅಂತ. ರಿಕವರಿ ಆಯ್ತು, ಎಲ್ಲಿಟ್ಟಿದ್ದ ಅವನು ತಗೊಂಡೋಗಿ? ದೇವಸ್ಥಾನದ ಬಲಭಾಗದಲ್ಲಿ ಗೋಡೆ ಪಕ್ಕದಲ್ಲಿ ಬಿದ್ದಿದ್ದವಂತೆ. ಬೀಗಗಳು ಯಾವ ಕಂಪನಿದು ಎಂದು ಗೊತ್ತಿಲ್ಲ. ಹೇಳಿ counsel ಹೇಳಿ. ಹೇಳಿ. What is your ground for exercising revisional jurisdiction?
Evidence led in by the prosecution not establish the guilty of this when the they say they on confusion state they recover the material of it. But in the even in that also the as far as this petitioner is concerned, he has stated that he has not committed that offense as such. He was only asked to be this. ಅಲ್ಲಿ ಯಾರು ಬರ್ತಾರೆ ನೋಡಿ ಇಲ್ಲಿ ಇದು ಅಂತೇಳಿ ಮಾತ್ರ ಹೇಳಿ ಈ ರೀತಿ ಕನ್ಫೆಷನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ರೀತಿ ಬರೆದಿದ್ದಾರೆ. ನಾವು 3 ಜನ ಸಂತೆ ಬಿದ್ದಿ ಬಂದು ನನ್ನನ್ನು ಆಸ್ಪತ್ರೆ ಕಡೆ ಯಾರು ಬಂದರಾಯ್ತು ನೋಡಿಕೋ ಎಂದು ಉಪೇಂದ್ರ ಹೇಳಿದ. ನಾನು ಪ್ರದೀಪಿಗೆ ಸ್ವಾತಂತ್ರ್ಯ ಕಡೆಯಿಂದ ಯಾರು ಬರ್ತಾರೆ ಎಂದು ಕಡೆ ನೋಡಿಕೋ ಎಂದು ಹೇಳಿ ನಮ್ಮನ್ನು ಕಾವಲಿಗಿರಿಸಿ ಉಪೇಂದ್ರ ಪಾರ್ವತಿ ಹತ್ತಿರ ದೇವಸ್ಥಾನಕ್ಕೆ ಹಾಕಿದ ಬೀಗವನ್ನು ದಾಡಿಯಿಂದ ಮೀಟಿ ದೇವರನ್ನು ತೆಗೆದುಕೊಂಡು ದೇವಸ್ಥಾನದ ಆವರಣದಲ್ಲಿ ಬಿದ್ದಿದ್ದ ಒಂದು ಪ್ಲಾಸ್ಟಿಕ್ ಅನ್ನು ಹಾಕಿಕೊಂಡು ಉಪೇಂದ್ರ ರಸ್ತೆಗೆ ಬಂದು ನಮ್ಮನ್ನು ಪ್ರದೀಪನ್ನು ಕರೆಕೊಂಡು ವಜ್ರಪ್ಪ ಮಿಲ್ಸಲ್ಕ ಹತ್ರ ಬಂದು ಕಿರೀಟವನ್ನು ಪ್ರದೀಪನ ಕೈಗೆ ನೀಡಿದನು ಅಂತೆ. So even a statement apart from that is the other witnesses not specifically stated anything on because they as far as theft is concerned. So at the most he can be a better to the proceedings, not even if it is to be considered. And in the Mahajar also, they are not able. They say, ನಾನು ಸ್ಥಳದಲ್ಲಿ ನಾನು 2 ಸ್ಥಳದಲ್ಲಿ ಸಹಾಯ ಮಾಡಿದ್ದು ನಿಜ, ಆದರೆ ನನ್ನ ಜೊತೆ ಇನ್ನೆಷ್ಟು ಜನ ಸಹಾಯ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳೋದು ಆಗುವುದಿಲ್ಲ. ಮಹಾಜರು ಮಾಡುವಾಗ ನಾನು ಅಲ್ಲೇ ನಿಂತಿದ್ದೆ, ನನ್ನ ಜೊತೆ ಗುರುತು ಸಹಾಯ ಮಾಡಿದ್ದಾರೆ, ಇನ್ನು ಯಾರು ಸಹಾಯ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನೆನಪಿಲ್ಲ. ನಾನು ಮಹಾಜರು ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಯಾವುದೇ ಹೇಳಿಕೆ ಕೊಟ್ಟಿಲ್ಲ. ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋಗಿಲ್ಲ 2 ಮಾಡಿ. And other witness, it was ನಾವು ಸ್ಥಳಕ್ಕೆ ನಡ್ಕೊಂಡು ಹೋಗಿದ್ದೆ. ನಾನು ಸ್ಥಳ ಇದ್ದಾಗ ಪೊಲೀಸ್ ಪಂಚರ್ ಆಗಲು ಹೇಳಿಕೊಂಡ ಪ್ರಕಾರ ಲಿಖಿತ ಹೇಳಿಕೆ ಕೊಂಡಿರುವುದಿಲ್ಲ. ಮಹಾಜರ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಮತ್ತು ದಫೇದಾರ್ ನನ್ನ ಅಂಶ ತಯಾರಿಸಿದ್ದಾರೆ, ಅದನ್ನು ಕೇಳಿಸಿಕೊಂಡೆ. ಅಲ್ಲಿ ಹೋಗೇ ಇಲ್ಲ. ನಾನು ಮಹಾಜರಿಗೆ ಠಾಣೆಯಲ್ಲಿ ಕುಳಿತು ಬರೆದು ಮುಗಿಸಿ ಅಲ್ಲಿಗೆ ಹೋಗಿ ಸಹಿ ಮಾಡಿದ್ದೇನೆ, ಸರಿಯಲ್ಲ. ನನ್ನ ಸಂಶಯ ಅವರ ಅಮಾನತು ಕೊಂಡ ಸ್ಥಳ ಮಹಾಜರು ಮಾಡಿಲ್ಲ ಎಂದು ಸುಳ್ಳು. ವಸ್ತು ಅಮಾನತು ಚಕ್ಕು ಬಂದು ಹೇಳಲು ಬರುವುದಿಲ್ಲ. ರೇಣುಕನ ಕಿರೀಟ ಅಮಾನತು ಪಡಿಸಿದ ಸ್ಥಳದಲ್ಲಿ ಪೊಲೀಸ್ ಠಾಣೆ 2 ಕಡೆ ಸಹಿ ಮಾಡಿದ್ದೇನೆ. ನನ್ನ ಯಾರು ಸಹ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಸಹಿ ಮಾಡಿದ ದಾಖಲೆ ಏನು ಬರೆಯಲಾಗಿದೆ ಎಂದು ತಿಳಿದುಕೊಂಡು ನನ್ನ ಕನ್ನಡ ಭಾಷೆ ಓದಲು ಬರೆಯಲು ಬರುವುದಿಲ್ಲ. ನಾನು ಖಾಲಿ ಹಾಳೆಗೆ ಸಹಿ ಮಾಡಿದ್ದೇನೆ. ಸರ್ ಪೊಲೀಸರಲ್ಲಿ ಮಹಾಜರು ಬನ್ನಿ ಕಂಡೆ ಅಂದರೆ ಅಲ್ಲ. ನಾನು ನಿಶಾನೆ P5 ಯಾರು ಬರೆದಿದ್ದಾರೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ, ಆದರೆ ನಾನು ಸಮಕ್ಷ ಬರೆದಿದ್ದಾರೆ, ಹೆಸರು ಗೊತ್ತಿಲ್ಲ. ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ನನ್ನ ಜೊತೆ ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಸಹಿ ಮಾಡಿರ್ತಾರೆ. ನ್ಯಾಯಾಲಯ ಮುಂದಿನ ಆರೋಪಿ ಮೊದಲ ಬಾರಿಗೆ ನೋಡಿದ್ದೇನೆ ಎಂದರೆ ಮೊದಲೇ ಹೌದು, ನಂತರ ಮಹಾಜರು ಮಾಡಿದ ಸದ್ಯ ನೋಡಿದ್ದೇನೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Therefore, inconsistencies, evidences are there. Therefore, some lenient to may be taken.
ಹೇಳಿ. PW 2 and 3. ಇವರೇ ಕಾಪಾಡ್ಬೇಕು. ಡಿಫೆನ್ಸ್ ನುವೆ ಸ್ಟೇಟ್ ನುವೆ ಇಬ್ರು this type of assistance by advocates.
Yes, sir. I requested for a time because I could not get ready. For that reason, morning I requested for a time.
Told. Heard the petitioner counsel and also the counsel appearing for the respondent. This revision petition is filed against the order of conviction for the offense punishment section 457 and also section 380 read with section 34 of IPC. In convicting the revision petitioners by the trial court for the period of 2 years. For the period of 30 months for the offense punishment section 457 and also for the offense 380 for 2 years. And also against the confirmation of the order passed by the trial court in criminal appeal number 30 of 2019 wherein reduce the sentence for a period of 18 months as against 30 months in respect of the offense punishment section 457 of IPC and also 1 year as against 2 years for the offense punishment section 380. The factual matrix of case of prosecution before the trial court that the present revision petitioner along with even accused number 3 na?
Accused number 3.
Present revision petitioner accused number 3 along with other 2 accused persons committed the offense of section 457 and 380 on 7/1/2015 during night hours. In furtherance of their common intention, have lurked the doors of Sri Parvati temple premises and stolen the goddess silver statue weighing about 835 gram worth of rupees 24,500. And immediately when the CW1 noticed the theft of the same, immediately lodged the complaint in terms of exhibit P1. The police have registered the case and apprehended accused persons and recovered the same at the instance of the accused persons in the presence of punch witnesses and drawn the panchanama of recovery and also investigated the matter and filed the charge sheet. The trial court, having received the police report under section 173, secured the accused and accused person did not plead guilty and claims trial. Hence, the prosecution relies upon the evidence of PW 1 to 6. Got marked document exhibit P 1 to 3. And also MOs 1 to 3. And the accused persons were subjected to 313 statement and thereafter not led any defense evidence. The trial court having considered the evidence of PW 1 to 6 comes to the conclusion that recovery is proved and recovery is also at the instance of the petitioners. And there is no scope to suspect the evidence of PW 1 to 6 and the corroboration in their evidence about commission of offense. And recovery is also made and hence convicted and sentenced. Being agreed by the said order, criminal appeal number 30 of 2019 is filed and appellate court also having reassessed the material and record, particularly in paragraph number 12, accepted the reasoning given by the trial court. And also relied upon the voluntary statement of accused persons which have been marked. And comes to the conclusion that it was in the special knowledge of the accused made in their voluntary statement and that the same being not known to anyone, much less the police and the witness, and this trial has rightly comes to the conclusion that the evidence is admissible under section 27 of the Indian Evidence Act and confirm the judgment of the trial court. Being agreed by the concurrent finding, the present revision petition is filed before this court. The main contention of the counsel appearing for the petitioner is that both the courts failed to exercise the jurisdiction and committed an error in convicting and sentencing, believing the evidence of PW 1 to 6. It also fails to take note of the fact that there was lack of evidence so as to convict the petitioner. And witnesses are all interested witnesses, and the very approach of the court is not correct, and there is a inconsistent evidence before the court, and hence it requires interference. For contra, the counsel appearing for the state, HCK would submit that the evidence available on record is consistent. PW 1 spoken with regard to the theft is concerned, and PW 2 to 4 are the witnesses for recovery of stolen article. And both the courts considered the evidence available on record and rightly convicted and sentenced, and appellate court also exercised its discretion in reducing the sentence, and it doesn't require any interference. Having heard the petitioner counsel and also the counsel appearing for the state, and also on perusal of material available on record, and also the grounds urged by the petitioner counsel and also the counsel for the state, the point that would arise for the consideration of this court are whether the trial court and also the appellate court committed an error in accepting the evidence of PW 1 to 6, and whether the order impugned passed by both the courts requires interference of this court exercising the revisional jurisdiction, and whether the order of both the courts suffers from legality and correctness. Next, what order? Having heard the counsel appearing for the petitioner as well as the respondent, and factual matrix of the case of the prosecution is that on 7/1/2025 during the night hours, this accused along with other accused with the common intention have lurked the doors of temple and stolen the goddess silver statue weighing about 835 grams worth rupees 24,500 rupees. In order to substantiate the said case of the prosecution, relied upon the evidence of PW 1 to 6. PW 1 is the complainant. The PW 1 complainant in his evidence and complaint, which is marked as Exhibit P1, says that when he went to do puja in the early morning at 5 o'clock, he found clerking of the temple and committed lurking of the temple and stolen the silver throne of the goddess was worth of rupees 24,500 was stolen, and hence lodged the complaint, and complaint was given at 11 AM. Based on the complaint, police have drawn the measure in terms of exhibit P2, that is the spot measure. The prosecution relies upon exhibit P3 and P4 photographs. And also exhibit P5 is the seizure measure. The spot panchanama is marked as exhibit 5 based on the statement of accused. It is also important to note that the voluntary statement of accused are also marked as exhibit P8, P9, and P10. And also exhibit P11 is the arrest memo having arrested the accused persons. The PW1 is not a material witness, only he had lodged the complaint with regard to lurking of the house and stolen the throne of the goddess. And he speaks only about the police came and conducted the spot measure. He admits regarding delay in lodging the complaint when he comes to know about the same at 5 AM, but complaint was lodged at 11 o'clock. He says he went to station twice and he had signed the same in the station thrice. And he had seen the accused persons on 24/1/2015 at the station. The other material witness is PW2. He speaks only about drawing of measure at the spot, and also identifies photographs exhibit P3 and P4. And also identifies MO3. And he says accused only showed the MO. And he identifies accused number 2. It says accused number 1 and 3 were also there. In the cross-examination, he admits that already several persons were gathered near the place where the seizure was made. And measure was also signed by one Lakshmi Narayan. And police have also not taken any slip on MO 123. The other witness is PW3. He also reiterates that police took his signature at the time of drawing the measure. He also identifies the photographs. In the cross examination also, he says he only signed the document. The other persons have not signed. And he signed the same near the temple. And no specific identification in respect of the MO 123. The other witness is CW4, who also claims to be the witness to the exhibit P5. And police have drawn the measure in terms of exhibit P5. And he also identifies the article. Categorically says that accused persons and police were there at the spot. But he categorically says that when they went to the spot already, the stolen articles were there at the spot. And also he cannot say who kept the same at the spot. But only comes to know that the same belongs to the temple. The other witness is PW5. He is the only a person who had signed the measure near the temple. He is the signatory to exhibit P2. And no special mark was made on the MO 123. The other witness is IO, who has been examined as PW6. And though he says that when after the arresting of accused persons, recovery is made at the instance of the accused persons. He says photographs exhibit P3 and P4 was taken while releasing the stolen article. In the cross-examination, he admits that near the temple there are residential houses. And also he categorically admits that he did not take the signature of neighboring witnesses to the measure. And also he had not put any special mark on the MO 123. And also he categorically admits that he did not take the signature of punch witnesses on MO 123. He also admits that like MO 123 will be available in any of the shop. Having reassessed the both oral and documentary evidence, though this court is not having jurisdiction to reassess the evidence since there is a concurrent finding, but the court is having power to consider the same if any perverse finding given by the trial court and appellate court. It has to be noted that while marking the document of voluntary statement, the trial court marked the entire voluntary statement of accused number 8 to 10. Voluntary statement of accused as exhibit P 8 to 10. And the very procedure adopted for marking of the voluntary statement in the entirety is not permissible. Only portion of the voluntary statement with regard to the recovery is concerned to be marked. But trial court committed an error in marking the voluntary statement in entirety. And there is a flaw in marking the same. and ought to have been marked only the portion of recovery. And even also appellate court relied upon this voluntary statement of accused persons while confirming the order of the trial court. And appellate court also committed an error in relying upon the voluntary statement of accused for conviction. It is also important to note that PW1 is only a complainant, and he went and identified the accused in the police station. No doubt, in terms of Exhibit P11, police who are on gust duty apprehended the accused persons and produced before the IO. And the procedure adopted by the IO is also not secured any punch witnesses to recover the same at the instance of the accused persons, and witnesses who have been examined as PW 2 to 4 also. Categorically, PW 4 says when he went to the spot, already the stolen articles were kept in the spot. And hence it is clear that it is not at the recovery at the instance of the accused. It is also important to note that evidence of PW 2 and 3 also not particular about that accused only led all of them and only showed where they have concealed the stolen article. And recovery is also not in accordance with law. The evidence of PW 2 to 4 also not helps the prosecution, and there is no any legal evidence. And finding of the trial court and also the appellate court that there is a recovery at the instance of the accused is not credible and fails to take note of the evidence available on record when the finding of the trial court is not legal. And also appellate court relied upon the voluntary statement of accused persons for confirming the order of the trial court. Both the order suffers from its legality and correctness, and hence the approach of the trial court and appellate court is erroneous, and the order of the trial court and appellate court suffers from its legal infirmity, and finding is not legal. When such being the case, the revision petitioners are entitled for acquittal, since there is no any legal evidence before the court, and hence it requires interference of this court. In view of the discussions made up, hence I answered the point as affirmative. In view of the discussions made up, I pass the following order. Revision petition is allowed, impugned judgment of conviction is set aside. And consequently, if any fine amount is deposited by the revision petitioners, are ordered to be refunded in favor of them, in favor of the petitioner who is accused number 3 on proper identification. The bail bond executed by this petitioner is cancelled. This stands cancelled.
45.
45, Kalyan Basuraj Ramachandra. Records ಬಂದಂಗಿಲ್ಲ ನೋಡಿ.
Petitioner in this matter, my lord. My lord,
Ready ಇದೀರಾ?
kindly seek an adjournment in this matter, my lord. Senior, due to an inconvenience, senior is not.
Inconvenience. ಸೀನಿಯರ್ಗೆ ನಿಮ್ಗೇನಾಯ್ತು?
My lord, he has to come and argue, argue in full length, my lord.
Check pertaining to
ಸೀನಿಯರ್ಗೆ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ನಿಮ್ಗೇನಾಯ್ತ್ರಿ?
check pertaining to the
Call for records ಆಗಿಲ್ಲ. Call for records and list the matter as soon as records are received. Call for records of both the courts ಅಂತ.
47, Vinay Kirti M.
Vinay Kirti M, Nehru MN. SCR, TCR ಬಂದಿಲ್ಲ. Registry is directed to issue reminder to send the TCR, and as soon as received the same, list the matter for, as soon as received the records, list the matter. 48. ಇದರಲ್ಲಿ ಕಾಲ್ ಫಾರ್ ಆಗಿದೆಯಾ ನೋಡಿ?
For the petitioner, Your Honor.
Hmm.
There has come some medical emergency. There has come some medical emergency in my senior's family.
Medical emergency to whom, madam?
In my senior's family.
Senior counsel.
Yes.
What about you? ಮಾತ್ರ ಆಗಿದೆಯಾ? Have you complied the order? Suspension of sentence. Sorry.
I don't know.
This matter was last listed on 23/9/22. And sentence was suspended. ಏನ್ರಿ ಇದು 138 ಅಂತ? ಬರೀ 25,000. ಏನಿಲ್ಲ ದುಡ್ಡು ಕಟ್ಟಿ ಅಂತ ಬರೀ ಬಾಂಡ್ ಬರ್ಕೊಡಿ ಅಂತಿದೆ ಆರ್ಡರ್ ನಲ್ಲಿ. Suspension of sentence, ಇದೆ 50%. Third, the council is directed to whether order of suspension, conditional order of suspension is complied or not. And in the meanwhile, registry is directed to get the records and list the matter as soon as records are received.
Much obliged.
49, J. Kirti.
A. Kirti MC. Dismissed, forfeited, warrant. LCR ಬಂದಿಲ್ಲಲ್ಲ? ಆರ್ಡರ್ ಆಗಿದೆಯಾ ನೋಡಿ.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಆಗಿತ್ತು, ಅವಾಗ ಆಗಿಲ್ಲ.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಆಗಿತ್ತಾ?
ಆಗಿದೆ ಅಷ್ಟೇ.
R123 ಅಷ್ಟೇ.
R123 is
ಆಯ್ತು.
50.
Call for records and list the matter as soon as records are received. 50 Rudrappa.
I appear for
Pawan
the
Kumar
respondent.
Vayan.
I appear for the respondent. There is a concurrent finding, my lord. I am
Ah.
seeking for release of deposited amount.
These are
Deposited amount, my lord.
application ಹಾಕಿದೀರಾ?
My lord, I am furnishing. My
ನಾವು
lord,
ಈಗ ಆಗ್ತಾ ಇದ್ದೀರಾ?
please.
ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರ ಅದರ್ ಸೈಡ್ ಗೆ?
File objection not.
Sorry, counsel for the respondent files an application for release of the amount and counsel for the petitioner fix time to file objections. List this matter on 28/2.
Obliged.
Obliged.
ನೀವು ಅಲ್ಲೇ ಆಫೀಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಬೆಟರ್. ಬಟ್ ಈಗ ನಾವು ಅವ್ರಿಗೆ ಹೇಳಿದ್ವಿ ನಂಬರಿಂಗ್ ಆಗ್ಬೇಕಲ್ಲ, ಏ ನಂಬರ್ ಆಗ್ಬೇಕು.
Please, my lord, I'll file.
ಮತ್ತೇನಾರು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆಯಾ ಅಂತ ನೋಡ್ಬೇಕು.
ಒಂದ್ ಸಬ್ಮಿಷನ್ ಸುಮ್ ಇದ್ರಲ್ಲಿ ಇವ್ರು ಎಂಪ್ಲಾಯಿ ಇದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಮಾತಾಡಿದೆ.
ಆಯ್ತು
ಅದೊಂದು ಸೆಷನ್ಸ್ ಕೋರ್ಟ್ ಅಮೌಂಟ್ ಏನಿದೆ ಅದನ್ನ ಕೊಡಕ್ ರೆಡಿ ಇದೀವಿ ನಾವು. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಜಾಸ್ತಿ ಆಗಿತ್ತು.
ಆಯ್ತು, ನೀವು ಮಾತನಾಡಿ
ಅದೊಂದು ಅದೊಂದು ಇದು ಮಾಡಿದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ.
ಮಾತನಾಡಿ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಅಲ್ಲೊಂದು ಇದಾಕೊಳ್ಳಿ. The counsel for respondent submits that he is going to file an application for release of the amount and hence directed to file the same in the registry. And copy is also served on the other side and counsel seeks time to file objections and hence list the matter on 28.
Obliged.
ಇಬ್ರು ಮಾತನಾಡ್ಕೊಳ್ಳಿ, ಅವ್ರು ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
Obliged.
28/2. 51 ಅರುಣ್ ಗೋವಿಂದ್ ರಾಜ್, ಗೀತಾ ಮೆನನ್.
Lord, husband's petition seeking revision of the order passed by the sessions court, then appeal filed by the wife, but seeking enhancement of maintenance in a DV proceeding. But may state a few facts, Lord, for your lordship's kind consideration. Lord,
on merits ಮೇಲೆ ಆಗಿರೋದಾ?
ನನಗೆ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿತ್ತು.
ನಾನ್ ಕೇಳ್ತಾ ಇರೋದು ನಿಮ್
Final order.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆನ್ ಫೈನಲ್ ಆರ್ಡರ್.
Final order.
ಫೈನಲ್ ಆರ್ಡರ್.
Final order.
ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಲ್ಲ ಹಾಗಾದ್ರೆ?
ಇಲ್ಲ,
ಬೇಡವಾ?
records may not be necessary. Records may not be necessary. ಯಾಕಂದ್ರೆ ನನಗೆ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿತ್ತು. I had engaged a lawyer. Lawyer appear ಆಗಿಲ್ಲ. And the other side, my lord, despite being aware that I have also filed an appeal, ನನ್ನ appeal pending ಇದೆ. ಇವತ್ತಿಗೂ pending ಇದೆ. Same order passed to DB court, final order ಮೇಲೆ.
Appellate court order ಮೇಲೆ
ಬರೀ appellate court order ಮೇಲೆ ಮಾತ್ರ ಇದೆ. ನಾನು what I'm seeking is remand.
When there were two appeals, only one appeal was considered and other appeal was not considered.
Other appeal was before a different court.
Different court.
In the other.
But copy of the appeal was served, the respondent was aware of the pendency of my appeal against the very same order.
Copy ಯಾವಾಗ ಸರ್ವ್ ಮಾಡಿದ್ರಿ ನೀವು?
6/2/2024. Yes.
16/9/2022.
16/9/20
ಮೆಮೊನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಕಾಪಿ ಸರ್ವ್ ಮಾಡೋಕ್ಕೆ. 16/9/2022.
16/9/2022. Copy was served on the other side.
Copy is served on the other side. Acknowledged.
Which one?
Page number 20. On the criminal petition pending between the same party, B383 of 2022 before this honorable court. ಆ criminal petition ಅಲ್ಲಿ
respondent advocate copy ನ ಇದು?
ಹೌದು.
Criminal petition number 3383.
ಹೌದು.
Received copy of petition ಗೀತಾ ಮೆನನ್ ಅಂತ ಅವರೇ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ.
ಆ ಪಿಟಿಷನ್ ಅಲ್ಲಿ
16/9/22. ಈ ಮ್ಯಾಟರ್ ಡಿಸ್ಪೋಸಲ್ ಆಗಿರೋದು ಯಾವಾಗ?
2023 ಸೆಪ್ಟೆಂಬರ್.
2023 ಸೆಪ್ಟೆಂಬರ್.
2023.
After 1 year.
My lord, one more. The wife files a application, divorce petition pending in the family court which is filed by the petitioner husband. ಅಲ್ಲಿ maintenance application ಆಗ್ತಾರೆ. ಆ maintenance application ಗೆ objection ಆಗ್ತೀನಿ. ಆ objection ಅನ್ನು I clearly avoid copy of on the respondent where I have said I have filed an appeal against the order passed by the magistrate in the DV proceedings and this is the appeal number. My appeal is pending. And before the appellate court, DV case ಅಲ್ಲಿ specific argument by the respondent is they have not filed an appeal. That is recorded by the learned judge. Lordship permits.
Anyhow, I will set aside the order and direct.
Your lordship, I'll
direct the appellate court to consider both the appeals together. That's all.
Your lordship, I'll just point out. My lord, what they serve a copy is out of a infructuous order which was dismissed by the sessions court. Against that, they file a criminal. Because what had happened, my lord, interim order of maintenance was granted by the magistrate court. Against that, the petitioner goes up in appeal against the interim order. The final case is disposed of. After the disposal of the final case, the sessions court says that since the final order has been passed, nothing survives in the criminal appeal and hence that is dismissed. Against that, they file a criminal petition. In the criminal petition, they have served a copy of that criminal petition, not notice in this second appeal. Now, your lordship may see the order sheet.
This acknowledgement is pertaining
To the criminal petition.
Petition number 33.
Filed in the High Court. Yes, my lord. It is not pertaining to the criminal appeal which they say they had filed. 1 minute. Now I did not. 1 minute.
ಅವ್ರು ಹೇಳಕ್ ಬಿಡ್ರಿ ಸ್ವಲ್ಪ.
My lord, your lordship.
ನೀವು ಇಲ್ಲಿ ಹಾಕಿರೋದು criminal petition number 33 of 83 ಅಲ್ವಾ?
Given a copy.
What is the order challenge in criminal petition?
For the interim order passed by the
Trial court. Trial court for maintenance. Yes.
Then your lordship.
Whether this appeal is against the merit, order on merits?
The appeal which was pending, which is now included before your lordship, that appeal copy was produced along with the criminal petition page number 202.
Whatever it may be, counsel.
Appeal file ಮಾಡಿದ್ದು.
Did you bring it to the court notice that one more appeal is pending before the trial court, before the appellate court, against the order of the main matter?
My counsel never appeared before the.
But in ನೀವೀಗೇನ್ ಕೊಟ್ಟಿದ್ದೀರಿ page number 20 ಅಲ್ಲಿ, that is in respect of criminal petition number 3383 of 22.
Yes.
Not in respect of the criminal appeal. Now you said that it was in the knowledge of the respondent that criminal appeal was also filed and copy has been served.
Yes.
But criminal appeal copy has not been served on the other side.
Criminal petition 3383 of 2022, annexure of the criminal appeal I filed, which is now challenged before your lordship, copy of the criminal appeal and also averment with regard to my appeal pending before the appellate court is made, page number 202.
That is in criminal petition only.
Copy is served on the respondent's counsel.
Whether you brought to the notice of the appellate court while disposing of the criminal appeal filed by them, that already you have filed on one appeal.
What happened was the criminal appeal, I was served with notice. I had engaged counsel, Lord. The counsel is not.
Show me any copy of the acknowledgement on the other side, having served the copy that one more appeal was pending before the court. This is with regard to the criminal petition is concerned that you are relying upon.
Page number 202, my lord. In the criminal petition.
Page number?
Page number 202.
You are not answering to my question, counsel.
ನನ್ನ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇರಕ್ಕೆ ಅದು ಅಪೀಲ್ ಕಾಪಿನ ಅವರಿಗೆ ಸರ್ವ್ ಮಾಡಿರಕ್ಕೆ
ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಎಲ್ಲಿದೆ ಅಂತ, ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ just now I brought your lordship's notice the memo acknowledged by the learned counsel for having received the criminal petition number 3383.
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಆಯ್ತ್ರಿ, ಬಟ್ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಇದೆ ಅಂತ ತೋರ್ಸಕ್ ಎಲ್ಲಿದೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್? ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಬಿಟ್ಬಿಡ್ರಿ, ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಕಾಪಿ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿರೋದು ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು.
ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅದು ನೋಡಿ ಸರ್ವಿಸ್ ಆಗೇ ಇಲ್ಲ ಅವರು. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿದೆ, ಅವ್ರ ಅಪೀಲ್ ಡಿಸ್ಪೋಸ್ ಆದ್ಮೇಲೆ ನಮ್ಮ ಅಪೀಲ್ ಸರ್ವಿಸ್ ಆಗಿದೆ ಡೈರೆಕ್ಟ್ ಕೋರ್ಟ್ ಇಂದ. ಬಟ್ ವೈಲ್ ಮೈ ಅಪೀಲ್ ವಾಸ್ ಪೆಂಡಿಂಗ್.
But at the time of disposal by the appellate court,
yes,
your appeal was pending or not?
Pending.
Have you served the copy on the other side or not?
They were not served.
Then how can you find a fault with now?
In other proceedings, not in other proceedings, in the very same parties, copy has been served and it's also not being brought to the court.
No, unless notice has been ordered in criminal appeal, how can they bring it to the court?
In my
Please.
notice was served upon them only after the disposal of their appeal. But while my appeal was pending, while their appeal was also pending, in other proceedings between the very same parties, I have pleaded that my appeal is pending. the copy is served.
In their appeal, have you represented or not?
Yes,
Why?
yes, I have.
I have also produced the document.
Well, why you are not represented?
Lawyer engage ಮಾಡಿ ವಕಾಲತ್ at that time I was staying in Haryana. Lawyer engage ಮಾಡಿ ವಕಾಲತ್ ಕಳಿಸ್ತೀನಿ. I have also produced a correspondence between me and my lawyer.
Whether your client has filed wakalat in that case or not?
Wakalat was sent to the lawyer, but not after because of COVID, but not the lawyer is not
You
appeared.
are not answering to my question, counsel.
ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿ.
ಮತ್ತೆ
ವಕಾಲತ್ ಫೈಲ್.
ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಕೋರ್ಟಿಗೆ ಏನ್ ಕನ್ಸ ಬೀಳ್ತದೆ ನೀವು ಒಂದು ಅಪೀಲ್ ಹಾಕಿದಿರಿ ಅಂತ?
I have engaged the lawyer, Lord. The lawyer is not appeared. I produced the.
You take action against the advocate. ಮತ್ತೆ?
I will take action, Lord, but.
I cannot find fault with the trial court in appellate court in disposal of the matter when the same was not within the knowledge of the judge. If it is within the knowledge of the judge that there were two appeals, it is bound and duty of the appellate court judge to dispose of the matter together. Now how can you find fault with them?
For one moment, I'm not even suggesting that the appellate court fell into error while passing the order. All I'm saying, the respondent who was aware of my pendency of my appeal has gone before the appellate court and said, I have not filed an appeal. That finding is recorded with the learned appellate court.
Counsel, while disposing of appeal by the appellate court, notice was ordered and the same was served on you. If any mistake committed by your advocate, you take action against the advocate. How can you find fault with the respondent and also the trial court?
The respondent, despite being aware of pendency of my appeal against the very same order, my lord, has gone before the appellate court and my lord made a statement.
You only said that in your appeal, no notice was served on the other side.
My lord, the MC case, Lord.
May I pass the order sheet of their appeal, my lord? Your lordship, may see the conduct. No process fees paid for 2 years to serve the notice.
After
No
filing of an appeal.
After filing of the appeal, from your lordship may see from 6/1/20.
ಇಲ್ಲೂ ನಾವು ನೋಡ್ತಾ ಇರ್ತೀವಿ 4-5 ವರ್ಷ ಹಂಗೆ ಬಿದ್ದಿರ್ತೀವಿ.
6/1/21 till 1 minute, 1/6/1/21 till 12/6/22, they don't pay process fee. Then they pay process fee on 23/7/2022.
PF and RPID not furnished ಅಂತ ಬರೀ
Then 12/9/22 onwards, there is no representation from the counsel for the appellant. My lord, thereafter, my lord, court notice is issued to the appellant and the appellant's counsel, none appears. Then finally, my lord, on 6/2/24, my learned friend appears filing NOC and then serves the copy of notice on me. This is the conduct of their appeal. Even in the first, against the order in the revision, in the first criminal petition, they don't appear before the court at all.
2019 in the 23 ವರೆಗೆ no steps at all. No representation, no steps. No steps. Now you are finding fault with the court and also the.
Then one more, I would like to draw your lordship's attention to one more page. Yes.
Kindly see page 211. An application for maintenance filed by the wife in an MC that I have filed before the family court. On 10/6/2022, one of the application is filed IA number 3. Page number 211. Is the application filed by the wife, not the date is available 10/6/2022. Not my objection, page number 216.
MC.
Not on paragraph number 2, if the lordship permits me. The petitioner submits that the respondent who had earlier filed a false and concocted petition under section 12 of the Domestic Violence Act in CMS 164 of 2013 by claiming monthly maintenance and other allowances, including compensation, etc. Accordingly, respondent was awarded 10,000 rupees per month by its order dated 30.
ಸರಿ ರೀ, ನೀವು ನಾನ್ ನೋಡ್ತಾ ಇದೀವಿ ಲಾಯರ್ಗಳ ಕೇಸ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇದ್ದಾಗಲೇ ಓದ್ಕೊ ಬರಲ್ಲ. ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದು ನಾವು ಓದಿದಾರೆ ಅನ್ನೋದು ನಾವೇನ್ ಪ್ರಿಸ್ಯೂಮ್ ಮಾಡ್ಕೊಳಕ್ಕಾಗುತ್ತೆ? ಮೇ ಬಿ ಯು ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ವೇರ್ ಇನ್ ಯು ಹ್ಯಾವ್ ನರೇಟೆಡ್ the filing of the criminal appeal.
Yes.
How many of them advocates read the objections? Only at the time of argument. ಅದು ಏನಾರು ಓದ್ಕೊ ಬಂದ್ರೆ ಪರವಾಗಿಲ್ಲ, ಪುಣ್ಯಕ್ಕೆ ಅವ್ನ ಕ್ಲೈಂಟಿನ.
Page number 202. But not only that,
ಮತ್ತೆ
Your lordship may turn to page 172.
Paragraph number 10.
ಈಗಲೇ ಒಂದು ಈ ಹಿಂದೆ ಒಂದು ಡಿಸ್ಪೋಸ್ ಮಾಡಿದೆ ನೋಡಿದ್ರಲ್ಲ, ಯಾವ ಅಸಿಸ್ಟೆನ್ಸ್ ವಾಟ್ ದಿ ಕೋರ್ಟ್ got ಅಂತ ಡಿಸ್ಪೋಸಲ್ ಮಾಡುವಾಗ, both the revision petitioner and also the counsel for the state. Unfortunate. If I have not taken pain while reading the papers. An injustice will cause to the client who having the belief that his counsel will protect his interest.
Unfortunately, not there.
May I draw your lordship's attention to page one seventy-two?
This statement of objection was filed on what date?
Not
In data ಇಲ್ಲ ನಿಮ್ದ್ರಲ್ಲಿ?
ಇಲ್ಲ, date ಇಲ್ಲ.
Date ಹಾಕಿಲ್ಲ ನೋಡುವಾಗ certified copy.
7/9/2022.
But ಇಲ್ಲಿಲ್ಲ.
But 7/9/2022. In the date on which the objection statement is filed. ಇದು ಅಪೀಲ್ ಡಿಸ್ಪೋಸ್ ಆಗಿರೋದು 11/9/2023 ಒಂದು ವರ್ಷದ ನಂತರ. Page number 202. Not I can only not.
ಹೋಗಿ ಕಾಪಿ ಶುರು ಮಾಡಿದಿರ ಅದರ್ ಸೈಡ್ ಗೆ?
Page number 202.
ಅಲ್ಲ ಇದ್ರದ್ದು ಈಗ
Appeal ಇಲ್ಲ.
ಹಾಕಿದಿರಿ ನೀವು objections ಹಾಕಿದಿರಿ.
Appeal copy is not served. Appeal copy was not.
10/6/22 ಅಂತ ಇದೆ.
Appeal copy, no, appeal copy is not served.
Maintenance application objections.
MC ನಲ್ಲಿ objections ಹಾಕ್ತವ್ರು ಯಾರು? ಅವ್ರ objection ಇದು?
7/9/2022. ಗಂಡ ಹಾಕಿ.
ಡೇಟ್ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ?
7/9/2022.
ಏನಾಗಿದೆ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕನ್ಫರ್ಮ್?
Now your lordship may just one.
TV court ಅಲ್ಲಿ 10,000 ರೂಪಾಯಿ magistrate has awarded 10,000 rupees. The wife in an appellate proceeding files an affidavit of assets and liabilities. ಗಂಡಿಗೆ 65 ಲಕ್ಷ ಇನ್ಕಮ್ ಇದೆ. ಅವ್ರ ಅಪೀಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಏನಾಯ್ತು ಹೇಳ್ರಿ ಅಪೀಲ್ ಅಲ್ಲಿ?
40,000 ರೂಪಾಯಿ ಮೇಂಟೆನೆನ್ಸ್.
10,000 ಇದ್ದಲ್ಲಿ 40,000 ಆಗಿದೆ.
ಮೇಂಟೆನೆನ್ಸ್ 23,000 ರೆಂಟ್ ಪ್ಲಸ್ ಕಾಂಪನ್ಸೇಷನ್ 5 ಲಕ್ಷ ಇದನ್ನ.
ನಾನು ನೋಟ್ಸ್ ಮಾಡಿದ್ದೀನಿ 23,000 ರೆಂಟ್ಗೆ ಅಕಾಮಡೇಷನ್ಗೆ.
40,000 ರೂಪಾಯಿ ಮೇಂಟೆನೆನ್ಸ್ ಪ್ಲಸ್ 10,000 ರೂಪಾಯಿ 10 ಲಕ್ಷ ರೂಪಾಯಿ ಕಾಂಪನ್ಸೇಷನ್ ಅಂತ ಅವಾರ್ಡ್ ಆಗಿದೆ.
ಆಯ್ತು.
As against 10,000 rupees award by the magistrate and 5 lakhs as compensation.
10 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ.
10 ಲಕ್ಷ 5 ಲಕ್ಷ ಕಾಂಪನ್ಸೇಷನ್.
5ಕ್ಕೆ 10 ಲಕ್ಷ ಮಾಡಿದ್ದಾರೆ ಅವರು.
ಹೌದು. 63,000 ರೂಪಾಯಿ.
I could recollect my memory when I was reading the papers. That was the order. ನೋಟ್ಸ್ ಮಾಡಿದ್ದೀನಿ. ಆಯ್ತು ಈಗ ಟೈಮ್ ಬೌಂಡ್ ಮಾಡ್ತೀನಿ. ಎರಡು ಕನ್ಸಿಡರ್ ಮಾಡ್ಲಿ ಒಟ್ಟಿಗೆ.
Let them deposit at least.
Was the cost on you for not assisting the court?
I'll just draw your lordship's attention to page 172, my lord. This is the order sheet in my appeal which I had filed, 172. That is the order sheet of the appellate court.
172.
Yes, my lord.
172 of?
The appeal memorandum filed by them.
Filed by them.
Yes, my lord.
172.
This is in my appeal, which was the orders.
172.
Your lordship may see the last paragraph, or that is dated 3/1/2022. Their counsel appears. No mention is made that there is a pen.
Called out advocate for appellant absent.
Advocate for respondent present. Even in 2022, they don't bring it to the notice of the court.
No requisition filed to hear arguments through EC.
So therefore, my lord, to say that from 2020 there no representation is a wrong statement. My lord, even that 10,000 which was ordered has not been paid up to date.
This appeal of?
This is my appeal against which this order revision is now filed.
Absent advocate for respondent present.
Present. In 2022, they can't say from 2020 there is no representation of their counsel.
Maybe wrong because in the
Not appeared.
No, he has appeared.
order sheet sees respondent absent anta ಬಂದಿದೆ.
Respondent party is absent, my lord. They say whenever parties are absent.
Counsel also not on record.
Counsel-
If counsel on record, initial would have been shown in the order sheet. But respondent absent only. In your appeal. Respondent absent. For submission of arguments on merits.
My lord, my only
Called out-
submission is my lord.
One second,
Yes.
called out both parties and there are arguments. Both parties and their advocates are absent. Then whether the advocate was on record. Issue notice to the respondent and call for LCR. Reissue notice.
23/3/2020, respondent called out absent for appearance of respondent. Therefore, Vakal is not filed.
Here. Notice received. Served on the father. In view of the closure of so-and-so case is not listed today, SOP. Case called out both parties and their advocates are absent. That is wrong, advocate when he has not filed wakalat. Both sides on merits. And also appellate court committed a mistake, madam, here. How can the court make an entry that both parties are absent and both counsels are absent
There-
unless advocate is filed wakalat for the
Because the respondent was served, so their court has.
anyhow,
My lord, that is one aspect of it,
the
my lord.
court decide the.
My lord,
both
one
the
aspect
appeals
of it is, my lord, the, even the 10,000 which was ordered by the magistrate, till date, they have not paid the arrears. Arrears are almost 7 to 8 lakhs. They don't pay that. Then, my lord, they keep dragging, they avoid service in the recovery proceedings.
First, I will see that we let them pay the amount of.
Yes, let them deposit the entire balance as per the DV court order, and then
10,000 ಪ್ರಕಾರ ಕಟ್ಟಿದಿರೇನ್ರಿ ಹೋಗ್ಲಿ?
3 lakhs in the first petition as on 2021, and now
Compensation, 10,000 ರೂಪಾಯಿ maintenance back. That was what was charged.
10,000 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ದೀರಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಇಲ್ಲ,
ಅಲ್ಲಿ?
full ಕಟ್ಟಿಲ್ಲ.
10,000 ರೂಪಾಯಿ ಪ್ರತಿ ತಿಂಗಳು
ಇಲ್ಲ.
6,30,000 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ದೀವಿ ಸರ್. ಇದರಲ್ಲಿ
6 ಲಕ್ಷದ
30,000 ರೂಪಾಯಿ ಕಟ್ಟಿದ್ದೀವಿ.
10,000 ರೂಪಾಯಿ ಆರ್ಡರ್ ಆಗಿರೋದು ಯಾವ ಡೇಟ್?
2019.
2019.
19 ಎಷ್ಟಾಗುತ್ತೆ ಇಲ್ಲಿವರೆಗೆ ಆಸ್ ಆನ್ ಟುಡೇ?
Uh,
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಓನ್ಲಿ 10,000?
Yes.
ರೆಂಟ್ ಗೆ
ಇಲ್ಲ,
ಏನಾದ್ರು ಮಾಡಿದಾರಾ?
rent,
ಇಲ್ಲ 10,000 ಇಲ್ಲಿವರೆಗೂ ಕಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ, they have not.
ಬಾಕಿ ಇದೆ 5 ಲಕ್ಷ compensation. That is what was challenged before the in the appellate.
ಕಾಂಪನ್ಸೇಷನ್ ಡಿಸೈಡ್ ಮಾಡೋಣ. ಫಸ್ಟ್ ಮೇಂಟೆನೆನ್ಸ್ 10,000 ಕಟ್ಟಿದ್ದೀರಾ? ಹೇಳಿ. How much you have received, madam?
My lord, as of now, my lord, they are due, they have paid 6,30,000, which is as of 2021. My lord, thereafter from 21 to 25, that at the rate of 10,000, nothing is paid.
You file a memo of calculation.
Yes, my lord.
At the rate of rupees 10,000. Let them also file. Memo of calculation ಹಾಕ್ರಿ ನೋಡೋಣ.
₹90,000 is what is it?
No,
ಈಗ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಹಾಕಿ ನೀವು. ಎಷ್ಟು
5 years, it
ಕಟ್ಟಿದ್ದೀರಿ
can't
ಅಂತ
be
ಗೊತ್ತಾಗ್ತದೆ. ಇಬ್ರು
90,000.
ಹಾಕಿ. I will give you 2 days time. Then I will consider this.
your
matter.
lordship may have it on 4th of March, my lord, because 2 days now, I'm not in station from tomorrow, my lord. That's why my person.
Tomorrow onwards.
Yes, till
Ah.
3rd of March. Your lordship may have it on 4th, my lord,
Otherwise-
because the case in the trial,
Otherwise, I will dispose of this matter with a direction to
but let
deposit
them
the
deposit the entire arrears.
entire amount.
Except
Yes.
the compensation.
No compensation, because my lord, rents also was not given, which we had asked for. And 23,100 is on the basis of the rental agreement when both of them were staying together. He leaves the house, tells the landlord, I'll find her an alternate accommodation. Eviction order is passed, recovery amount is passed. He remains ex parte throughout in all those
Your
proceedings.
lordship kind of the memo I have filed today. So your lordship kind of
ಏನ್ ಹೇಳಿ ಮೆಮೋ? What is that
page
memo?
number 21. So it is not a person who requires maintenance or not page number ಇವತ್ತು ಹಾಕಿರೋ memo ಅಲ್ಲಿ.
Her mother sent
Page
money
number
from Russia.
21, 22, 20, and this is of 2022, all these photographs.
ಆಯ್ತು.
She is working at the DJ in Goa.
No.
Page number 20, 21, 22, 23, 24. 25.
I'll also produce documents, my lord.
She is a person, a destitute woman who has no money to have.
ಆಮೇಲೆ ಅದಾದ್ಮೇಲೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ. You both go and
I have also produced
Best
documents to
material
show,
for the trial.
my lord,
The rate of 10,000 rupees per month, I will deposit whatever.
let the compensation be also deposited. 5 lakhs, no, 5 lakhs. My lord, because from,
But there is an order of 5 lakhs.
Yes.
I will direct you to pay half of the amount. Let the appellate court decide on the same. You pay out of 5 lakhs, you pay 2.5 lakh. With
And the
regard to
entire
the
arrears.
compensation is concerned. And also pay an amount of rupees 10,000 each from the date of order. Remaining issue will be considered by the appellate court. That's all. Let the appellate court decide.
Unless even I succeed in the appeal, then I would have.
I three, even if you succeeds in the appeal before the trial court, I will pass an order to adjust the amount. ಆಗ್ಬೋದಾ?
2 ಲಕ್ಷ ಬಂದ dispose ಮಾಡೋದು ಬೇಡ ಸುಮಿತ್. That's only request.
ನಾನು ಅಪೀಲ್ ಡಿಸ್ಪೋಸಲ್ಗೆನೆ ಒಂದು ಟೈಮ್ ಬೌಂಡ್ ಲಿಮಿಟ್ ಕೊಡ್ತೀನಿ. ದಟ್ಸ್ ಆಲ್. ತೊಗೊಳ್ಳಿ.
And clubbing of both the ಬೇರೆ ಬೇರೆ ಕೋರ್ಟ್. ಬೇರೆ ಬೇರೆ ಕೋರ್ಟ್ ಇದೆ appeal.
ಕ್ಲಬ್ಬಿಂಗ್ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಈಗ.
Obliged.
ತೊಗೊಳ್ಳಿ ಮೇಡಮ್. Serial number 51 ಅಲ್ಲ? Heard the revision petitioner counsel and also the counsel appearing for the respondent. This revision is filed against the order of the appellate court. And of counsel would contend that the appellate court disposed of the matter. And even when the appeal filed by the revision petitioner was also pending in other court and did not bring it to the court notice. at the time of the disposal. The council also filed memo along with copy of the acknowledgement having served the copy of criminal petition number 3383 of 22. And the same is not in respect of the appeal filed by the appellant. Copy was served on the other side. However, the council relies upon in the statement of objections, filing of appeal was pending before the court has been mentioned in the same. As against this submission, counsel for the respondent also brought to notice of this court that though the appeal filed by the revision petitioner from 2019, PF was not paid and steps was not taken. Only after the disposal of the appeal by the respondent, notice was served and hence cannot find fault with the respondent as well as the court. Having perused the order sheet of the appellate court also, wherein notice has been served on the revision petitioner and his father, but he was unrepresented. However, the appellate court taken note of both parties are absent and counsels are absent. And when the counsel has not filed the wakalat, question of appearance also doesn't arise. However, taking into note of when the two appeals are pending before the appellate court for consideration of the impugned order passed by the trial court ought to have been considered together. And this revision petitioner also did not bring it to the court notice, and also it was not within the knowledge of the appellate court. And also order sheet discloses that although the appeal was filed in 2019, steps were not taken in the appeal filed by him and kept on continuation of the proceedings without taking steps. And after the disposal of the appeal, only the present revision petition is filed. Having taken note of the said fact into consideration, when two appeals are pending before the court, though it was not within the knowledge of the appellate court, and both the parties have not brought to the notice of the trial court. However, the matter was disposed of on merits. And having taken note of the said fact into consideration, it is appropriate to direct the trial court by setting aside the order of the appellate court. And the principal district and session judge is directed to transfer both the case to the same court. Criminal appeals kodi eradu.
Criminal appeal 2451 of 2019.
2451 of 2019 filed by you na, filed by the revision petitioner.
And criminal appeal 2524 of 2019.
2524 of 19 filed by the respondent to be placed before the same judge, and both the appeals could be considered together on merits. Having taken note of the conduct of the petitioner, even though appeal was filed in the year 2019, notice was not served on the respondent, and hence it is appropriate to impose a cost of rupees 50,000, and the same is payable to the respondent within 2 weeks from today. The parties are directed to appear before the particular court. Otherwise, I will pass an order to post the same before the very same judge who have already decided.
Yes, my lord.
Other file.
Because it will take time on the administrative side.
That is the reason. Directed to appear before the court of CCH 64, and the principal district judge is directed to place the other appeal before the very same court to consider the same, and both parties to appear before the appellate court on
After 10th, any date.
after 10th.
Any date.
Appear before the trial court on 11th of March 2025. The revision petitioner is also directed to pay the amount of rupees 10,000 awarded by the trial court from the date of application till today. Till today, and also pay the 50% of the amount of compensation awarded by the trial court, that is 2.5 lakh out of 5.5 lakhs.
Out of 5 lakhs.
Out of 5 lakhs.
Yes, because
50%, that is
Your lordship
2.5
said
lakh.
5.5 lakhs.
Out of 5 lakhs. Out of 5 lakhs. Within 4 weeks from today. Within 4 weeks from today. That's all. With this observation, this revision petition is disposed of. I'll mail set aside antide.
Your lordship,
Setting
it's
aside
a
the order of the
time
trial court. Huh?
Time frame
Oh,
to be disposed.
time frame. The appellate court is also directed to dispose of the matter within 45 days from 11th March 2025. ಅವತ್ತಿಂದ 45 ದಿವಸ. ಹಾ.
ನಾವು ಹೇಳಿದ್ರಿ some date of application, the judgment is some date of order ಅಂತ ಇದೆ.
ತಪ್ಪದು.
Yes,
ಅವ್ರ ಹಂಗ್
as per
ಮಾಡಿದ್ರು
the
ತಪ್ಪು.
Supreme Court is-
ಕಾನೂನು ಹೇಳೋದು from the date of application.
Intermediate was being paid in terms of the order of this honorable court, 8,000 rupees was being paid during the pendency of the petition proceedings. So
Hmm.
disposal date ಇಂದ 10,000 ರೂಪಾಯಿ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ.
ಅಲ್ಲ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ ಇಂಟ್ರಿಮ್ ಏನಾಗಿದೆಯೋ ಅದು ಲೆಕ್ಕಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಅದು ಓನ್ಲಿ ಇಂಟ್ರಿಮ್ ಅರೇಂಜ್ಮೆಂಟ್ಸ್ ಅಷ್ಟೇ. ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್ ಬರೋದು ಮೇನ್ ಪಿಟಿಷನ್. ದಟ್ ಈಸ್ ದ ಲಾ. ಸೆಟ್ಲ್ಡ್ ಲಾ.
Already paid 8,000, that means
ಇಲ್ಲೊಂದು ಸೆಂಟೆನ್ಸ್ ಹಾಕ್ಬಿಡಿ. ದ ಅಮೌಂಟ್ ವಾಟ್ ಎವರ್ ಪೇಯ್ಡ್ ಬೈ ದಿ ರಿವಿಷನ್ ಪಿಟಿಷನರ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡಿಡಕ್ಟೆಡ್
Yes.
ಇನ್ ದಿ ಟೋಟಲ್ ಅಮೌಂಟ್.
like
52. VB Ravishankar.
Warnings. ಲಾಸ್ಟ್ ಟೈಮ್ ಕಾಲ್ ಪರ್ ಆಗಿತ್ತು.
ಕಾಲ್ ಆಗಿದೆ ಇನ್ನ ಬಂದಿಲ್ಲ.
ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 52 ತಗೊಳ್ಳಿ. Registry is directed to issue reminder to get the records.
Malada, one submission Malada permitted to file the application for release the deposit.
Amount release
Oh.
officer lucky.
Please.
The respondent is permitted to file an application for release of the amount in the registry.
Next week alone date.
Huh?
Next week al Bengaluru there. Date.
Bangalore issue reminder and list this matter on 10/3 ಅಂತ ಹಾಕ್ಬಿಡಿ.
Please.
53 Arjun.
53 ಅರ್ಜನ್ ಆಗಿದೆ. 54 ಇದು ಸೀರೀಸ್ ಆಫ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ. ನೋಟ್ಸ್ ಕೊಡಿ. ಅದರ್ ಡೇ ಯಾರ್ಯಾರು ಸಬ್ಮಿಷನ್ ಮಾಡಿಲ್ಲ ಅವ್ರು ಕೊಡಿ. ಚಾರ್ಟ್ ಕೊಡಿ. ಈಗ ಅಮೆಂಡೆಡ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? ಅದನ್ನ ವಾಪಸ್ ಕೊಡೋಣವಾ? ಕೊಡಿ ತೊಗೊಳ್ಳಿ. ಮತ್ತೆ ಅವತ್ತೇನೋ ಒಂದು ಕೊಟ್ಟಿದ್ರು ನೋಡಿ. ಇಲ್ಲ ಅದನ್ನು ರೆಕಾರ್ಡಿಗೆ ತಗೊಳ್ಳಿ. ಬಟ್ ಕೊಡಿ. ಅದೇನ್ ಕೊಟ್ರ ನೀವು? ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಚಂದ್ರಶೇಖರ್ ಫೈಲ್ಸ್ fresh shot and the same is taken on record. Niva counsel Sri Vijay Kumar also filed the charter. Is statement filed by ಅದ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕೆಲವರು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಿ. ಆಯ್ತು, ಅದನ್ನ ಫೈಲ್ಡ್ ಅದಿ ಚಾರ್ಟ್ ಅಂತ ಹಾಕ್ಬಿಡಿ. ಸಪರೇಟ್ ಚಾರ್ಟ್. ನೆಕ್ಸ್ಟ್ ಇನ್ಯಾರು? Charges already been framed. ಆಯ್ತು, ನಿಮ್ಮ ಹೆಸರೇನು ಹೇಳಿ? ಕೌನ್ಸಿಲ್ ನೇಮ್. PM Gopi also files a memo along with details of charges have been framed. ಮೂರಾಯ್ತು. ನೆಕ್ಸ್ಟ್ ಈಗ ಅಡ್ವೊಕೇಟ್ ಯಾರು ಮೊನ್ನೆ ಟೈಮ್ ತಗೊಂಡವ್ರು ಹೇಳ್ತೀವಿ, ಬೇರೆಯವ್ರೇನ ತಗೊಂಡ್ರಲ್ಲ? 1 2 3 4 5.
I will be filing in due course, another 5 minutes.
ಆಯ್ತು. ಏನ್ ಚಾರ್ಟಾ? ಹೌದು, ಆಯ್ತು, ಪರವಾಗಿಲ್ಲ. ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹೇಳೋರು ಯಾರು ಹೇಳಿ ಇದ್ರಲ್ಲಿ? ಮೊನ್ನೆ ಯಾರ್ದು ಕಂಪ್ಲೀಟ್? ಈಗ ವಿಜಯ್ ಕುಮಾರ್ ಅವ್ರ ನಿಮ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆಯಾ?
10 minutes.
ಹೇಳಿ ಯಾವ್ದು 65 ಪಾಯಿಂಟ್ ಹೇಳ್ಬಿಡಿ ಯಾವ್ದು ಅಂತ.
Now I am addressing the argument in
ಓ ಅದರ್ ಡೇ ಸ್ವರೂಪಾನಂದ ಏನೋ ಕಮೆಂಟ್ಸ್ ಮಾಡಿದ್ರಲ್ಲ.
Yes.
hearing for
ಹಾ ಹಾ
the short accommodation.
ಅಕಾಮಡೇಷನ್ ಯಾವ್ದು ಇಲ್ಲ ಪಾರ್ಟ್ ಅಲ್ಲಿ. ಪಾರ್ಟ್ ಅಲ್ಲಿ ಅಕಾಮಡೇಷನ್ ಯಾವ್ದು ಇಲ್ಲ.
Some inconvenience, my lord, not accommodation.
ಎಷ್ಟ್ ಕೇಳಿದೀನೋ ಅಷ್ಟೇ ಹರ್ಡ್ ಅಂತ ತಗೊಳ್ತೀನಿ ಅಷ್ಟೇ. ಇಫ್ ದಿಸ್ ಇಸ್ ದಿ
One small
ನೋ
accommodation.
ಕೌನ್ಸಿಲ್ ದಟ್ಸ್ ಆಲ್. ಆಯ್ತು ನೀವು ವಿಜಯ್ ಕುಮಾರ್ ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳಿಲ್ಲ ಹೇಳಿ.
54.51.
54.51
And 54.13. Then 54.88.
54.51 54.13
13.
ಹಾ
And 54.88.
88 ಹಾ
Along with, my lord, the criminal revision petition which is not listed today, my lord, is 116 of 2025. Why I have
ನಾಟ್ ಲಿಸ್ಟೆಡ್ ಅಂದ್ರೆ ಅದ್ಯಾಕೆ ಈಗ
it is not listed, I don't know.
ಆಲ್ರೆಡಿ ಇದ್ರ ಜೊತೆ ಪೋಸ್ಟ್ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ದೆ.
Take wakalat,
ಹಾ
it is non-compliance.
ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆದ್ರೆ ಈಗ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ ಅದಾವೆಲ್ಲ ಆಮೇಲೆ ಒಂದು ಸೆಟ್ ಆಫ್ ಇದಾವ ಆಮೇಲೆ ಅದನ್ನ ನೋಡೋಣ.
Please, then
ಈಗ ಇರೋದ್ ಮಾತ್ರ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿರೋದ್ ಮಾತ್ರ ಹೇಳಿ.
these three, this one, my lord,
ಹಾ
along with, my lord, 54.25,
ಹಾ
54.26.
ಅಲ್ಲ ಈಗ ಆಲ್ರೆಡಿ ಹೇಳಿದಿರಲ್ಲ ಅದ್ರಲ್ಲೆಲ್ಲ ಹೇಳಿಲ್ವಾ?
ಇದು
ಈಗ
ಹೇಳಿಲ್ಲ.
ಈಗ ಹೇಳ್ತೀರಾ ಇದು 54.25 ಹಾ
54.26,
26
54.58,
58
54.60,
ಹಾ
54.72.
72 ಮೊನ್ನೆ ಹೇಳಿರೋದು ಅಲ್ದಲ್ಲೇ.
ಇದು
ಹಾ.
ಅದು ಬಿಟ್ಟು ಇದು.
ಆಯ್ತು ಹಾ
Today what I am addressing is in respect of those two.
ದೀಸ್ ಕೇಸಸ್.
Yes.
ಹಾ
So these two employees, not one, Basuraj, M. Basuraj.
Hmm.
The accused number 7 in special case number 120 of 21, my lord, that is criminal revision petition 1014 of 24.
ಹ್ಮ್
He is accused number 7.
ಹ್ಮ್
But it was, he had filed a discharge application. In all these three cases, my lord, he had filed a discharge applications,
ಫಸ್ಟ್ 3 ಅಲ್ಲಿ
first three,
ಹಾ
including the one which is not listed.
ಹಾ
So all these three cases, my lord, the discharge application was heard.
ಹಾ
It was his specific contention before the trial court that he was not working as a technical assistant at the relevant point of time.
ಹ್ಮ್
And in the charge sheet, my lord, it was shown that he was working as a technical.
ಟೆಕ್ನಿಕಲ್ ಅಸಿಸ್ಟೆಂಟ್ ಹಾ
That was brought to the notice of the trial court.
Huh.
Trial court has considered that same.
Huh.
But before any order could be passed on the discharge application, in lieu of the order passed by the coordinate which are report in the petitions, not yet there is a sanction or not obtained. In lieu of the order passed on that, the trial court did not pass any order on the.
ಆನ್ ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ನಾಟ್ ಪಾಸ್ಟ್ ಎನಿ ಆರ್ಡರ್.
He said, the discharge application orders will also be included in the main order.
ಈ ದಿಸ್ ಆರ್ಡರ್ ಅಂತ ಇಂಪ್ಯೂರ್ಡ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಹಾ ಹಾ
Ah. The rate specific condition that you are not working at the level of legal estate.
ಹಾ
Secondly, Murad, no sanction or prosecution has been obtained under 187 against this person.
ಹಾ ಹಾ
In respect of the other persons also, not sanction under 187 has not been obtained.
ಹ್ಮ್
That is the other list, not 4.252658
ಹಾ 252658
4.25
ಹಾ
2658 6070.
ನೋ ಸ್ಯಾಂಕ್ಷನ್. ಹ್ಮ್
No sanction has been obtained.
ಹ್ಮ್
These two are presently working in the corporation and not taking sanction of prosecution, not a charging.
ಹ್ಮ್
The specific condition raised even in the discharge application also by the patient,
Hmm.
the respondents.
ಹ್ಮ್
And that has not been considered and therefore not entitled for, not at least the sanction has not been obtained, even assuming that they obtained the sanction or not, and even asking us to follow the criminal petition. But they are entitled to file a discharge application before the
ಹ್ಮ್
trial court.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹ್ಮ್
The cases where the Basuraj is being added as a respondent.
ಹ್ಮ್
I have only filed discharge application in 4 cases. But in respect of other cases also, I was about to file another, at that time the discharge, the trial court has passed the discharge.
ಹ್ಮ್
Therefore, not my legal for filing a discharge has to be affected. And secondly, the revision, the sanction of prosecution has not been obtained, but that has to be not, the ground for, and the not maintainability of the legal revision.
ಹ್ಮ್
Finally, statement one is authorized. there is sanction to petition, not both under the section 19 and
Yes.
187 of CRPC.
Section 19 for PC Act and the IPC offences is 197. Kodi. That's all. Next, share. Bekailla. We'll make general remarks in the order itself. In case if this court comes to a conclusion that revisions to be allowed, then liberty will be given them to consider the application of discharge application and pass an order. That can be, observation can be made. Yes. Yes.
Statement showing where sanction is not in the state.
Yes, Savannah.
All these cases is
No sanction, huh?
sanction. It's a one murder system of
Kodi. Right.
Serial number 54.18.
54. 18. 52.
Yes.
In
both the cases, my lord, respondent is serial number 4.
On
the reloader. It's a contract. It's a contractor. And when the next serial counsels are already argued the matter, it's composed the same thing. When taken it as adopted the same.
ನಿಮಗೆ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ರಶ್ನೆ ಬರಲ್ಲ, ಓನ್ಲಿ ಅದರ್ ಗ್ರೌಂಡ್ಸ್. 54.9 9 and 10 ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ಹೇಳ್ಬಿಡಿ. ಪದ್ಮಾ ಪ್ರಸಾದ್. In only 2 cases you are ಯಾವ್ದು ಅದ್ನ ನಂಬರ್ ಕೊಟ್ಬಿಡಿ ಹಿಂದೆ. other matter, other. He is also a contractor. Accused name is Muralidhara. They are contractors. Any other advocates? 54.82. Charge ಆಗಿಲ್ಲ. Charge ಆಗಿದೆ. Charge not framed. Advocate ಹೆಸರು ಹೇಳಿ. ಲೋಹಿತ್ ಕುಮಾರ್.
In this regard, respondent number 2 and respondent number 6 are washed by the sum code. This petition itself not better.
ಕ್ವಾಶ್ ಆಗಿದೆಯಾ? ಕ್ವಾಶ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ಲಿಬರ್ಟಿನಾ? ನೋ ಲಿಬರ್ಟಿ. ಈಗ ನಿಮ್ಮ ಪ್ರಕಾರ 54.68 R2 and R6 ಆಲ್ರೆಡಿ ಕ್ವಾಶ್ಡ್. ಹೌದಾ? ನಾಟ್ ಮೇಂಟೈನಬಲ್. ಹೌದಾ? ರಿವಿಷನ್ ನಾಟ್ ಮೇಂಟೈನಬಲ್. Yes, counsel, you bring your senior counsel at 2:30. Counsel, he only took time to, no accommodation, counsel. What happened to him today? ನೀವು ರಿಪ್ಲೈ ನಾಡಿದ್ದೆ ಕೊಡಿ ಹಾಗಾದ್ರೆ. ನಾಡಿದ್ದಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ 24th ತೋಳು ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಸ್ವರೂಪ್ ಹೇಳಿ. ಈಗ ಯಾರ ಏನೋ ಕೊಡ್ತೀವಿ ಅಂದ್ರಲ್ಲ, ಚಾರ್ಟ್ ಯಾರ ಕೊಡ್ತೀವಿ ಅಂದ್ರಲ್ಲ, ಕೊಡ್ಲಿ ಇನ್ನು ಆಮೇಲೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹತ್ರ ಕೊಡಿ, ವಕಾಲತ್ ಹಾಕಿ. ಇನ್ ಕೆಲವು ಕೇಸಸ್ ಇದೆ ಇಲ್ಲಿ. ಪರಮೇಶ್ವರ್ ಹೆಗಡೆ ಇದಾರೆ ಈಗ, ಅವ್ರು ಬೆಳಗ್ಗೆ ಎಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದ್ವಲ್ಲ, ಅದ್ರಲ್ಲಿ ನೀವ್ ಯಾವ್ದು ಅಪಿಯರ್ ಆಗ್ತೀರಿ. ಕೆಲವೆಲ್ಲ ಸರ್ವಿಸ್ ಆಗಿದೆ ಅಂದ್ರು, ಅದೇ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಇರೋವು. ಅದನ್ನ ಯಾವ್ದಾವ್ದು ಲಿಸ್ಟ್ ಮಾಡ್ಬಿಡೋಣ. ಅದ್ರ ಜೊತೆಗೆ ಪರಮೇಶ್ವರ್ ಹೆಗಡೆ ಸೀರಿಯಲ್ ನಂಬರ್ 26 ಇರ್ಬೇಕು. ಇದ್ರಲ್ಲಿ ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಬರ್ಕೊಳ್ಳಿ. ಕ್ರಿಮಿನಲ್ RP 484 of 24, criminal RP 1319 of 24, criminal RP 1506 of 24. There is a delay of 82 days, 169 days, 270 days respectively, and counsel for the respondent opposes the condonation of delay in spite of having knowledge, belatedly filed these revision petitions. And counsel for the petitioner state would submit that due to approval of filing of this revision petition, there was a delay. Having considered the delay of 82 days, 169 days, 270 days, delay is condoned. These matters are also connected matters. ಇದು ಸೀರೀಸ್ ಇದೆ ಮೇಡಮ್, ಅದ್ರ ಜೊತೆಗೆ ಹೇಳಿ. ಇದ್ರಲ್ಲಿ ನೀವೇನಾರು ಹೇಳೋದಿದೆಯಾ ಆರ್ಗ್ಯುಮೆಂಟ್? ಇವು ಮೂರಲ್ಲೂ ಅಥವಾ ಸಿಮಿಲರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅನ್ನ, ಕಾಮನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಾಗಾದ್ರೆ ಅದನ್ನ ಇಲ್ಲೇ ಸೇರ್ಸ್ಕೊಬಿಡೋಣ. ಇದು ಅದ್ರ ಜೊತೆ ಬರ್ಲಿ. 26, 27, 28 this matter along with series of letters matters ಇದೆ ಮೇಡಮ್, ಅದ್ರ ಜೊತೆ ಬರ್ಬೇಕು. ಆಯ್ತಾ? ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಇದು ಯಾವ್ದೋ ಪಾಸ್ ಓವರ್ ಒಂದ್ 2-3 ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಾ ಮೇಡಮ್? ಸೀರಿಯಲ್ ನಂಬರ್
Service is not yet complete, my lord.
ಸರ್ವಿಸ್ ಇಸ್ ನಾಟ್ ಕಂಪ್ಲೀಟೆಡ್ ಅಂದ್ರೆ 24th ಲಿಸ್ಟ್ ಮಾಡ್ತೀನಿ, ಅಷ್ಟರೊಳಗೆ ನೀವು
Sir, I'll
ಮಾಡ್ಕೊಳ್ಳಿ.
complete
ಇದನ್ನ
the service.
24th ಬೇಡವಾ? ಆಯ್ತು, 25th ತಗೊಳ್ಳಿ. ತಗೊಳ್ಳಿ. await notice in criminal RP number 97 of 22 and criminal RP 50 of 24, criminal RP 555 of 24. ಯಾವ್ದ್ರಲ್ಲಿ ಹಾಕ್ತಿದ್ರಾ? ಯಾವ್ದ್ರಲ್ಲಿ? 15 ಅಲ್ಲ? 3 and 5 ಗೆ ಕೌನ್ಸಿಲ್ ಇದ್ರಲ್ಲಿ ಹಾಕೋಬಿಡಿ. ಅದು 13 and 14 ಅಲ್ಲಿ. ಅಂಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಸ್ಟೇಟ್ ಇದು ನಿಮ್ದು ಅಲ್ಲೇನ್ರಿ? ಇವ್ರದಲ್ಲ. 13, 14 ಇವ್ರದಲ್ಲ, ಬೇರೆ ಪಾಸ್ ಅವರು. 15 ಆಗರ್ ಸ್ಟಾರ್ಟ್ ಆದ್ ಮೇಡಮ್. 13, 14 ಬೇಡ. 15 ಅಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಚಂದ್ರಶೇಖರ್ ಫೈಲ್ಸ್ ವಕಾಲತ್ ಫಾರ್ R3 and R6, R3 and R5. R6 ಆಲ್ರೆಡಿ ಸರ್ವ್ಡ್, ಅದೇನ್ ಬೇಕಿಲ್ಲ. R3 and R5. ಗೋಪಿ ಫಾರ್ R1 ಇದಾರೆ ಆಲ್ರೆಡಿ. R2 ಗೆ ಯಾರು ಇಲ್ವಾ? await notice of R2. You see that R2 is served. ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್ ನೀವು. You see that R2 is served. ಆಯ್ತು, ಅಲ್ಲಿಗೆ R2, R3, R5 ಗೋ ಆಯ್ತು. ವಾಟ್ ಅಬೌಟ್ R4 ನೀವು ಹಾಕ್ತಾ ಇದ್ದೀರಾ? ರೆಸ್ಪಾಂಡೆಂಟ್ ನೋಡಿ. 555 ಅಲ್ಲಿ ನೀವು ವಕಾಲತ್ ಹಾಕಿದ್ದು ಯಾರ್ಯಾರಿಗೀಗ? 1 and 5, 2 and 5 ಇರ್ಬೇಕು. 3 and 5 ಇರ್ಬೇಕು. 3 and 5 ಅಲ್ಲ? ಶಿವಮಲ್ಲು ಇಲ್ಲ ಇಲ್ಲ ತಗೊಳ್ಳಿ. ನೀವು ಸರ್ವ್ ಮಾಡ್ಬೇಕು. ಮೋಸ್ಟ್ಲಿ ಸರ್ವ್ ಆಗಿಲ್ಲ. ಈಗ ಚಂದ್ರಶೇಖರ್ ಫೈಲ್ಸ್ ವಕಾಲತ್ ಫಾರ್ R3 and R5 ಕರೆಕ್ಟಾ? ಅಂಡ್ ರಿಜಿಸ್ಟ್ರಿ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಶೋ ದಿ ನೇಮ್ ಆಫ್ ದಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ R3 and R5. ಕರೆಕ್ಟ್ ಏನ್ರಿ? R3 and R5 ಆಯ್ತಾ? State counsel for the state undertakes to see that notice is served on the R2, R4, R 7 to 9. 7 to 9 ಆಗಿಲ್ಲ.
Yes, ma'am.
ನೋಡ್ಕೊಬಿಡಿ ಅದು 7 to 9. List this matter on 25/2 along with ಅಲ್ಲ ಬಟ್ ಕಂಪ್ಲೀಟ್ ಆದ್ರೆ ಮಾತ್ರ along with, otherwise ತಗೊಳ್ಳೋದಿಲ್ಲ ನಾನು.
Yes, I'll
ಆಮೇಲೆ
complete
ಬೇಕಾದ್ರೆ
it.
ನೋಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ.
Complete.
ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ಯಾವ್ದು ಮೇಡಮ್?
It's
ಹೊಸದು
yours.
along with ಬೇಡ,
20.
ಅದು ಬೇಡ. 15 along with ಬೇಡ, post this matter on 25/2.
It is completed. Then 17.
Yes, 17. ಇದ್ರಲ್ಲಿ ಯಾರು ಹಾಕ್ತೀರಾ? ಪರಮೇಶ್ವರನ್ ಹೆಗಡೆ ಹಾಕಿದಾರೆ R3ಗೆ.
3 and R2.
LK ಶಿವಾನಂದ ಯಾರು ಹಾಕ್ತೀರಾ? ಇಲ್ಲ, ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗ್ಬಿಡಿದೆ ಬಿಡಿ. ಇದ್ರಲ್ಲಿ awaiting notice of R1 and R4. ಇದ್ರಲ್ಲೂ ಅಷ್ಟೇ ಮೇಡಮ್, R1 and R4 you have to see that it is served. ಇದು ಸರ್ವಿಸ್ ಹಾಕ್ದಲೆ ಇದು ಮೇಡಮ್ ಹಾಗಾದ್ರೆ ಈಗ ಎಲ್ಲೇ
15 ಆಯ್ತು,
ಹ್ಮ್.
15 ಆಯ್ತು.
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್
19.
ಆಮೇಲೆ 19 ಇದೆ.
19 ಅಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಚಂದ್ರಶೇಖರ್ ಫೈಲ್ಸ್ ವಕಾಲತ್ ಫಾರ್ 1 to 4 ಅಲ್ಲಿಗೆ ಎಲ್ಲರಿಗೂ ಆಯ್ತು.
Service is complete.
1 to 4. What about 5 is served ಅಷ್ಟೇ. And hence the registry is directed to show the name of the counsel Chandrasekhar for R1 to 4. Chandrasekhar?
ಚಂದ್ರಶೇಖರ
K ಏನಾ? ಚಂದ್ರಶೇಖರ K. ಚಂದ್ರಶೇಖರ್ K. ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಅವ್ರು R4 1 to 4 ಅವ್ರು ಅಂದ್ರಲ್ಲ ಈಗ.
1 to 4
ಅವ್ರು 1 to 4 ಅವ್ರು ಹಾಕ್ತವ್ರಂತಲ್ಲ. 1 to 4 ನೀವು ಅಲ್ವಾ? ಮೊಳ್ಳ ಸಿದ್ದಪ್ಪ ಅಂತಿಲ್ಲ, ಎನ್ ಸಂಪತ್ ಕುಮಾರ್ ಅಂತಿದ್ದಾರೆ. ಮೊಳ್ಳ ಸಿದ್ದಪ್ಪ ಇಸ್ R5. ನೀವು ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ತೀರಾ? ವಿಜಯ್ ಕುಮಾರ್ ಅಂಡರ್ಟೇಕ್ಸ್ ಟು ಫೈಲ್ ವಕಾಲತ್ ಫಾರ್ R5. ಅಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಆಯ್ತು ಅದ್ರಲ್ಲಿ. ಹೌದಾ? ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 25/2 ಅಲಾಂಗ್ ವಿತ್ ಅದರ್ ಸೀರೀಸ್ ಆಫ್ ಮ್ಯಾಟರ್ ಅಂತ ಹಾಕ್ಬಿಡಿ. ಅಲ್ಲಿಗೆ ಇಲ್ಲಿ ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ. ನೆಕ್ಸ್ಟ್ 20 R2 and R3 ಪರಮೇಶ್ವರ್ ಹೆಗಡೆ R1 ಹಾಕಿದಿರಿ. ಇದ್ರಲ್ಲೂ ಅಷ್ಟೇ ಮೇಡಮ್ 2 and 3 ಯು ಸಿ ದಟ್ ದಿ ಸೇಮ್ ಇಸ್ ಸರ್ವ್ಡ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 25/2 ಅಂತ ಹಾಕಿರ್ತೀನಿ ಮೇಡಮ್, ವಿತ್ ನಾಟ್ ಅಲಾಂಗ್ ವಿತ್ ಸೀರೀಸ್. 21 ಅಲ್ಲಿ ಯಾರ್ಯಾರು ಹಾಕ್ತೀರಾ ವಕಾಲತ್ತು? ಕೌನ್ಸಿಲ್ ಚಂದ್ರಶೇಖರ್ K ಫೈಲ್ಸ್ ವಕಾಲತ್ ಫಾರ್ R3 and R5. ಹಾಗಾದ್ರೆ ಇಲ್ಲ R2 and 4 ಮಾತ್ರ ನೀವು ಸರ್ವ್ ಮಾಡಬೇಕು. R2 and 4 ಮಾತ್ರ. await notice of R2 and 4. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಅಷ್ಟೇನಾ? ಇನ್ನು SPP ಇದೆಲ್ಲ ಆಯ್ತಲ್ಲ. 26, 27, 28 ಆಯ್ತು.
27 ಇಲ್ಲ 28
ಆಯ್ತಲ್ಲ ಮೇಡಮ್, ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡಿದ್ವಿ, ಅದು ಆಯ್ತಲ್ಲ. ಈಗ ಆಲ್ರೆಡಿ ಆಯ್ತಲ್ಲ, ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡಿದ್ವಿ. ಆಯ್ತು. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಅಲಾಂಗ್ ವಿತ್ ಲಿಸ್ಟ್ ಇದು ಸೀರೀಸ್ ಆಫ್ ಮ್ಯಾಟರ್ಸ್ ಅಂತ ಮಾಡಿದ್ವಿ. ಹಾ ಹಾಕಿ ಯಾರಿಗೆ ಹಾಕಿದ್ರಿ? 1ಗ. ಹಾಗಾದ್ರೆ 28 ಅಲ್ಲಿ ಅದರಲ್ಲಿ ಕೌನ್ಸಿಲ್ ಚಂದ್ರಶೇಖರ್ ಫೈಲ್ಸ್ ವಕಾಲತ್ ಫಾರ್ R1 ಹಾಗಾದ್ರೆ ಅದನ್ನ ತಗೋಬಿಡಿ ರೆಕಾರ್ಡ್. ಡಿಲೇ ಆಲ್ರೆಡಿ ಕಂಡೋನ್ ಮಾಡಿದ್ವಿ. ಹಾ ನೆಕ್ಸ್ಟ್ ಅಷ್ಟೇನಾ? 54 ಅದ್ರಲ್ಲಿ ಆಲ್ರೆಡಿ ಆಗಿರ್ಬೇಕಲ್ವಾ? 54/12 ಅಲ್ಲಿ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಫ್ ನೋಟಿಸ್ ರಿಸೀವ್ಡ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ R4 ಇದೆಯಲ್ಲದ ಕೌನ್ಸಿಲ್ ಚಂದ್ರಶೇಖರ್ K ಫೈಲ್ಸ್ ವಕಾಲತ್ ಫಾರ್ R2 and 4. And registry is directed to show the name of the counsel in the cause list. 54.42. 42 ಏನಾಗ್ಬೇಕು ಹೇಳಿ? 2ನಾ? ಕೌನ್ಸಿಲ್ ಚಂದ್ರಶೇಖರ್ ಫೈಲ್ಸ್ ವಕಾಲತ್ ಫಾರ್ R2. And hence registry is directed to show the name of the counsel in the cause list. ಕಂಪ್ಲೀಟ್ ಆಯ್ತು ಅಲ್ಲಿಗೆ?
Yes.
ಹಾ ಹ್ಮ್ 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 ಚಾರ್ಟ್ ಜೊತೆ ಸೇರಿಸಿ. ಈಗ ಇದ್ ಕೊಡಿ, ಆಮೇಲೆ ಇನ್ನೊಂದು ಕೊಡಿ ಅಡಿಷನ್, ಪರವಾಗಿಲ್ಲ. ಈಗ ಚಾರ್ಟ್ ಹಾಕಂಗಿದ್ರೆ ಕೊಡಿ, ತಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಪರಮೇಶ್ವರ್ ಹೆಗಡೆ, ಪರಮೇಶ್ವರ್ ಎನ್ ಹೆಗಡೆ ಫೈಲ್ಸ್ ಚಾರ್ಟ್ ಅಲಾಂಗ್ ವಿತ್ ಸಪೋರ್ಟಿಂಗ್ ಸೈಟೇಷನ್ಸ್. ಆಯ್ತು, ಸೈಟೇಷನ್ಸ್. ಹಾ
I have mentioned the intermediate petition and petition number.
Hmm.
And my statement because this one was for.
Stage
State.
ಸ್ಟೇಜ್ ಇನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಹಾ ಕೆಲವೆಲ್ಲ HBC ಇದೆ. ಹಾ ಹಾ ಹಾ
But the second matter, no.
ಹಾ
And
ಹಾ
and I have taken some of the cases here on from the government. Application is
ಹಾ
the trial court can so much of ask the order.
ಹಾ
So that's why I have mentioned the last column.
ಹಾ
Application filed in the trial court.
ಹಾ ಹಾ
ಯಾವ್ದ್ರೊಳಗೆ ಎವಿಡೆನ್ಸ್ ಸ್ಟೇಜ್ ಇದೆ, ಎಕ್ಸ್ಪ್ಲಿಸಿಟ್ ಸ್ಟೇಜ್ ಇದೆ, LS 227 ಅಪ್ಲಿಕೇಶನ್ ದಟ್ ಇಸ್ at the stage of ಎಕ್ಸ್ಪ್ಲಿಸಿಟ್.
ಅದೇ ಕಾಲಮ್ ನಂಬರ್ ಅದರಲ್ಲಿ ತೋರಿಸಿದಿರಿ.
ಎಲ್ಲ ಕಾಲಮ್ ನಂಬರ್ ಅಲ್ಲಿ ಫೈಲ್ ಇದೆ, ರಿಜೆಕ್ಟ್ ಆಗಿದೆ, ಕನ್ಸಿಡರ್ ಆಗಿದೆ ಯಾರು? Notification files all 19 and 197 were never raised before the court.
ಅಲ್ಲ even whether ಅಲ್ಲ one even if it is not considered or considered, I will pass an order making an observation. If any applications are filed, that can be considered on merits. Instead of stopping up proceedings, in
Yes.
case if this
Yes.
court comes to a conclusion that revision petitions to be allowed, then I will give directions to the trial court to consider on merits
Yes.
applications which are pending for discharge. And also in case if any no sanction, if any sanction is granted, you have to follow the procedure after the sanction. That can be, I can make an observation.
Yes.
In case if court comes to a conclusion that revision petition will be allowed anta bandre. Ashte. List this matter on 25-2. ಇನ್ನೇನು? ಹಾ 54.12 ಅಲ್ಲ ಆಯ್ತಲ್ಲ ಈಗ. ಇಲ್ಲ ಎಷ್ಟು ದಿವಸ ಇದೆ ಕೊಡಿ ಅದು. ಅದೇನು 51 days ಎಲ್ಲ ಕಂಡೋನ್ ಮಾಡೋಣ. ಡಿಲೇ ಕಂಡೋನೇಷನ್ ಇದೆಯಾ? ಕೊಡಿ ಯಾವ್ದಾದ್ರು ಹೇಳಿ. 54.12. ಹಾ ಅದೇ ಸೇಮ್ ಮಾಡ್ರಿ ಈಗ ಹೇಳಿದ್ನಲ್ಲ ಅದರ್ ಸೈಡ್ ಅಪೋಸಸ್ ಅಂಡ್ ಹಾ ಅದೇ ಸೇಮ್ ಮಾಡ್ರು ಅದನ್ನು ಮಾಡ್ಕೊಬಿಡಿ. 54. ಸರ್ವಿಸ್ ಆಗಿದೆಯಾ? ಸರ್ವಿಸ್ ಆಗಿದೆ ಅವ್ರಿಗೆ ಏನೋ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ R2 and R4. ಇದು IA 1/24 ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೇ 51 days ಕಂಡೋನ್ಡ್ ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ ಅದನ್ನು ಈಗ ಅದರಲ್ಲೇ ಸೇರಿಸ್ಕೊಬಿಡಿ. ಆಮೇಲೆ 104 ಅಲ್ಲಿ ಒಂದಿದೆಯಾ? 103 ಮೊನ್ನೆ ಎಲ್ಲ ಮಾಡಿದ್ವಲ್ಲ 100 ಇದೆ. 103 103 ನಲ್ಲೂ ಕೂಡ 264 days ಇದೆ ಡಿಲೇ ಕಂಡೋನ್ಡ್. ಆಮೇಲೆ ಇನ್ನೊಂದು 104 ಅಲ್ಲಿ 260 days. ಆಮೇಲೆ 286 105 ಅಲ್ಲಿ 106 ಅಲ್ಲೂ ಕೂಡ 263 days. ಇನ್ನೊಂದ್ರಲ್ಲಿ 268 days 7 ಅಲ್ಲಿ 108 ಅಲ್ಲಿ 260 days. 109 ಅಲ್ಲಿ 260 days. ಯಾವ್ದ್ರಲ್ಲಿ ಏನಾಗಿದೆ 109 ಅಲ್ಲಿ? ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಆಫ್ ನೋಟಿಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ R3. ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಅಂದ್ರೆ ಏನಾಗಿದೆ? ಸರ್ವಿಸ್ ಆಗಿದೆ ಇಲ್ಲ ನೋಡ್ಬೇಕಲ್ಲ, ನೋಡ್ಬಿಟ್ಟು ನನ್ಗೆ ಹೇಳಿ. ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು. ಬಾಕಿಯವ್ರಿಗೆಲ್ಲ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ. ಅವ್ರು ಯಾರು ಶಾಂತಿ ಭೂಷಣ್ ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರಲ್ರಿ ಮೊನ್ನೆ?
ಹೌದು.
ಅವ್ರು ಇವತ್ತು ಬಂದೇ ಇಲ್ಲ ನಿಮ್ಮ ಜೊತೆಗೆ. ಅವ್ರು ಮಾಡ್ಬೇಕಲ್ಲ, ಅವ್ರಿಗೆ ಹೇಳಿ 25th ಅವ್ರು ಮಾಡ್ಬೇಕು. ಅದು 309 days ಅದು ಸರ್ವಿಸ್ ಆಗಿಲ್ವಾ? ಆಗಿದೆಯಲ್ಲ, ಹಾಕಿದ್ರೆ ಆಯ್ತು. ಅದು ಡಿಲೇದ್ ಯಾವ್ದು ಇದೆಲ್ಲ ನೋಡ್ಕೊಂಡಂಗಾಯ್ತು. 25-2.
My lord, may I be permitted to make one submission, my lord?
Yes, counsel.
In serial number 54.1, my lord, I'm for respondent number 2 and 3.
54.1.
Please, my lord. In this, I'm for respondent number 2 and 3. I would just like to bring to the notice of this honorable court that in this matter also the charges have been framed against me.
In this matter?
The charges have been framed against me, my lord.
Charges have been framed.
Please. And in 54.4, I'm for respondent number 3. And in this also the charges are.
Rajashekhar S.
Please, I appear on behalf of S. Rajashekhar. So I would just like to bring to the notice of this court that in 54.1 and 54.4 and 54.50. And all these matters, my lords, I'm for respondent number 2 and 3. And the charges have been framed against me. I'll file a memo to this effect.
Yes, you file a memo to that effect on 25th.
Please, Lord.
My lordship, may I make a submission? Serial number 35, my lord, the matter has been settled. A week's time may be given, my lord, we will report the settlement.
35.
35, I'm for the petitioner.
Last time also you took time on the ground that settlement.
Last time the respondent number 1 took time, my lord. This time it is already settled.
Third. Serial number 35 thoroughly. You are appearing for whom?
Petitioner, my lord.
Petitioner counsel submits that matter is settled. I'm going to report the settlement on
28th, my lord.
28th.
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 My lord, I have one submission, my lord. My lord,
Yes.
serial number 68, I seek a short accommodation, my lord.
Serial number?
Serial number 68, my lord.
68.
Yes, my lord, 68, my lord.
What happened other side? It has been served or not? Some Dhanalakshmi is appearing on behalf of the respondent.
Yes, my lord.
You intimate other side.
I'm suffering from fever, my lord. That's the reason I.
Intimate ಮಾಡಿ ಅವ್ರು wait ಮಾಡೋದು ಬೇಡ. I will give you the date, but you intimate.
Yes, my lord. Yes,
They need not wait till 5 o'clock.
I will intimate.
Huh? ಏನಾಗ್ಬೇಕು 67? ಶ್ರೀನಿವಾಸನ್ MY. ಹೇಳಿ ಮಾಡಿ ಇದಿರಲ್ಲ 21 ಮ್ಯಾಟ್ರ್. ಏನ್ ಮಧ್ಯಾಹ್ನ? ಅದರ್ ಸೈಡ್ ಸ್ಟೇಟ್. Petitioner counsel seeks time on the ground of he is having appointment with doctor and HCK is present. List this matter on the madam 53 na? 53. 13. 13. ಇವೆಲ್ಲ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಇರೋದು ಈಗ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀರಿ? PF ಎಲ್ಲ ನೋಡೋಣ, ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ, ಈಗಿಲ್ಲ. ಹೇಳಿ, ಈಗ ಇನ್ನು ನಮ್ಗೆ ಕೆಲಸ ಇದೆ ಇನ್ನು ಮಾಡೋದು. ಹೇಳ್ರಿ, ಆಮೇಲೆ ನೋಡೋಣ ಅದೆಲ್ಲ. ಈಗ ಯಾವ 55 ಈಗ 100? ಅದು ಹೆಲ್ಡ್ ಸಫಿಷಿಯಂಟ್. 103 ನಲ್ಲಿ ಸರ್ವಿಸ್ ಹೆಲ್ಡ್ ಸಫಿಷಿಯಂಟ್ ಅಂಡ್ ದಿ ಸೇಮ್ ಈಸ್ ಸರ್ವ್ಡ್ ಆನ್ ದಿ ಅಡಲ್ಟ್ ಮೆಂಬರ್ ಆಫ್ ದ ಫ್ಯಾಮಿಲಿ ಅಂತ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ. ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ R3. ನೆಕ್ಸ್ಟ್ 55 ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಎಲ್ಲ ಬನ್ರಿ ಯಾರು? 419 420 ಇದೆಲ್ಲ ಫೈನ್ ಅಮೌಂಟ್ ಎಲ್ಲ ಕಟ್ಟಿದ್ದೀರಾ? ಫೈನ್ ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ದೀರಾ? Sorry, heard on IN number 1 of 24, madam. On suspension of sentence, having considered the grounds urged in the petition as well as application. Sentence is stayed. Sentence is suspended subject to depositing of fine amount if it is not deposited before the trial court within 2 weeks. And also directed to execute a bond for rupees 1 lakh with 1 surety before the trial court within 4 weeks. Call for records. List the matter on 21-3. 56. ಆಯ್ತು. 50% ಕಟ್ಟಿ. ಇದೆಲ್ಲ ಮೇಡಮ್ ಸೇಮ್ ಫಾರ್ಮ್ಯಾಟ್ ಇರ್ತದೆ. 50% ಅಂಡ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ 4 weeks. ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಬಾಂಡ್ ಫಾರ್ rupees 3 lakhs with 1 surety before the trial court within 4 weeks. Issue notice against the respondent and call for records. Call for records. List this matter on 21-3. ಅಷ್ಟೊಳಗೆ ದುಡ್ಡು ಕಟ್ಟಿರ್ಬೇಕು 50%. ನೆಕ್ಸ್ಟ್ 57. ಹೇಳ್ರಿ ಏನ್ ಇದರಲ್ಲಿ? ಮಾಡಿರೋದೇ 4,000 3,000. 4,000 ಇದೆಯಲ್ರಿ? 4,000 3,000 7,000 ಇದೆ. ವೈಫಿಗೆ 4,000 3,000 ಡಾಟರ್ಗೆ, ಆಮೇಲೆ ಮತ್ತೆ 3 ಜನಕ್ಕೆ 10,000ದಲ್ಲಿ ಏನು ಅದೇನು ಜಾಸ್ತಿ ಆಯ್ತು ಅಂತನಾ? ಅಲ್ಲ, ಅಷ್ಟೊಂದು ಅಪ್ಪ ಅಮ್ಮನ ಮೇಲೆ ಕರುಣೆ ಹೆಂಡತಿ ಮಕ್ಳ ಮೇಲೆ ಇಲ್ವಾ? ತೋರ್ಸಿ. ಒಂದ್ಸಲ ನೋಡ್ರಿ, 10,000ದಲ್ಲಿ 3 ಜನ ಜೀವನ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಕಷ್ಟ. ಅದ್ರಲ್ಲೂ ನಾನು ಸ್ಟೇ ಕೊಡೋದಿಲ್ಲ, ನಾನಂತೂ ಕೊಡೋದಿಲ್ಲ. ಆಯ್ತಾ? ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ಬರ್ಲಿ ರೆಕಾರ್ಡ್ಸ್. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. ಮತ್ತೆ ಯು ಬಿ ಪ್ರಾಕ್ಟಿಕಲ್ ಅಲ್ವಾ? 10,000ದಲ್ಲಿ 3 ಜನ ಬದುಕ್ಬೇಕು ಅಂದ್ರೆ ಅದ್ರಲ್ಲೂ ನೀವು ಸ್ಟೇ ಕೊಡಿದ್ರೆ ಹೆಂಗ್ರಿ? ನನ್ ಮನ್ಸಂತೂ ಒಪ್ಪೋದಿಲ್ಲ. ಆಯ್ತು, ಎಲ್ಲಾದ್ರೂ ಅಷ್ಟೇ. ವಿಲೇಜ್ ಅಲ್ಲಿ ಆದ್ರೂ ಊಟ ಮಾಡ್ಬೇಕು. 50 ರೂಪಾಯಿ ಇಲ್ಲ ಅಕ್ಕಿ, 80 ರೂಪಾಯಿ ಈಗ. ನೋ ಸ್ಟೇ. ನೋ ಸ್ಟೇ ಕೌನ್ಸಿಲ್. ಅದು ಕೊಟ್ಟಿರೋದು 50,000. 50,000 ಕೊಟ್ಟಿರೋದು. ಮತ್ತೆ ಆಯ್ತಾಯ್ತು. ನೋಟಿಸ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂಡ್ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 21-3. ನಾನ್ ಕೊಡಲ್ಲ, ಯಾರೋ ಮುಂದಿನ ಬರೋ ಜಡ್ಜ್ಗಳಿದ್ರೆ ತಗೊಳ್ಳಿ, ಆರ್ಡರ್ ತಗೊಳ್ಳಿ, ನಂದೇನಿಲ್ಲ. ಕೊಡಲ್ಲ ಇರೋದ 50,000. ಮಕ್ಳು ಬೇರೆ ಸ್ಕೂಲ್ಗೆ ಹೋಗ್ಬೇಕು, ಎಲ್ಲ ಮಾಡ್ಬೇಕು, ಅದೆಲ್ಲ ಇರ್ತದ್ರಿ. ನೀವು ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಚಿತ್ರ BP 1,50,000 93,000 ಆಯ್ತು. 50% ಕಟ್ಟಿ ಆಮೇಲೆ then we'll decide. 20% inclusive of 50% already deposited. Issue notice and execute a bond for rupees 50,000 with one surety before the trial court within 4 weeks. Issue notice, call for records and list this matter on 21/3. Next 59. ಇದ್ರಲ್ಲೆಲ್ಲ ಫೈನ್ ಕಟ್ಟಿದಿರೇನ್ರಿ? ತಗೊಳ್ಳಿ. Heard on IA number 1 of 25 for suspension of sentence having considered the ground surgery in the same matter. Application and affidavit directed to pay fine. Idu fine amount within 2 weeks if not deposited before the trial court. And ಅದ್ರಲ್ಲಿ HCP take notice ಆಗಬೇಕು. HCP is directed to take notice ಅಂತ ಫಸ್ಟ್ ಮಾಡಿ. ಮೇಲ್ಗಡೆ ಯಾವ್ದಾದ್ರು ಒಂದು ಕ್ರಿಮಿನಲ್ ಇದ್ರಲ್ಲಿ ಇತ್ತು ಮೇಡಮ್, ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗ್ಲಿಲ್ಲ. ಪ್ರವೀಣ್ ಕುಮಾರ್ ಅಲ್ಲಿ HCP is directed to take notice. ಆಯ್ತಾ? ಏನ್ 3 weeks ಫೈನ್ ಕಟ್ಟಕ್ಕೆ? ಆಯ್ತಾಯ್ತು, 2 ವಾರ ಫೈನ್ ಕಟ್ಟಕ್ಕೂ ಏನ್ 3 weeks. ನೆಕ್ಸ್ಟ್ ಇಶ್ಯೂ ನೋಟಿಸ್. ಅದ್ರಲ್ಲಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಬರಲ್ಲ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂಡ್ ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಆನ್ 21/3. ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಬಾಂಡ್ ಫಾರ್ ಅದೇ ಆಯ್ತಲ್ಲ ಹೇಳಿದ್ನ 1 lakh with one surety within 4 weeks. 60 ಇದರಲ್ಲಿ ಆಯ್ತು. ಸಬ್ಜೆಕ್ಟ್ ಇದು ಸೇಮ್ ಮೇಡಮ್ 50%. ಇದನ್ನು ಕೂಡ 1 lakh with one surety 4 weeks. ನೆಕ್ಸ್ಟ್ 61 4 lakhs ಇದು 50%. ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಬಾಂಡ್ ಫಾರ್ rupees 1 lakh with one surety before the trial court. Issue notice, call for records, list the matter on 21/3. ಎಲ್ಲ 21/3 ಎಲ್ಲ 138. ಯಾಕೆಂದ್ರೆ 4 weeks ಟೈಮ್ ಕೊಟ್ಟಿರ್ತೀವಿ. 62 suspend the sentence. ಇದು 50% 1 lakh with one surety 21/3. ಬಾಕಿದೆಲ್ಲ ಸೇಮ್ ಮಾಡ್ರು. ನೆಕ್ಸ್ಟ್ ಕೇಶವಮೂರ್ತಿನೂ ಸೇಮ್ ಮಾಡ್ರು 21/3. ನೆಕ್ಸ್ಟ್ 64 ಅದು ಅಷ್ಟೇ. ರಾಹುಲ್ ಎಸ್ ರೆಡ್ಡಿ 21/3 ಅಷ್ಟೇ ಸೇಮ್. ಇನ್ಕ್ಲೂಸಿವ್ ಎಲ್ಲ ಇನ್ಕ್ಲೂಸಿವ್ ಅದೆಲ್ಲ ಫಾರ್ಮ್ಯಾಟ್. ನೆಕ್ಸ್ಟ್ ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಆಕ್ಟ್. ಎಷ್ಟು ಪಾಠಾಡ
ಅಷ್ಟಾಗಿದೆ ಬೆಳಗ್ಗೆ ಯಾವಾಗ ನಿಮಿಷ ಕೊಡ್ತೀನಿ. ಇದೆಲ್ಲ ಮುಗಿತಾನೆ ಇಲ್ವಲ್ಲ. 34 ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಆಗಿದೆ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಆಗಿದೆ, ಅದು ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಬೇಕು. ಆಮೇಲೆ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇಲ್ಲ ತಗೊಂಡಿಲ್ಲ. ಹೇಳಿ ಅದು ಇದು ಯಾವ್ದು ಇನ್ನು ಇದೆಯಲ್ಲ ಇವತ್ತು ಜಡ್ಜ್ಮೆಂಟ್ ಏನು ಫಾಲೋ ಮಾಡ್ತಾ ಇಲ್ಲ ಅವರು. ಅದು ಆರ್ಡರ್ ಆಗಿದ್ಯಾ? ನೀವೇನು ಕೇಳಕ್ ಹೋಗ್ಬಿಡಿ, ಸುಮ್ಮನೆ ಅವರು ಫಾಲೋ ಮಾಡ್ತಿಲ್ಲ. ಹೇಳಿ. ಹೌದು.
ಸೀರಿಯಸ್ ಆಗಿ ಓದ್ತಾ ಇದ್ದೀರಾ ಅಲ್ವಾ ಇವತ್ತು? ಸೀರಿಯಸ್ ಆಗಿ ಓದ್ತಾ ಇದ್ದೀರಾ? ಅಲ್ವಾ? ಪ್ರತಿರೋಧ ಮಾಡಿ ಮಾಡಿ. ಇದು ಯಾವುದು? ನಮ್ದೇನಾ? ಮತ್ತೆ ಕೊಡಿಯಲ್ಲ ನಮ್ಮದೇ ಕನ್ಫ್ಯೂಷನ್ ಮಾಡ್ತಾರೆ. ಇದೆಲ್ಲ ಅವ್ರದೇನಾ? ಇದೇನಾ? ಎಂಟರ್ ಕೊಡೋದಕ್ಕೂ ನರ್ಸಿಂಗ್ ಇರೋದಕ್ಕೂ ರಿಲೇಶನ್ಶಿಪ್ ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡೋದು ಎಲ್ಲ ಅದೇ ಕಡಿಮೆ ಆಗಿರೋದಕ್ಕೆ ಅಲ್ವಾ ಕ್ಲೀನ್ ಮಾಡಿಸೋದಕ್ಕೆ ಒಂದು ಸಮಾಧಾನವಾಗಿ ಕೂತುತ್ತೇನೆ. ಇದು ಮನೆಯಿಂದ 4 ಫೋನ್ ಬಂದಿಲ್ಲ, ವಾಪಸ್ ತಗೊಂಡ್ ಬರ್ಬಾರ್ದು, ತಿನ್ಬಿಟ್ಟು ನಾವಿದ್ದು ಮಾಡ್ತೀರಾ ಅಂತ ಕೇಳಲಿಕ್ಕೆ ಹೌದಾ, ಫಾರ್ಮ್ ಬಂದ್ಬಿಟ್ರಲ್ಲ. ಮತ್ತೆ ನಿಮ್ಗೆ ಕರೀಲಿಲ್ವಾ ಬೆಳಿಗ್ಗೆ ಬಾ ಅಂತ? ಕೊಟ್ಟಿನಿ 5 ನಿಮ್ಮನ್ನ Now that's considered in its first one, ಏನಿರುತ್ತೆ ಅವ್ರಿಂದ ಮ್ಯಾಟ್ರ್ ಯಾವಾಗ್ಲೂ ನಂದ ಫಸ್ಟ್ ಬರೋದು ನಿಂದ ಹೇಳ್ಬಿಡ್ತಾರೆ ಹೋಗಿಲ್ಲ ಸರಿ ಹೋಗಿಲ್ಲ ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ ಶ್ರೀಗಂಧ ರೋಡ್ ರೋಟ್ಲೇನಾ ಮತ್ತೆ ಬಿರಿಯಾನಿ ಅಂದ್ರೆ ಫುಲ್ ಹೋಗುತ್ತೆ ಚಿಕನ್ ಅಂದ್ರೆ ಅರ್ಧ ಹೋಗುತ್ತೆ
After matter, seal number 13, Akshata Shetty, 13, Akshata Shetty.
ಏನಕ್ಕೆ ಏನು 138 ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿದಿರಾ 30% ನೀವು ಇಲ್ಲಿ ಇದು 50% ಆಗಿದೆಯಲ್ಲ ಆರ್ಡರ್ 13/4/23 ಹಾ ಈ ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲ ಕಟ್ಟಿಲ್ಲ ಹಾ ಕಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸಲ್ ಹಾ ಕಟ್ತೀರಾ 15 ದಿವಸ PF ಕೊಟ್ಟಿಲ್ಲ ನೀವು ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೀರಿ ಆರ್ಡರ್ ಆಗಿರೋ 23 then why you have to keep this matter pending if you are not compliant I will give you 1 week time if your client fails to pay the amount within 1 week I will dismiss it 15 ದಿವಸ ಎಲ್ಲ ಕೊಡಲ್ಲ this matter on 28th in the meanwhile issue notice against the respondent ಹಾ ಅಷ್ಟೊಳಗೆ ಪೇಮೆಂಟ್ ಮಾಡ್ಬೇಕು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಪಿಟಿಷನ್ ಉಳಿಯಲ್ಲ ಕೊಟ್ಟಿನು ಪಾಸ್ ಅವರ ಸುಭಾಷ್ ಚಂದ್ರ ಬೋಸ್ ಹೆಸರು ಮಾತ್ರ ಬಹಳ ಚೆನ್ನಾಗಿದೆ ಬೆಳಗ್ಗೆನೂ ಇಲ್ಲ ಈಗ್ಲೂ ಇಲ್ಲ ಹಾ ಬೆಳಗಿದ್ರ ಹೌದಾ PF ಕೊಡ್ತೀನಿ ಅಂದ್ರ ಕೊಡಿ ನೋಡೋಣ ಏನು ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಮಾತ್ರನಾ PF ಕೊಟ್ರ ಅಥವಾ ಕೊಡ್ಬೇಕ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡೋಣ ಮತ್ತೊಂದ್ಸರಿ ಕಾಯೋಣ ಸುಭಾಷ್ ಚಂದ್ರ ಬೋಸ್ ಸೆಕೆಂಡ್ ಪಾಸ್ ಓವರ್ 29 JR ಮೋಹನ್ ಏನು ಹೇಳಿದ್ರ ಬೆಳಗ್ಗೆ ನೀವು ಇರ್ಲಿಲ್ಲ, you are not there.
12 held upon.
ಹಾ,
It was the 3 lakh amount which we drawn as regarding, which are deposit, they can withdraw it.
ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರ ವಿಡ್ರಾಯಲ್ ನೀವು ಹಾಕಿದಿರಾ?
ಇಲ್ಲ, ಅದು that has to be filed in 48833 of 2019 ಮೇಲೆ. 48833
ಹಾ,
ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಫೈಲ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ.
ಇದ್ರಲ್ಲ ಆಗಿದೆ ಆರ್ಡರ್.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಇವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ನಾನು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀನಿ, ಅಮೌಂಟ್ ಅವ್ರು ರಿಲೀಸ್ ಮಾಡ್ಕೊಳ್ಳಿ, ದೇರ್ ಬೈ ದಿ ಎಂಟೈರ್ ಆರ್ಬಿಟ್ರಲ್ ಅವಾರ್ಡ್ ಇಸ್ ಗೋಯಿಂಗ್ ಟು ಬಿ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಅನ್ನೋದು ಇವ್ರ ಕಂಟೆನ್ಷನ್ ಮೇಲೆ. So what is my contention, my lord? Whatever the check issued by the son of the petitioner, this came to be dishonored, and for which we have filed a CC, convicted, and the son of the petitioner was preferred on appeal, which came to be judgment to post agida son. So under that
ಈ
circumstance,
ರಿಟ್ ಪಿಟಿಷನ್ ಏನ್ ಆರ್ಡರ್ ಯಾವ್ದ್ರ ಮೇಲೆ?
one submission, my lord.
ಅದ್ರಲ್ಲಿ ಇದೆ 3 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಅಲ್ಲ, ವೆದರ್ ಇಟ್ ಪರ್ಟೈನ್ಸ್ ಟು ದಿ ಬೌನ್ಸಿಂಗ್ ಆಫ್ ಚೆಕ್ ಕನ್ಸರ್ನ್.
No, not my lord, not my lord.
ಆಯ್ತು, ಇದು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಮಾಡೋಣ. ಈಗ ಡಿಲೇ ಕಂಡೋನ್ ಮಾಡೋಣ. ತೊಗೊಳ್ಳಿ, ವರ್ಡ್ ಆನ್.
One submission, my lord. This RP came to be dismissed, my lord, because
ಆಲ್ರೆಡಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಅಲ್ಲ, ಇದು ಡಿಸ್ಮಿಸ್ ಆಗ್ಬೇಕು. ಕಾರಣ ಯಾಕೆ ಅಂದ್ರೆ,
ಅಲ್ಲ, ಬಟ್ ಈಗ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಬೇಕಲ್ಲ, ನಾವು ರೆಕಾರ್ಡ್ಸ್ ತರ್ಸ್ಕೊಂಡ್ ಮಾಡ್ಬೇಕು, ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕು.
this is on the basis of the MFA filed before this honorable court. This was disposed during the admission itself.
RP na?
ಹೌದು ಮೇಲಂ, RP ಮೇಲಂ. Under that circumstances, what the contention of the
What is the order passed in MFA?
MFA ಮೇಲಂ? It came to be dismissed during
Review
admission.
petition. Review ಏನ್ ಗ್ರೌಂಡ್ ಏನು?
One of the ground ತಗೊಂಡಿದ್ದಾರೆ.
One of the ground.
Page number 25 in MFA appeal memo. Appeal memo ನಲ್ಲಿ.
Page number 25 ನಲ್ಲಿ ಏನಾಗಿದೆ?
25 appeal memo ಅದರಲ್ಲಿ
MFA ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಡಿಸ್ಪೋಸ್ ಆಗಿಲ್ವಾ?
Merits ಮೇಲೆ dispose ಆಗಿದೆ.
Page 26. It is fully submitted that in terms of the order passed by this court in WPN was also to deposit some of before the trial court within 4 weeks. So the appellate deposit set sum of 3 lakh by way of PD, drawn on Excise Bank, Bangalore, and thereafter set sum of. It is fully submitted that the set sum of 3 lakh is still lying in deposit. After dismissal, and no observation has been made by the trial judge about the amount of rupees lying with the trial court while dismissing the appeal. So ತಾವು ಇದು ಮಾಡೋ continue that only appeal is ಮಾಡಿ. Let them take the 3 lakh so that ನಮಗೊಂದು credit ಸಿಗುತ್ತೆ ಇದಾಗುತ್ತೆ.
In terms of the order passed by this honorable court in WP number so and so, to deposit a sum of rupees 3 lakh before the trial court within 4 weeks from the date of order on 29/5/2017, the appellant had deposited the said sum of rupees 3 lakh by way of DD so and so drawn on so and so Saurashnagar Bank in favor of the Discharge City Civil Court, Bangalore on 23/6/2017, and that thereafter said sum was ordered to be converted as fixed deposit by order of the trial judge dated so and so in State Bank of India Residency. It is responsibly submitted that the said sum of rupees 3 lakh is still lying in deposit of the City Civil Court. After dismissal of the AS number, and no observation has been made by the trial judge about an amount of rupees 3 lakh lying with the trial court while dismissing the application suit only on the ground of limitation.
I am not know all that. Your Lordship has said that confirm the order of the trial court by dismissing the limitation ground.
So respond.
Only thing is, the 3 lakh amount is there, our body they can take it back.
My submission, madam. Upon the submission of the respondent, my lord, trial court in AS number 2500 of 2015, the 3 lakhs has to be deposited before the bank, my lord, nationalized bank as per the direction of the.
FD ನಲ್ಲಿ ಇತ್ತು.
Also, FD ಅಲ್ಲಿ ಇದೆ. ಈಗಲೂ ಕೂಡ ಅಲ್ಲೇ ಇದೆ.
ಈಗಲೂ ಇದೆ.
So for which respondent is at liberty to file necessary application before the trial court itself by
withdrawing the amount.
Yes, madam.
He has to make an application.
That I used to file an application. ನಾನು ಹಾಕ್ಬೇಕು ಸರ್.
ಆಯ್ತು.
So ನಾನು ಹಾಕೊಳ್ತೇನೆ ಅದನ್ನು. So here, if I am going to file necessary application before this honorable court, direct the trial court to release the said amount. The petitioner herein might have come before the criminal appeal, and wherein is raised an objection, the matter has been posted for judgment. So ಅಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ನಾನು 3 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದೀನಿ, ಇಟ್ಸ್ ಎ ಪಾರ್ಟ್ ಆಫ್ ಪೇಮೆಂಟ್ ಅಂತ ಬರ್ತಾರೆ ಸರ್. ದಿಸ್ ವಾಸ್ ವೇ ಬ್ಯಾಕ್ 2010 my lord. So under that circumstances 7,20,053 rupees as liable to be payable by the award amount, my lord.
ಈಗ ರಿವ್ಯೂ ಏನಕ್ಕೆ? what has to be reviewed?
Reviewed nothing, my lord. There is no contention. The contention of the petitioner is only that the award amount has been satisfied by issuing check by way of check issued by the son of the petitioner anta. Sign check kotbitre that is not going to be satisfied, my lord. Check kotu came to be dishonored, and for which also we have roaming before the courts of law, my lord.
The very suit itself is barred by limitation, and the same is filed almost after lapse of 5 years. Award passed by the arbitration award.
1 decade, my lord.
Reasonings are given. Question of interfering with the findings of the award passed by the arbitration board as well as the arbitration suit does not arise. The appellant's slept over more than 1.5 decade when the
Yes, ma'am.
claim was made.
Before the arbitration board and did
The
not
arbitration board
participate.
and did not participate and put
Put
forth
his
his
case
case
and
by
won.
only attended the arbitration proceedings twice, and thereafter he did not attend the arbitration proceedings. The very contention that the producer has to pay the amount and not the appellant also cannot be considered in this appeal, since no such plea was set forth before the arbitration board. Hence, I do not find any merit in the appeal.
Yes, ma'am.
3 lakh amount ಬಗ್ಗೆ ಎಲ್ಲೂ ಬಂದಿಲ್ಲ. ಒಂದು
3 lakh ನೀವು ಏನಿದೆ ಅದನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋಬಹುದು ಅಷ್ಟೇ.
ಅವ್ರು ಅದನ್ನ ಇದು ಮಾಡೋದು ಸಾಕು ಅಷ್ಟೇ.
ನಾವು ಹಾಕೊಳ್ತೀವಿ ಅದನ್ನ ಅಮೌಂಟ್ ಟುವರ್ಡ್ಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಗೆ ಅದು ಡಿಡಕ್ಟ್ ಆಗುತ್ತೆ. ಇಟ್ ಇಸ್ ಇನ್ ದ ಲೇಟೆಸ್ಟ್ ತಗೊಳ್ತೀವಿ. ದೇರ್ ಇಸ್ ನೋ ಬರ್ಡನ್.
As far as the check is concerned, it's a separate litigation. So now only by full submission that your lordship can give them liberty to withdraw that amount which is based on the direct of this amount.
ನಾನ್ ಕೂಡ ಲಿಬರ್ಟಿ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಅವರೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋತಾರಂತೆ. Let them file an application, that's all. Third, the review of petitioner counsel and also the counsel appearing for the respondent. And counsel for the petitioner in this review petition would contain that there was a pleading in the MFA appeal with regard to the deposit of amount of ₹3 lakh. In terms of the order passed by the court in WP number 48833 of 2016. And this court, while disposing of the MFA, not touched upon the said point for consideration. And hence this court has to review the order.
Para 12 of the case.
And also brought to notice of this court, para 12 of the grounds urged in the MFA, na? MFA.
Page 26, para 12.
The said amount is lying with the trial court. While dismissing the application, public suit only on the ground of limitation. And hence this court has to review the order passed by this court. Per contra, the counsel appearing to the respondent would vehemently contend that.
Objections filed, ma'am. Objections filed, ma'am.
Objections ಹಾಕಿದ್ರೆ ಈ revision ಗೆ.
12/2/25. Last
filing objection statement would contend that detailed objection statement is filed. Elide madam objections?
last date important.
Copy of acknowledgement. ಇಲ್ವಲ್ಲ?
Open court ನಲ್ಲೇ ಕೊಟ್ಟು ಸರ್ last date.
12?
Open court ನಲ್ಲೇ submission ಆಯ್ತು ಮೇಲ.
12/2 ನಾ?
12/2 ಮೇಲ.
ಇಲ್ಲೇನೋ ಇದೆ. Filed a statement of objections contending that respond number 1 filed execution number 2426 of 2012 against the petitioner herein for recovery of the amount awarded in arbitration case number 24 of 2009 by the arbitration board of Karnataka Film Chamber of Commerce, Bangalore. After service of notice in the execution, the court was pleased to issue an order of attachment of movables. On 22/9/2015, respondent and court bailiff entered into the house of petitioner at the instance to to stop the execution of the order of attachment, petitioner's son voluntarily issued post-dated check towards the attachment amount of rupees 7,20,053. And the said check came to be dishonored on its presentation. The case was also filed in CC number 813, wherein conviction order was passed and appeal was also filed. The same is posted for judgment. The petitioner herein also preferred AS number 25004 of 2015 on 30/11/2015, and IA came to be dismissed. And also he preferred writ petition, wherein stayed the proceedings of CC number 813 of 2016. That on 29/5/2017, petitioner counsel submits that a sum of rupees 3 lakh would be deposited before the jurisdictional court. In the light of the said submission, this court continued the order dated 18/10/2016 until further orders, subject to deposit. The respondent herein also filed an IA number 1 of 18 for release of the said deposited amount in WP, and the same was disposed of on 14/9/2022. Then AS number 25004 of 2016 dismissed on 29/11/23 itself. And against that order, preferred MFA, and the same is also dismissed at the time of the admission itself. It is also contended that petitioner presently preferred the above revision petition, with the contention that petitioner deposited rupees 3 lakh. The respondent number 1 has taken entire award amount together with interest by way of check from petitioner's son. In view of the fact that entire award has been satisfied by the petitioner by way of deposit a sum of rupees 3 lakh before trial court, and also the check issued by the petitioner's son in favor of the respondent number 1. The check issued was not honored, and petitioner herein misrepresented the facts. And court also reprimanded the petitioner by imposing exemplary cost. When such being the case, question of reviewing the order does not arise. Having considered the grounds urged in the MFA as well as in the objection statement, and also considering the factual aspects of the case, this court, considering the appeal, passed an order, particularly with regard to the issue of limitation, and made an observation that the appellant slept over more than 1.5 decades when the claim was made before the arbitration board and did not participate and put forth his case. And only he attended the arbitration proceedings twice, and thereafter he did not attend the arbitration proceedings. And when such order is passed by this court, in coming to the conclusion that when the claim was made and the same was dismissed on the ground of limitation, and even though the said ground was urged before this court regarding deposit of the said amount is concerned, and when the issue is with regard to the limitation is concerned, and this court considered the same, and particularly the trial court also taken note of the very proviso section 34(3) of the Arbitration and Conciliation Act, wherein if any application for setting aside may not be made after 3 months, have elapsed from the date on which the party making that application had received the arbitral award, or if a request had been made under section 33, from the date on which that request had been deposited or disposed, request had been disposed of by the arbitral tribunal, and comes to the conclusion that the trial court not committed any error in considering the issue of limitation is concerned. When the issue of limitation is considered by this court, question of reviewing the order in view of the contention taken by the appellant counsel doesn't arise. The counsel for the respondent also would submit that even if any such amount has been deposited, he is going to make an application for withdrawal of the amount, and he can withdraw the said amount. With this observation, writ petition is disposed of. Review petition is disposed of.
30. SS Hiramat.
Concurrent finding, the amount is 3,50,000.
ರೆಕಾರ್ಡ್ ಬಂದಿಲ್ವಾ?
Please,
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ?
I am for the respondent. Complainant.
Petitioner counsel absent in the early morning and also in the afternoon. ಹೌದಾ? ಈ ಆರ್ಡರ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಾರ ಹೋಗ್ಲಿ?
ಮಾಡಿದರೆ ರಿಲೀಸ್ ಆಗಿದೆ 1,05,000.
ಈ ಅಮೌಂಟ್ ಆಗಿದೆಯಾ?
Yes, 1,05,000.
ಆಯ್ತು. And if counsel for the petitioner doesn't appear in the next date of hearing, revision petition will be dismissed. However, in the meanwhile, registry is directed to get the records of the both the courts and list the matter. Other date kodi 21 matter. 10-3.
32.
32 nu pass over ಆಯ್ತಾ?
sheet.
ಶಂಕರಪ್ಪ ನೀವೇನೋ ಹೇಳ್ತಿದ್ರಲ್ರಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಬೆಳಗ್ಗೆ ಯಾರೋ ಏನೋ ರಿಟೈರ್ಮೆಂಟ್ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರಿ?
ಯೂನಿವರ್ಸಿಟಿ ವಕಾಲತ್ ಟುಡೇ ಮಿಲಾಡ್
ಯೂನಿವರ್ಸಿಟಿ ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ಕೌನ್ಸಿಲ್ ಶ್ರೀ
ವಿಖ್ಯಾತ್ ಬಿ
ವಿಖ್ಯಾತ್ ಬಿ submits that he has filed wakalat today on behalf of the respondent and hence registry is directed to put up the same and show the name of the counsel Vikyat B in the cause list. The petitioner counsel absent in the early morning and also in the afternoon. ಬೆಳಗಿನ ಇರಲಿಲ್ಲ ಮೇಡಮ್? However, one more opportunity is given to the petitioner counsel. If petitioner counsel doesn't appear in the next date of hearing, revision will be dismissed. List this matter on 10-3.
ಏನ್ ರಾಧಾಕೃಷ್ಣ
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ? 279 2 years ಕೊಟ್ಟಿದಾರ? 279 304A. 1 and 2. Tractor. He was? Petitioner was driving the vehicle on the date of the accident anta. Death only ಒಂದೇನಾ? ಒಂದೇ ಡೆತ್. ಆಯ್ತು 6 ತಿಂಗಳಿಗೆ ಇಳಿಸೋಣ. PW 2 and 3 ಎವಿಡೆನ್ಸ್ ಇದೆ ಅಂದ್ರೆ ಏನ್ ಹೇಳಿ ಅದು ಏನು? ಸ್ಯಾಂಡ್ ಟ್ರಾಕ್ಟರ್ ಸ್ಯಾಂಡ್ ಇತ್ತಾ? ಎರಡು ವರ್ಷಗಳ ಹಿಂದೆ ಟ್ರಾಕ್ಟರ್ಗೆ ಅಪಘಾತವಾಗಿರ್ತದೆ. ಅಪಘಾತದಿಂದ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಆರೋಪಿ ಟ್ರಾಕ್ಟರ್ ಇವ್ ಸತ್ತವನ್ ಇಲ್ಲಿದ್ದ ಅವಮ್ಮ ಇಲ್ಲಿದ್ಲು ಒಂದೆ ನಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ಲ ಏನು? ರಸ್ತೆ ಬದಿಯಲ್ಲಿ ಹೋದವ್ರಿಗೆ ಡಿಕ್ಕಿ ಹೊಡೆದಿರೋದು. ಸಿ ಒಂದೇ ನಿಮಿಷ. Within the jurisdiction of Dandaseva police station between Arpsanoli, Ranganathpura village near Venkatesh property in the Tar road, the accused being the driver of tractor also drove his vehicle in rash and negligent manner from side so Ranganathpura village and dashed the pedestrian, namely Hanumamma, who is proceeding by the side of road. Due to the said incident, said Hanumamma was fell down and thereafter the tractor was run over the head of the said Hanumamma, and due to that injury her brain was came out. Due to that injury, she succumbed in the spot. CW1 has been registered in case of so and so. Evidence kodi ಏನಾರು ಇದೆಯಾ? ಹೋಗ್ಲಿ PW1 and 2 ನಲ್ಲಿ ಏನಾರು ಸೇಮ್ ಥಿಂಗ್.
ಅಪಘಾತವಾದ ನಂತರ ಟ್ರಾಕ್ಟರ್ ಚಾಲಕ 300 ಮೀಟರ್ ದೂರ ಹೋಗಿ ಟ್ರಾಕ್ಟರ್ ಬಲಭಾಗಕ್ಕೆ ಅಪ್ಸೈಡ್ ಮಾಡಿಸಿ ಓಡಿ ಹೋಗಿರುತ್ತಾನೆ. ಫೆಲ್ ಡೌನ್ ಅಂತ. And PW2 also say same thing. ಆ ದಿನ PW2 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಂತ ಆ ದಿನ ಸದಾ ಟ್ರಾಕ್ಟರ್ ನಲ್ಲಿ ಮರಳು ತುಂಬಿತ್ತು. ಯಾವುದೇ ಒಂದು ವಾಹನ ತುಂಬಿದಾಗ ತಿರುವಿನಲ್ಲಿ ವೇಗವಾಗಿ ಅಲ್ಲಿ ಎಸ್ಬಿಟ್ಟು ಸ್ಪಾಟ್ ಬಾಜರ್ನಲ್ಲಾಗಲಿ ಅಥವಾ ಫೋಟೋದಲ್ಲಾಗಲಿ ಏನು ಮರಳು ತುಂಬಿತ್ತು ಮರಳು ತುಂಬಿತ್ತು ಅಂತ.
ನಿಮ್ ಓನರ್ ಕೂಡ ಒಪ್ಕೋತಾನಲ್ರಿ.
ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂತ ಡ್ರೈವಿಂಗ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಟೂ ವೀಲರ್
ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. ಆಯ್ತು.
ಕುರಿ ಚಿಕ್ಕ ಸೈಟ್ ಇಲ್ಲ. ಫೋಟೋ ತಗೊಂಡಿಲ್ಲ.
ಅದಾದ್ಮೇಲೆ ಕುರಿ ಕಟ್ ನಿಲ್ಸಿದ್ದಾಗೆಲ್ಲ ಮಾಡಿರ್ತಾರೆ. ಸ್ಪಾಟ್ ನೋಡಿ ಎಷ್ಟ ನೀವು ಸ್ಕೆಚ್ ನೋಡಿದಾಗ ಕೃತ್ಯ ನಡೆದ ಜಾಗ ಔಟ್ಸೈಡ್ ದಿ ರೋಡ್. ಬಟ್ ಅಟ್ ದ ಟೈಮ್ ಆಫ್ ಇದಿಲ್ಲ. H exhibit P7. ಯಾವ ವರ್ಷದಲ್ಲಿ ಆಗಿರೋದು ಇದು? 15.
MBC ಕೇಸ್ ಹಾಕೊಳ್ತಾರೆ. ಅದರಲ್ಲಿ 3 ಲಕ್ಷ ಕಾಂಪನ್ಸೇಷನ್.
ಬರೀ 3 ಲಕ್ಷ
ಕೊಟ್ಟವ್ರೆ. ಬಟ್ ಏಜ್ ಆಗಿತ್ತು ಸರ್ ನಾವು.
ಈಸ್ 18 ಏನೋ ಇದೆ. 80 year. 80 ವರ್ಷ. ಆಯ್ತು ಆಯ್ತು. ಸರಿ, ಒಂದು 2 ವರ್ಷ ಇರೋದು 6 ತಿಂಗಳಿಗೆ ತಂದು ನಿಲ್ಸೋಣ ಅಷ್ಟೇ. ಮೆಟೀರಿಯಲ್ ಇದೆ. ಫೈನಾ ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಹೇಳಿ? ನಾನು ಹೇಳಲ್ಲ, ನೀವು ಹೇಳೋದ್ರ ಮೇಲೆ ನಾನು ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ.
ಹೇಳಿದೆ
ನಾನೇನ್ ತಪ್ಪು ತಿಳ್ಕೊಬೇಕ್ರಿ? ಇಟ್ ಡಿಪೆಂಡ್ಸ್ ಅಪಾನ್ ದಿ ಕೇಪಬಿಲಿಟಿ ಆಫ್ ಎನ್ ಅಕ್ಯೂಸ್ಡ್ ರಿವಿಷನ್ ಪಿಟಿಷನರ್ ಅಷ್ಟೇ. ಡ್ರೈವರ್ ಅಲ್ಲ. ಆಯ್ತು, ಯಾರು ಓನರ್ ಇರ್ತಾನ ಅವ್ನು ಕೊಡ್ತಾನೆ ಬಿಡಿ. ಅಷ್ಟೇ. ಆಯ್ತು.
1.5 ಲಕ್ಷ ರೂಪಾಯಿ.
ಆಯ್ತು, ಏಜ್ ಏನೋ ಒಂದು ಆಗಿದೆ, ಒಂದು 90 ವರ್ಷ ಆಗ್ಲೇ. Told. Heard the petitioner, counsel and also the counsel appearing for the respondent. This revision petition is filed against the concurrent finding of trial court and also the appellate court. In trial court convicted the petitioner for the offence punishment section 279 and 304A of IPC for a period of 6 months and 1,000 fine for 279 and 2 years and 10,000 fine for the offence punishment under section 304A of IPC. The factual matters of case of the prosecution is that this petitioner on 10/9/2015 at about 3 PM drove the tractor in a rash and negligent manner and dashed against the pedestrian who was proceeding on the very same road. As a result, the victim, who is aged around 80 years, was passed away. And police have registered the case and investigated the matter and filed the charge sheet. And accused was secured and he did not plead guilty, and hence prosecution mainly relies upon the evidence of PW 1 to 6 and also document exhibit P 1 to 14. The accused was subjected to 313 statement but not led any defense evidence. Having considered the material available on record, the prosecution mainly relies upon the PW1, who is the son of the victim, and also the PW2 is also an eyewitness, and PW3 is the owner of the tractor, who also identifies that, who also deposes that this petitioner was driving the tractor on the same day, and other witnesses, master witness and IO. Having considered the material, trial court convicted and imposed the fine of ₹10,000 with 2 years punishment. The same is confirmed by the appellate court, having reassessed the material on record. and hence present revision petition is filed before the court. The counsel appearing for the revision petitioner would vehemently contend that both the courts failed to take note of the material on record and the evidence of PW1 who is none other than the son of the deceased, and PW2 is also the relative of the PW1, and though PW3 admits in his cross-examination, it is elicited that they are the relatives. The counsel also vehemently contend that the victim was also aged about 80 years, and specific defense was taken that on account of age factor, she fell down and sustained injury and falsely implicated this petitioner, and the same has not been appreciated. For contra, the counsel appearing for the state would vehemently contend that when the PW1 and 2 are the eyewitnesses and their evidence is credible, nothing is discredited in the cross-examination of PW1 and 2, and PW3 is also the owner of the tractor. And he also says that the petitioner was driving the vehicle on the date of the accident, and hence it doesn't require any interference. In reply to the argument, the counsel would vehemently contend that this court can take lenient view considering the age of the victim also, who is aged about 80 years, and also petitioner is aged about 42 years at the time of the accident, and even this court can modify the order and direct the petitioner to pay the compensation instead of undergoing a simple imprisonment as ordered by the trial court. Having heard the petitioner counsel and also the counsel appearing with the respondent and also perusal of material, point that would arise for the consideration of this court whether this court can exercise the revisional jurisdiction. Having heard the respective counsel and also on perusal of material, it is not in dispute that charges are leveled against the petitioner that on 10/9/2015 at about 3:15 p.m. he drove the vehicle in a rash and negligent manner and dashed against the victim Hanmamma, who fell on the road. As a result, he succumbed to the injuries. The witness PW1 is none other than the son of the victim, and PW2 is also supports the case of the prosecution, and PW3 also not disputes the fact that this petitioner was driving the vehicle at the time of the accident. And also having considered the sketch which is marked as Exhibit P7 also, I do not find any error committed by the trial court and appellate court in considering the material available on record. However, taking into note of incident was taken place in 2015, and also the victim was aged about 80 years at the time of the incident. It is appropriate to modify the sentence, reducing the imprisonment to the fine amount, and hence it is appropriate to, instead of 10,000 fine and setting off the imprisonment, order to pay an amount of rupees 1,50,000, and the same is payable within 6 weeks from the from today, and the same is payable in favor of yarri maklaro nodidiraru, PW1 is the son, and the same is also payable in favor of the PW1 since it is an accident and not an intentional act, and hence modified the order of the trial court. New of the discussions made up, I pass the following order. Revision petition is allowed. The judgment of conviction and sentence. The conviction is confirmed, but sentence is modified as fine amount, enhancing the same from 10,000 to 1,50,000, and the sentence of 2 years. No need to undergo the same in view of enhancing of the fine amount. The trial court is directed to release the amount in favor of the PW1 who is the son of the deceased on proper identification. And the petitioner is directed to deposit the amount within 6 weeks. ಅದೇ ಜಾಸ್ತಿ ಕೊಟ್ಟಿರೋದು 6 weeks. ನೀವು ದುಡ್ಡು ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಅಂತ 4 ಬದಲು 6 ಕೊಟ್ಟಿದ್ದೀನಿ. ಮತ್ತೆ ಅದರಲ್ಲೂ ಮತ್ತೆ ಕೇಳೋದು ಸರಿ ಅಲ್ಲ.
Started in hearing matter. R.B. Deshpande.
ಇದೇನ ಹೇರ್ ಮಾಡಿದ್ವಿ ಮೊನ್ನೆಲ್ಲ ಕೇಳಿ ಹೇಳ್ತೀನಿ ಅಂತಲೇ ನಮ್ದು. ಯಾರಿಗೆ ಏಕೆ ಏನ್ ಮ್ಯಾಟರ್ ಹೇಳಿದ್ವಿ?
ಸ್ಯಾಂಡಲ್ವುಡ್ ಕೋರ್ಟ್.
ಸ್ಯಾಂಡಲ್ವುಡ್ ಹಾ ಹಾ ಅವ್ರನ್ನೇನ್ ಕೇಳ್ಬೇಕು ಅಂತಿದ್ವಿ ಸ್ಟೇಟ್ ನ? ಹಾ
Who is concerned, my lord, he filed a review appeal, was partly allowed by law. And considered only for petitioner under section 4, actually 8 KP Act. He is suggested for section 457 and 3A. So for the section 411 and 87 of the Karnataka Parliament, must be such a thing. So for the allegation against this petition is not is the receiver of the sandalwood pieces.
Billets.
Allegation is that in the
This petitioner is the receiver.
So far as the receiver is concerned, my lord, the sandalwood was not recorded from his possession, my lord. Not recorded from his possession. Allegation is that, my lord, accused number 1.
It was not in his possession. Where it was there then?
As per exhibit to piece 7, my lord, the recovery master, my lord, the recovery master was done in the outside of his house, my lord. So that, my lord, he was living in that house, my lord, there is no material.
ಓ ಆ ರೀತಿ ನೀವು ಹೇಳಿದ್ದು. ಆ ಮನೆ ಅವನಿಗೆ ಸೇರಿತ್ತು ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನು ದಾಖಲೆ ಇಲ್ಲ ಅಂತ. ಅದೇ ಮೇನ್ ಗ್ರೌಂಡಾ?
After, my lord, so far as A5 is concerned, my lord, he is the court staff. He also similar case under
He was acquitted.
Nothing is shown, my lord, they are in common intention, my lord, the act was done.
But recovery at whose instance?
Number 1 to 3.
1 to 3. ನಿಮ್ಮವನ್ ಎಷ್ಟು ಅಕ್ಯೂಸ್ ನಂಬರ್?
Number 4 in the original charge.
ಒರಿಜಿನಲ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಯ್ತು. ನಿಮ್ಮವನಿಂದ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅವರು? ರಿಕವರಿ ಏನು ಮಾಡಿಲ್ವಾ? ಮತ್ತೆ
ರಿಕವರಿ ಮಾಡಿದ್ದೀವಿ.
ಮಾಡಿದಾರ? ಏನದು ರಿಕವರಿ?
ಅದು ಪ್ರಾಸೆಸ್ PW70 ನರಸಿಂಹಯ್ಯ ಘಟನೆಯ ಕಾಲಕ್ಕೆ ಹೊಸನಗರ ಠಾಣೆಯ ಮುಖ್ಯ ಪ್ಯಾದೆಯಾಗಿದ್ದು ತಮ್ಮ ಸಾಕ್ಷ್ಯದಲ್ಲಿ ಆರೋಪಿಗಳ ಹೆಸರು ಅದೆಲ್ಲ ತಿಳಿಸಿರ್ತಾರೆ. ಅದನ್ನು ಪಂಚರ ಹಾಗೂ ತನಿಖಾಧಿಕಾರಿಯವರ ಸಮಕ್ಷಮ ವಶಪಡಿಸಿಕೊಂಡು ಮಾಜರ್ ಮಾಡಿರುವುದಾಗಿ ನುಡಿಯುತ್ತಾರೆ. ಕೈಂಡ್ಲಿ ಪೆರೂಸ್ ದ ಪೇಜ್ ನಂಬರ್ 15 ಲಾರ್ಡ್ಶಿಪ್ ಸಿಸಿ ಇದರಲ್ಲಿ. ಸೊ PW17 ಅವರು ಮುಂದುವರೆದು ತಮ್ಮ ಸಾಕ್ಷ್ಯದಲ್ಲಿ ದಿನಾಂಕ 16/11/97 ಆರೋಪಿಗಳು ಹೇಳಿದಂತೆ ಸೊರಬಕ್ಕೆ ಹೋಗಿ 1ನೇ ಆರೋಪಿಯ ಹೇಳಿಕೆಯ ಮೇರೆಗೆ 11 kg 800 ಗ್ರಾಂ ಶ್ರೀಗಂಧವನ್ನು ಸೊರಬದಿಂದ ಚಿಕ್ಕಜಂಬೂರು ಗ್ರಾಮದಲ್ಲಿ 4ನೇ ಆರೋಪಿಯ ಮನೆಯ ಹಿಂಭಾಗದಲ್ಲಿ ದಿಸ್ ಪಿಟಿಷನರ್ 4ನೇ ಆರೋಪಿ 4ನೇ ಆರೋಪಿಯ ಮನೆಯ ಹಿಂಭಾಗದಲ್ಲಿ 6 ಶ್ರೀಗಂಧದ ತುಂಡುಗಳನ್ನು ವಶಪಡಿಸಿಕೊಂಡು ಮಾಜರ್ ಮಾಡಿರುವುದಾಗಿ ನುಡಿದಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ಮುಂದುವರೆದು ದಿನಾಂಕ 17/11/97 ಬ್ರಹ್ಮೇಶ್ವರ ಕಾಡಿನಲ್ಲಿ 3 ಗೋಣಿ ಚೀಲದಲ್ಲಿ ತುಂಬಿಸಿಟ್ಟಿದ್ದ ಶ್ರೀಗಂಧದ ತುಂಡುಗಳನ್ನು ಅಮಾನತು ಪಡಿಸಿಕೊಂಡಿದ್ದು ಮಾರಿಗುಡ್ಡ ಗುರುಭವನದ ಮುಂಭಾಗದಲ್ಲಿ ಕೃತ್ಯಕ್ಕೆ ಉಪಯೋಗಿಸಿದ ಕಬ್ಬಿಣದ ರಾಡು ಮತ್ತು ಬೀಗವನ್ನು ವಶಪಡಿಸಿಕೊಂಡು ಪಂಚನಾಮೆ ಮಾಡಿದ್ದು MO 72 ರಾಡು, MO 73 ಬೀಗ ಮತ್ತು MO 3 ಇಂದ 70 ಅಂದ್ರೆ MO 3 ಇಂದ 70 ಈ ಅಕ್ಯೂಸ್ಡ್ ಮನೆಯಲ್ಲೇನೆ ವಶಪಡಿಸಿಕೊಂಡಿರೋದು
ತುಂಡುಗಳು.
ಸೊ ಈ ಅಕ್ಯೂಸ್ ಮನೆಯಿಂದ ವಶಪಡಿಸ್ಕೊಂಡಿರೋದು ಇದನ್ನೆಲ್ಲ ಪೂರ್ತಿಯಾಗಿ. ಹಾಗಾಗಿ ಇವ್ರಿಗೆನೆ ಸೇಲ್ ಮಾಡಿರೋದು ಇವರೇ, ಇವ್ರ ಮನೇಲಿ ಬಚ್ಚಿಟ್ಕೊಂಡಿದ್ರು ಅಂತಾನೆ ನಾವು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅವರು ಪ್ರೂವ್ ಮಾಡಿರೋದು. ಮೈ ಲಾರ್ಡ್ಶಿಪ್
ರಿಸೀವರ್.
ಈಸ್ ದ ರಿಸೀವರ್.
ಹೇಳ್ರಿ.
Father is conducted on 17/11/1997. So far as this petitioner is concerned, my lord, he obtained the anticipatory bail, my lord, and surrendered before the court on 17/3/1998. From this, it is very clear that, my lord, from his possession, nothing was seized. At the instance of the accused number 123, my lord, they showed the place and they went to the near the according to the prosecution they went to near to the because of the this petition. There they conducted the matter as per exhibit P7 in my absence. So this petitioner
He was not present.
Not present. And that is the reason, my lord, I read the evidence of PW 18 my lord. The investigation officer. The investigation officer clearly stated that, my lord, see the accused number 123, my lord, committed the theft. MP Basappa, PW 18.
He was not present at the time of seizure. No recovery at the instance of this petitioner, only near the house of this petitioner.
The report is done, my lord, there is no material to show that, my lord, he was residing in that place. This is the evidence of PW 18, my lord. 1995 ಏಪ್ರಿಲ್ ಜೂನ್ ತಿಂಗಳಿಂದ 13/8/98 ಹೊಸನಗರದಲ್ಲಿ ಸಿಪಿಐ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು. ಹೊಸನಗರ ಪೊಲೀಸ್ ಠಾಣೆ ನನ್ನ ವ್ಯಾಪ್ತಿಯೊಳಗೆ ಬರುತ್ತಿದೆ. 4/11/97 ಕೇಸಿನ ಮಾಹಿತಿಯನ್ನು ತೆಗೆದುಕೊಂಡು ಈ ಕೇಸಿನ ಆರೋಪಿಗಳು ವಸ್ತುಗಳನ್ನು ಪತ್ತೆ ಮಾಡಲು ಹೊಸನಗರ ಠಾಣೆಗೆ ಭೇಟಿ ನೀಡಿ ಪಿಎಸ್ಐಗೆ ಸೂಚನೆ ನೀಡಿದೆ. 5/11/97 ಕೇಸಿನ ಮುಂದಿನ ತನಿಖೆಗೆ ಮುಖ್ಯಮಂತ್ರಿ ಪಡೆದುಕೊಂಡರು. ಈ ಕೃತ್ಯದ ನಡೆದ ಸ್ಥಳಕ್ಕೆ ಭೇಟಿ ನೀಡಿ 2 ಗಂಟೆಯಿಂದ 9 ಕೃತ್ಯವನ್ನು ಮಾತನಾಡಿದರು. ಸಾಗರ ಸಾಗರ ಮತ್ತು ಹೊಸನಗರ ಗಂಟಾಳು ತುಂಡುಗಳನ್ನು ಕಳ್ಳತನ ಮಾಡುವ 50ರಿಂದ 60 ಜನರ ಪಟ್ಟಿಯನ್ನು ತಯಾರಿಸಿದೆ. ವಶಪಡಿಸಿಕೊಂಡ ಮಾಲುಪಟ್ಟಿ ಅಳವಡಿಸಿ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಕಳುಹಿಸಿಕೊಟ್ಟರು. ಗಂಧ ತುಂಡುಗಳನ್ನು ಕಳ್ಳತನ ಮಾಡುವ 30ರಿಂದ 40 ವಿಚಾರಣೆ ಮಾಡಿ ಯಾವುದೇ ಮಾಹಿತಿ ಇಲ್ಲದೆ ಬರದಿದ್ದ ಕಾರಣ ಅವರನ್ನು ಬಿಟ್ಟು ಕಳಿಸಿದರು. ದಿನಾಂಕ 7/11/90 ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಕರ್ತೆ ಮಾಡುವ ಸಿಬ್ಬಂದಿಯನ್ನು ಕೂಡ ವಿಚಾರಣೆಯನ್ನು ಅನುಮತಿಪಡಿಸಿದರು. 14/11/90 ದ್ಯಾಮಪ್ಪ SDA ಕ್ರಿಮಿನಲ್ ಬ್ರಾಂಚ್ ಪೆಂಡಿಂಗ್ ಇವರನ್ನು ವಿಚಾರಣೆ ಮಾಡಿದೆ. ಅದೇ ರೀತಿ ರತ್ನಮ್ಮ ವೆಂಕಟಗೌಡ ಡಿಸೋಜ ವೆಂಕಟಗೆ ಇವರುಗಳನ್ನು ವಿಚಾರಣೆ ಪಡಿಸಿಕೊಂಡರು. 15/11 ನಾನು ಮತ್ತು ನನ್ನ ಸಿಬ್ಬಂದಿಯರು ಆರೋಪಿಯ ಮಾತನ್ನು ಪತ್ತೆ ಮಾಡುವ ಸಲುವಾಗಿ ದಾಳಿಗೆ ಹೋದಾಗ ಬ್ರಹ್ಮೇಶ್ವರದ ಹತ್ತಿರ ಗಣೇಶ ತಂದೆ ನಾಗಪ್ಪ ಆತನಿಂದ ಒಂದು ಮಾಹಿತಿ ಸಿಕ್ಕಿತ್ತು. ಕೃತ್ಯ ನಡೆದ ದಿವಸ ಬೆಳಗ್ಗೆ 2 ಗಂಟೆಗೆ ಸಮಯ ಒಂದು ತೆಳು ಕಪ್ಪು ಬಣ್ಣದ ಸ್ಕೂಟರ್ ಅವರ ಮನೆ ಹತ್ತಿರ ಸಾಗರ ಹೊಸನಗರ ಬಂದು ಸ್ಕೂಟರ್ ಇದ್ದ ಶಬ್ದ ಬಂದು ನೋಡಲಾಗಿ ಟಾರ್ಚ್ ಬೆಳಕಿನಿಂದ ನೋಡಲಾಗಿ ಅದರಲ್ಲಿ 3 ಜನ ಇದ್ದರು. ಅವರ ಎತ್ತರ ಇದ್ದ ಅಳತೆಗಳನ್ನು ಹೇಳಿ ತಕ್ಷಣ ಕೂಡ ತಿಳಿಸಿ ಅವರು ಕಾಡಿನಲ್ಲಿ ಹೋದರು ಎಂದು ತಿಳಿಸಿದರು. ಸ್ಕೂಟರ್ನಲ್ಲಿ ಹಿಂಭಾಗ ಬೆಂಕಿ ಹಚ್ಚಿಕೊಂಡಿತ್ತು. ಅದಕ್ಕೆ ನಾನು ನೀರು ಹಾಕಿ ಆಡಿಸಿದ್ರೆ ಅಷ್ಟರಲ್ಲಿ ಹಿಂಭಾಗದ ಸ್ಕೂಟರ್ನ ಭಾಗ ಸಿಕ್ಕಿ ಸೀಟು ಮತ್ತು ಹಿಂದುಗಡೆ ಭಾಗ ಹಾನಿಯಾಯಿತು. ಸ್ಕೂಟರ್ ನೋಡಲಾಗಿ ಬಾಕ್ಸ್ ಮತ್ತು ಚೀಲದಲ್ಲಿ ಬಿಳಿ ಬಣ್ಣದಿಂದ ಗುರುತು ಮಾಡಿರುವ ಗಂಧದ ತುಂಡುಗಳಿದ್ದವು ಎಂದು ತಿಳಿಸಿದ್ದಾರೆ. ಗಾಬರಿಯಾಗಿದ್ದಂತಾಗಿ ನಾನು ಒಳಗಡೆ ಹೋಗಿ ಮಾರನೇ ಸ್ಥಳಕ್ಕೆ ಬಂದು ನೋಡಲಾಗಿ 4-4 ವ್ಯಕ್ತಿಗಳು ಹೇಳುತ್ತಾರೆ. ಸುತ್ತಮುತ್ತ ಪ್ರದೇಶದಲ್ಲಿ ಆರೋಪಿಗಳನ್ನು ಹುಡುಕಾಡಿದಾಗ ಆರೋಪಿಗಳು ಸಿಗಲಿಲ್ಲ. 16/11 ನಾನು ಸಿಬ್ಬಂದಿಗಳು ಗಣೇಶ ಸಿಬ್ಬಂದಿ ವ್ಯಕ್ತಿಗಳನ್ನು ಪತ್ತೆ ಮಾಡುವ ಸಾಗರಕ್ಕೆ ಭೇಟಿ ನೀಡಿದೆ. ಆರೋಪಿಗಳು ಸಿಗಲಿಲ್ಲ. ಸಂಜೆ 4 ಗಂಟೆ ಸಾಗರದಿಂದ ವಾಪಸ್ ಹೆಬ್ಬೆಲ್ಲಗಳು ಬರುತ್ತಿರುವಾಗ ರಸ್ತೆಯ ಬಳಿ ಒಂದು ಸ್ಕೂಟರ್ ನಿಂತುಕೊಂಡು 3 ಜನ ಅಪರಾಧಿಗಳು ಇದನ್ನು ರಿಪೇರಿ ಮಾಡುತ್ತಿದ್ದರು. ಅವರು ನನ್ನನ್ನು ನೋಡಿ ಸ್ಕೂಟರ್ ಅನ್ನು ಬಿಟ್ಟು ಕಾಡಿನಲ್ಲಿ ಹೋಗಲು ಪ್ರಯತ್ನಿಸಿದರು. ಅವರನ್ನು ಬೆನ್ನಟ್ಟಿ ಹಿಂಬಾಲಿಸಿ ಇರಿಸಿಕೊಂಡರು. ಅವರ ಹೆಸರನ್ನು ತಿಳಿದಾಗ 1ನೇ ಆರೋಪಿ ಗಜಾನ್, 2ನೇ ಆರೋಪಿ ರಿಯಾಜ್.
ಅದೆಲ್ಲ ಆಯ್ತ್ರಿ. PW 18 ಎವಿಡೆನ್ಸ್ ಎಲ್ಲಿ ಬರುತ್ತೆ ಅಂದ್ರೆ ಅವ್ರ ಮನೆ ಹತ್ರ ಹೋದಾಗ ಇವನೇನೋ ಚೀಲದಲ್ಲಿ ಇಟ್ಕೊಂಡು ತಗೊಂಡ್ ಹೋಗ್ತಾ ಇದ್ದ, ನಮ್ಮನ್ನ ನೋಡಿ ಓಡೋದ. ಆವಾಗ ಗೋಣಿ ಚೀಲದಲ್ಲಿ ಇದ್ದಿದ್ದನ್ನ ನಾವು ಸೀಸ್ ಮಾಡಿದ್ವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇದು ಬೇರೆ ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 4 ಅಲ್ಲಿ ಇವುಗಳಿಂದ 1ರಿಂದ 6 ಎಂದು ಬರೆಯಲಾಯಿತು. ಗೋಣಿ ಚೀಲದ ಗಂಟಿಗೆ ನಂಬರ್ 7 ಎಂದು ಚೀಟಿ ಇರಲಾಯಿತು. ಅವುಗಳನ್ನು ತೂಕ ಮಾಡಿದಾಗ 7 kg 500 ಗ್ರಾಂ ಇತ್ತು. ಅವುಗಳನ್ನು ಮಾಜರ್ ಮುಖಾಂತರ ಅವುಗಳನ್ನು ಅಮಾನತುಪಡಿಸಿಕೊಂಡೆವು. ಸದರಿ ಮಾಜರನ್ನು ಈಗಾಗಲೇ ಪಿಸುಣಿ ಎಂದು ಭರಿಸಲಾಯಿತು. ಅಮಾನತುಪಡಿಸಿ ಮಾಲನ್ನು 40 ಆದೇಶ ಪಡೆದೆ.
ಆದೇಶ ಪಡೆಯಿತು.
ಇವನ್ ಮನೆ ಹತ್ರ 6 ಇದ್ದು ಅಂತ ಇವನ್ ಕಡೆಯಿಂದ ಏನ್ ರಿಕವರಿ ಆಗಿಲ್ಲ ಮೇಡಮ್.
ಇವ್ರ ಕಡೆಯಿಂದಾನೇ ರಿಕವರಿ ಆಗಿರೋದು ಮೈಲಾಕ್ಷ. 1, 2, 3 ಅವ್ರ ಹೇಳಿಕೆ ಆಧಾರದ ಮೇಲೆ ಸಿಕ್ಕಿರೋದು.
ಆಯ್ತು, ಹೋಗಿದ್ದೆ ನೀವು
A4 ಮನೆಗೆ
ಅವ್ನ ಮನೆಯನ್ನ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ ದಾಖಲೆ? ನೀವು
A4 ಮನೆ ಎಲ್ಲಿದೆ ಅನ್ನೋದಕ್ಕೆ ನಾವು ದಾಖಲೆ ಕೊಡದಲ್ಲೇ ಇರ್ಬೋದು. ಆದ್ರೆ ಇವರು ಸಹ ನಾನು ಆ ಮನೇಲಿ ಇರ್ಲಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಯಾವುದೇ ದಾಖಲೆ
ಮನೆ ಅವ್ರು ಹೇಳೋದಲ್ಲ ಮೇಡಮ್. ನೀವು
ಅಲ್ಲ, ಅದು ಇಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅಲ್ಲಿ
ಆರ್ಗ್ಯೂ ಲೈಕ್ ಏನು ಕಾಮನ್ ಇದು ಮ್ಯಾನ್
ಇಲ್ಲಿ
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು. ಅವ್ರು ಕೂಡ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಅವ್ರು ನೆಗೆಟಿವ್ ಪ್ರೂವ್ ಮಾಡೋದ್ ಬರೋದಿಲ್ಲ. You being a senior, ಏನು SPP ಏನ್ ಮಂಗ್ ಮಾತಾಡ್ತಾರೆ?
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಅದನ್ನ ನರೇಟ್ ಮಾಡಿ
ಅವ್ರೇನ್ ಕೊಡ್ಬೇಕು ಮೇಡಮ್?
actually it may be that prosecution may not have produced ಇದ್ರಲ್ಲಿ ಇರೋದು. however kindly produce page number 10 my lordship. However, it is to be noted that
prove the case beyond reasonable doubt ಅಂತ.
yes lordship
ಸರಿ, ಅವ್ನ್ ಮನೆ ಅದು ಸೇರಿತ್ತು ಅನ್ನೋಕಾರ ಏನ್ ದಾಖಲೆ ಕಲೆಕ್ಟ್ ಮಾಡಿದ ನಿಮ್ಮ ಐವೋ? ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಅವ್ನು ಸಿಕ್ಕಿಲ್ಲ.
ಎಲ್ಲಾ
ನಿಮ್ಮ ಪ್ರಕಾರ ಅವ್ನು ಓಡಿ ಹೋದ ಅಂತ ಹೇಳ್ತೀರಿ.
ಬಟ್ ಎಲ್ಲಾ PW 1 to PW 18 ನಾವು ಇದ್ ಮಾಡಿದೀವಿ, ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದೀವಿ. ಎಲ್ರೂ ಸಹ ಸಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ. ಅಂಡ್ ನೋ ಡೌಟ್ ಇಟ್ ಈಸ್ ಟು ಬಿ ನೋಟೆಡ್ ದಟ್ ಸಮ್ ಆಫ್ ದ ಸ್ಟೋಲನ್ ಆರ್ಟಿಕಲ್ಸ್.
What is the incriminating evidence against this petitioner? You point out.
It is to be noted that some of the stolen articles were recovered from the house of the accused number 4 at the instance of other accused. It is not that other accused simply named him.
ಅವನಿಗೆ ಮನೆ ಸೇರಿತ್ತು ಅನ್ನೋದಕ್ಕೆ ಏನ್ ದಾಖಲೆ ತಗೊಂಡಿದ್ದೀರಿ?
That is
ಆ ಮನೆ ಅವನಿಗೆ ಸೇರಿತ್ತು ಅಂತ ತೋರ್ಸಕ್ ಏನ್ ದಾಖಲೆ ಇದೆ?
but once the recovery is shown to be from the house of accused number 1.
Except oral evidence.
oral evidence.
He ran away ಅಂತ. ಹೌದಾ?
ಹೌದು.
He ran away from the spot ಅಂತ. ಎಲ್ಲಿದ್ದೀರಿ ಡಿಸ್ಕಷನ್ ಹೋಗ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಈ ಅಕ್ಯೂಸ್ ಮೇಲೆ A4 ಮೇಲೆ? ರೀಸನಿಂಗ್ ಎಲ್ಲಿದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ವಿಟ್ನೆಸ್ ಗಳು ಮಾಡಿದಾರೆ 18 ಜನ ಆಯ್ತು. ರೀಸನಿಂಗ್ ಇವನನ್ನ ಕನ್ವಿಕ್ಟ್ ಮಾಡಕ್ ಎಲ್ಲಿದೆ ರೀಸನಿಂಗ್? ಕ್ಲಾಸ್ 18.
ಇದು ರೀಸನಿಂಗ್ ಅಲ್ಲಿ ಪ್ರಾಸ 1ರಿಂದ ಪ್ರಾಸ 4ರವರು ನ್ಯಾಯಾಲಯದ ಸಿಬ್ಬಂದಿಗಳಾಗಿದ್ದು ಕಳುವಾದ ವಸ್ತುಗಳು ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣದ ವಸ್ತುಗಳಾಗಿರುವುದರಿಂದ ಈ ಬಗ್ಗೆ ಸಿಬ್ಬಂದಿಗಳು ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳಲು ಬರುವುದಿಲ್ಲ ಅಂತ ರೀಸನಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು ಮೇಡಮ್, ಇವನನ್ನ ಇಂಪ್ಲಿಕೇಟ್ ಮಾಡಕ್ ಏನಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು. ಯು ಬೋತ್ ಆರ್ ನಾಟ್ ಅಸಿಸ್ಟಿಂಗ್ ದಿ ಕೋರ್ಟ್. ಈಗ ರಿವಿಷನ್ ಈಸ್ ಓನ್ಲಿ ಬೈ ದಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 4 ಹೌದಾ? ಅವನನ್ನ ಕನ್ವಿಕ್ಟ್ ಮಾಡಕ್ ಏನಿದೆ ಮೆಟೀರಿಯಲ್? ಏನ್ ರೀಸನ್ಸ್ ಕೊಟ್ಟಾರ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Only discussing about the evidence, nothing is stated, madam. Up to page number 26, madam. All relating to the accused number 1 to 3, madam.
ಆರೋಪಿಗಳಿಂದಲೇ ಮತ್ತು ಆರೋಪಿಗಳ ಉದ್ದೇಶದಿಂದಲೇ ಕಳ್ಳತನ ಮಾಡಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಕೆಲವು ಸೂಚನಾತ್ಮಕ ಪ್ರಶ್ನೆಗಳನ್ನು ಅಭಿಯೋಜಿಸುತ್ತಾರೆ. ನಿಖರವಾಗಿ ಹೇಳಲಾಗಿಲ್ಲ. ತಮ್ಮ ವಾದವನ್ನು ಮಂಡಿಸಲು ಆತನ ಠಾಣೆಯಲ್ಲಿ ಗುರುತಿಸಲು ಸಾಧ್ಯ ಕಾರಣದಿಂದ ಆತ ದೋಷಾರೋಪಣೆ ಹೊರಟಿದ ನಂತರ
Even my lord, appellate court my lord is concerned, my lord, in paragraph 30, my lord, regarding the accused number.
ಫಸ್ಟ್ ಫೌಂಡೇಶನ್ ನೋಡ್ರಿ, ಹೇಳ್ರಿ, ನನಗೆ ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು. ಇವನನ್ನ A4 ನ ಕನ್ವಿಕ್ಟ್ ಮಾಡಕ್ ಎಲ್ಲಿ ಡಿಸ್ಕಷನ್ ಇದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ಇಲ್ಲಿದೆ ನೋಡಿ, ಮೂಲ ಪ್ರಕರಣದಲ್ಲಿ 4ನೇ ಆರೋಪಿ ಮತ್ತು ಈ ಪ್ರಕರಣದ 2ನೇ ಆರೋಪಿಯಾದ ಇಲಿಯಾಸ್ ಅವರ ಪರ ಪ್ರಾಜ್ಞಾ ವಕೀಲರಾದ ಶ್ರೀ ಸೋನ್ ಲಿಖಿತ ಮಾತನ್ನು ಮಾಡಿರುತ್ತಾರೆ. ಇದರಲ್ಲಿ ಮುಖ್ಯವಾಗಿ ಈ ಆರೋಪಿಯನ್ನು ಯಾವುದೇ ಸಾಕ್ಷ್ಯದ ಗುರುತಿಸಿಲ್ಲ ಎಂದು ಪ್ರತಿಪಾದನೆಯನ್ನು ಮಾಡಿರುತ್ತಾರೆ. ಹಾಗೂ ಆ ಮನೆಯು ಆತನಿಗೆ ಸಂಬಂಧಿಸಿದ್ದು ಎಂದು ತೋರಿಸಲು ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸಿಲ್ಲ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. ಆದರೆ ಈ ನಿಟ್ಟಿನಲ್ಲಿ ನ್ಯಾಯಾಲಯವು ಕಂಡ 313 ಅಡಿಯಲ್ಲಿ ಹೇಳಿಕೆಯನ್ನು ದಾಖಲಿಸಿಕೊಂಡಾಗ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ಸುಳ್ಳೆಂದು ಹೇಳಿದ್ದು ತನ್ನ ಪರ ಯಾವುದೇ ಹೇಳಿಕೆಯನ್ನು ನೀಡಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಆತನನ್ನು ಗುರುತಿಸಿಲ್ಲ ಎಂದ ಮಾತ್ರಕ್ಕೆ ಆತ ಈ ಕೃತ್ಯದಲ್ಲಿ ಭಾಗಿಯಾಗಿಲ್ಲ ಎಂದು ನ್ಯಾಯಾಲಯ ಅಭಿಪ್ರಾಯಕ್ಕೆ ಬರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ಸದರಿ ಆರೋಪಿಯ ಪರ ಪ್ರಜ್ಞಾ ವಕೀಲರು ಕ್ರಿಮಿನಲ್ ಸ್ವಂತರಲ್ಲಿ ಮಾನ್ಯ ತ್ವರಿತಗತಿ ನ್ಯಾಯಾಲಯ ಶಿವಮೊಗ್ಗ ಮಾಡಿರುವ ತೀರ್ಪಿನ ದೃಢೀಕೃತ ನಕಲನ್ನು ಹಾಜರುಪಡಿಸಿರ್ತಾರೆ. ಸದರಿ ತೀರ್ಪಿನ ಪ್ರಕಾರ ಮೂಲ ಪ್ರಕರಣದ 5ನೇ ಆರೋಪಿಯನ್ನು ದೋಷಮುಕ್ತಗೊಳಿಸಿ ಮತ್ತು 2ನೇ ಆರೋಪಿ ಮೇಲೆ ಭಾರತೀಯ ದಂಡ ಸಂಹಿತೆಯ ಕಲಂ ಆರೋಪಗಳಿಂದ ಮುಕ್ತಗೊಳಿಸಿರುವುದು ನುಡಿದಿರುತ್ತಾರೆ. ಸದರಿ ಮೇಲ್ಮನೆ ಆದೇಶ ಈ ಇಬ್ಬರು ಆರೋಪಿಗಳಿಗಷ್ಟೇ ಸೀಮಿತವಾಗಿದೆ. ಅಷ್ಟೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೀಸನಿಂಗ್.
Appellate court, madam, in paragraph 13, madam. Appellate court, regarding accused number 4, no doubt, no incriminating material have been used. But the statement of other accused is that they have told the stolen articles to accused number 4 here. However, it is to be noted that some of the stolen articles are recorded from the house of accused number 4. It is not that the other accused simply named him, but no incriminating.
ಯಾವ ಪ್ಯಾರಾ ಓದ್ತಾ ಇದ್ರಿ ನೀವು?
Paragraph 30, madam.
30.
30.
ಹಾ,
regarding the.
No doubt, no incriminating materials have been seized at his instance, but the statement of other accused is that they have sold the stolen properties to accused number 4, Ilyas. However, it is to be noted that some of the stolen articles were recovered from the house of accused number 4 at the instance of other accused. Not that the other accused simply named him, but no incriminating articles were seized. The incriminating articles were seized from his house. May not necessarily be at the instance of the accused number 4, but seizure of incriminating article, even if it at the instance of the other accused, that clearly establishes the nexus between the stolen articles and the accused number 4. The accused number 4 is neither owner nor tenant of the said house. But once the recovery is shown to be from the house of accused number 4 under a Panchanama in the presence of Panchas by the responsible police officer, and when this fact is spoken by these witnesses, burden would be on the accused number 4 to prove the contrary, namely that he has never been in occupation of the said house. That has not been done by the accused number 4, nor he has any documents to show that he is residing somewhere else other than the premises prescribed under Panchanama.
That's what
This
I.
is the reason. I thought. Heard the petitioner counsel and also the counsel for
And 313 statement allೂ ಸಹ ಅವರೆಲ್ಲೂ ಸಹ ನಾನು ಆ ಮನೇಲಿ ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಲಿಲ್ಲ.
313 ನಲ್ಲಿ ಹೇಳ್ಬೇಕಾದ್ರೆ first there must be an incriminating material against him. Then only he can deny it. What is the incriminating materials against him? ಅವಂದೇ ಮನೆಯನ್ನಕ್ ನೀವೇನು ಕಲೆಕ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ, ಅವ್ನು ಓಡಿ ಹೋದ ಅನ್ನೋದಕ್ಕೂ ಅವ್ನು ಯಾರನ್ನು ಐಡೆಂಟಿಫೈ ಮಾಡಿಲ್ಲ, ಅವನ ಆ ಟೈಮಲ್ಲಿ ಬಿಸಾಕ್ ಹೋದ ಅಂತ ನಿಮ್ ಕೇಸ್.
ಮನೆ ಹಿಂದೆನೆ ಇತ್ತು ಅಂತ ನಮ್ ಕೇಸ್.
ಮನೆ ಫಸ್ಟ್ ಅವನು ಹೇಳ್ಬೇಕಲ್ರಿ, ಏನಿದೆ ನೆಗೆಟಿವ್ ಪ್ರೂವ್ ಮಾಡಕ್ಕಾಗುತ್ತ? ಅವನು ನಿಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಂಗಿದೆ, ನೆಗೆಟಿವ್ ಅವ್ನು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು ಅಂತ ಅದನ್ನೇ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿರೋದು ಅಪಲೇಟ್ ಕೋರ್ಟ್ನವರು. ನೆಗೆಟಿವ್ ಎವಿಡೆನ್ಸ್ ಕೊಡಕ್ಕಾಗುತ್ತ ಅವನು? ನೋಡಿ, heard this revision petition is filed against the concurrent finding of trial court and appellate court by the accused number 4, wherein the petitioner was convicted for the offence punishable under section 411. 457 ಇದ್ದಂಗಿದೆ. 457
and 380
with 87 of forest offence, forest act and section 380. ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಪನಿಷ್ಮೆಂಟ್? 3 years. 3 years
and 5,000.
3 years 5,000 for 457 and 380 for 457. ಇವನಿಗೆ ಹೆಂಗ್ರಿ ಅಟ್ರಾಕ್ಟ್ ಆಗ್ತದೆ?
457 380 ಇವ್ರಿಗೆ ಅಟ್ರಾಕ್ಟ್ ಆಗಲ್ಲ ಸೀಸ್ ಮಾಡಿರೋದ್ರಿಂದ. ಸೆಕ್ಷನ್ 87 and ಫಾರೆಸ್ಟ್ ಆಕ್ಟ್ 87 ಮತ್ತೆ IPC 411 ಅಟ್ರಾಕ್ಟ್ ಆಗುತ್ತೆ.
ಎಲ್ಲಿ ಮಾಡಿದಾರೆ? ಅಕ್ಯೂಸ್ ನಂಬರ್ 4 ಗೆಲ್ಲಿದ್ದಾರೆ. $411.
411. 1 year and
ಬಗ್ಗೆ ಆದೇಶ. ಪ್ರತಿಯೊಬ್ಬ ಆರೋಪಿಯು ಭಾರತೀಯ ತಂಡದ ಕಲಂ 457 ಎಲ್ಲರಿಗೂ ಸೇಮ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಲ್ವಾ? 3 years and 5,000 punishment and 1 year and 2,000 rupees for the offence punishment section 380. So also 1 year and a fine of rupees 2,000 for the offence punishment section 411 of IPC. The factual matrix of case of the prosecution is that on 2/11/1997, during 8 hours, accused number 1 along with other accused, that is accused number 2 and 3 na? 2 and 3 broken the lock of the property room of Munsi Fund JMFC Court Hasanagar. Stolen standard load worth of rupees 44,400. Kept in FOC number 894 of 94, PR number 50 of 97. In that sold 400 grams sandal billets to second accused. And scooter number K 17E1326 and 11 kg, 800 grams sandal confined in Mavina Vole forest, 51 kg, 800 grams, in total 71 kgs of sandalwood stolen and thereby committed an offence. And in order to prove the said charges, prosecution examined the witnesses PW 1 to 17 and also got marked document exhibit P 17 and 18, exhibit P 1 to 16 and MO 1 to 73. And the trial court, having considered the evidence available on record, convicted all the accused persons. And the same is challenged before the appellate court by this petitioner. Even matra madangidanalri. This petitioner in criminal appeal number 17 of 13. Howda?
Split agide, split
ಅದಕ್ಕೆ
ಆದ್ಮೇಲೆ
ಇಲಿಯಾಸ್
ಇದು
ತಾನೆ? ಇಲಿಯಾಸ್.
ಇಲಿಯಾಸ್.
And the apex court, appellate court affirmed the judgment of the trial court in giving the reasons in paragraph number 30 and 31. Being agreed by the said concurrent finding, present appeal revision petition is filed under counsel for the petitioner would vehemently contend that the prosecution failed to prove the case against this petitioner and there is no any incriminating evidence against this petitioner. Only allegation is that when they went to seize the sandalwood, he ran away from the spot. But he was not in the house, as well as at his instance, nothing is recovered. And only contention, only case of the prosecution that the house belongs to him, wherein 6 sandalwood billets are seized and punch PW 5. But he has not supported the case of the prosecution with respect to the seizure. The counsel also would vehemently contend that when he was not at the spot and also when the document is not placed before the court, that house belongs to him. The trial court and appellate court ought not to have convicted and confirmed the same. The counsel also brought to notice of this court the judgment of the trial court. With regard to this accused is concerned, an observation is made in paragraph number 50. Trial court made an observation that in 313 statement, accused has not explained the same. And also when he was not identified, and the same cannot be a ground to acquit him. And the appellate court also committed an error in confirming the same when the court comes to a conclusion that no doubt no incriminating materials have been seized at the instance of this petitioner. But the statement of other accused is that they have sold the stolen properties to the accused number 4. And also stolen articles were recovered from the house of the accused number 4 at the instance of other accused. And hence confirmed the same. The very approach of the trial court is erroneous. Per contra, the counsel appearing for the state would vehemently contend that when the recovery is made at the instance of the accused number 1 to 3 in the house of this petitioner, and he was ran away from the spot, and though he has not been identified, and recovery is not at his instance, but the fact that the same was recovered from his house is not in dispute. And accused number 1 to 3 only led the punch witnesses as well as the IO to the house of this petitioner, and hence same is taken note of by the trial court as well as the appellate court, and hence it doesn't require any interference. Having heard the petitioner counsel and also the counsel appearing for the respondent, and also the considering the material available on record, the point that would arise for the consideration of this court are whether the judgment of conviction and sentence passed by the trial court and also the confirmation order passed by the Appellate court requires interference of this court exercising the revisional jurisdiction. What order? Having considered the material on record, charges leveled against this petition is that he had received the sandalwood and the same was stolen article, and the same is also recovered in the house of this petitioner. It is important to note that no doubt prosecution examined several witnesses, PW 1 to 18, and also got marked several documents. And it is the case of the prosecution that accused number 1 to 3 led the investigation team as well as punch witnesses to the house of this petitioner. It is the case of the prosecution also that he ran away from the spot and they seized the sandalwood in the house of this petitioner. And in order to prove the factum that this petitioner was having the house and no such material is collected by the IO that the house belongs to this petitioner. It is also important to note that not the recovery and the same is not in the conspicuous possession of this petitioner. And only statement of other accused is that they have sold the stolen properties to this petitioner, but not recovered the same at the instance of this accused. And though content that the same was recovered from the house of this petitioner at the instance of the other accused, but no any incriminating evidence against this petitioner. And the same is also observed by the appellate court in paragraph number 30, but comes to the conclusion that seizure of incriminating articles even if it is at the instance of the other accused, that clearly establishes the nexus between the stolen articles and the accused number 4. And in order to show the nexus also, nothing is placed on record except the statement of co-accused. On the basis of co-accused statement, the petitioner cannot be convicted. It is also important to note that the appellate court made an observation that once the recovery is shown to be from the house of accused number 4 under a panchanama in the presence of panchas by the responsible police officer, and when this fact is spoken to by the witnesses, burden would be on the accused number 4 to prove the contrary, namely that he has never been in occupation of the said house. The appellate court committed an error in making such an observation, and at the first instance, it is burden on the prosecution to prove the same. And in order to prove the same, no document is collected to show that the house belongs to this petitioner, and also no recovery at the instance of this petitioner. And recovery is also at the instance of accused number 1 to 3. And only accused number 1 to 3 made the statement that house belongs to them. And in order to prove the fact that the same belongs to the house of the belongs to this petitioner, nothing is placed on record. And the appellate court made an observation of proving the same in a negative manner, that the accused and major witnesses have spoken about the same, and hence the accused has to disprove the same. That is not the principles in a criminal jurisprudence. To accused has to prove, and accused only can give an explanation and explain the same if incriminating evidence is placed against the accused and nothing is on record, any incriminating evidence against the accused. And when such being the case, question of explanation under section 313 also doesn't arise. Both the trial court and also the appellate court proceeded in an erroneous approach. And the trial court gives the reasons that in 313 statement not been explained. And I have already made it clear that unless incriminating evidence is placed before the court, question of explanation doesn't arise under section 313. And appellate court also in paragraph number 30 and 31 committed an error in placing on the burden on the accused to prove the same. And hence, the very finding of the trial court is not legal. And also the judgment of conviction and sentence passed by the trial court as well as the appellate courts suffers from its legality and correctness. And hence, it requires interference of this court. And hence, I answered the point as affirmative. In view of the discussions made above, I pass the following order. Revision petition is allowed. The impugned judgment of conviction and sentence is set aside, and consequently, the affirmation made by the appellate court is also set aside. The accused is acquitted for the offences invoked against him, and if any fine amount is deposited, order to release the same in favor of the petitioner and proper identification. The bail bond executed by the petitioner is hereby stand cancelled.
68.
68. ತಪ್ಪಣ್ಣನವ್ರು ಏನೋ ಹೇಳಿದ್ರಲ್ರಿ ಬೆಳಗ್ಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತ ಅದರ್ ಸೈಡ್ ಇದಾರ petitioner counsel seeks time on the ground of 11th and counsel for the respondent absent. List this matter on other date ಕೊಡಿ 5-3
69. Abhijit
69 Abhijit HM. ಯಾವಾಗ ಬಂದಿರೋ ಯಾವಾಗ ಆಮೇಲೆ ಬಂದಿಲ್ವಾ? Petitioner counsel absent, HCGP is present. However, one more opportunity is given to the petitioner counsel since matter was last listed on 21/2/24 and thereafter not listed. If petitioner counsel doesn't appear, petition will be dismissed in the next date of hearing.
5-3.
5-3.
70.
Dilraj Root Joyt. Sorry, petitioner counsel in the first instance sought time and this court refused to grant time since this is the revision petition of the year 21. However, no representation in the afternoon. And in the ends of justice, one more opportunity is given and HCGP is present. List this matter on 5-3.
71.
Nataraj Sharma. Hmm.
54 is not ready.
54. Again, offenses section 32 and 38.
38. But there were so many informative. Even in the judgment also, that they are committed by the trial court. Appreciating the evidence. There are 5 witnesses that have been examined. Out of 5 witnesses, 4 are witnesses of the official witnesses. Only 1 witness, that is PW1, is a independent witness, cannot he is third or last time. And
Iga, law is very clear. Even if they are official witnesses, if their evidence is credible, the court cannot disbelieve the same. If the evidence is not credible, then court has to take into note of the same in a meticulous manner and consider the same. Only because they are the official witnesses and also the raiding parties and their evidence cannot be discarded. And only on that ground. That is the law. ಹೇಳಿ ಏನ್ ಡಿಸ್ಕ್ರಿಪೆನ್ಸಿಸ್ ಇದೆ ಅನ್ನೋದನ್ನ ಹೇಳಿ ತೋರಿಸಿ ಎವಿಡೆನ್ಸ್ ಕೊಡಿ. ಮೊನ್ನೆನೂ ನಾನು ಮಾಡಿದ್ದೀನಿ ಯಾವ್ದೋ ಒಂದು ಸೆಕ್ಷನ್ 32 ನಲ್ಲಿ. ಏನ್ ಅಲಿಗೇಷನ್ ಏನ್ ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಹೇಳಿ. ಶಾಪ್ ಅಲ್ಲಿ ಲಿಕ್ವರ್ ಮಾರ್ತಿದ್ದಂತನಾ?
2 liters 430 ml of the the tetra packs which is used by the measured by the official.
ಮೋಸ್ಟ್ಲಿ 4 ಲೀಟರ್ ವರೆಗೂ ಪರ್ಮಿಷನ್ ಇದೆ ನೋಡ್ರಿ ಎಕ್ಸೈಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ.
2016 and this case happened. This case happened. It was 2 liters. ಆದ್ಮೇಲೆ amendment 2017 ಅಲ್ಲಿ. But judgment ಬರೋ ಟೈಮ್ಗೆ that amendment was actually existent that has been considered with the trial court.
ಯಾವ ಇಯರ್ ಇದು ಇನ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು? 2016. 16 ಅಲ್ಲೂ ಇತ್ತು ನೋಡ್ರಿ ಇದು. ನೀವು ಒಂದು ಲಿಮಿಟೆಡ್ ಕ್ವಾಂಟಿಟಿ ಏನೋ ಇಟ್ಕೋಬಹುದು ಅಂತ ಇದೆ, ಪರ್ಮಿಷನ್ ಇದೆ ನೋಡಿ.
2 liters 300 ml ಅಂತಿದೆ. ಇವ್ರ ಹತ್ರ
ಇಲ್ಲಿರೋದು 2000 2 liters 430 ನಾ?
430
ಆಯ್ತು. ಏನ 54 ಅಂದ್ರೆ ಏನೋ ಕೊಡಿ ನೋಡೋಣ. ಯಾವ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಕವರ್ಡ್ ಬೈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂದ್ರೆ ಏನ್ ನೋಡೋಣ ಕೊಡಿ. $480 ml ನ 7 ಹೈ ವಾಟ್ಸ್ ಚಿಯರ್ಸ್ ವಿಸ್ಕಿ ಮದ್ಯದ ಟೆಟ್ರಾ ಪ್ಯಾಕೆಟ್ಗಳು ಮತ್ತು 90 ml ನ 13 ಹೈ ವಾಟ್ಸ್ ಚಿಯರ್ಸ್ ವಿಸ್ಕಿ ಮದ್ಯದ ಟೆಟ್ರಾ ಪ್ಯಾಕೆಟ್ಗಳನ್ನು ಅಕ್ರಮವಾಗಿ ಇಟ್ಟುಕೊಂಡು ಮಾರಾಟ ಮಾಡುವುದರ ಮೂಲಕ ಕರ್ನಾಟಕ ಅಬಕಾರಿ ಕಾಯ್ದೆ 38 ಅಡಿಯಲ್ಲಿ ಇದ್ದಾರೆ. Evidence witness ಕೊಡಿ ನೋಡೋಣ.
Search for before wait for it is a mandatory provision. That was even affects for time.
ನೀನೇನ PW1 ನಾನು ಅಬ್ಕಾರಿ ಇಲಾಖೆಯಲ್ಲಿ ಸಹಿ ಮಾಡಿದ್ದೆ ಅಂತಾನೆ.
ಇಲಾಖೆಯಲ್ಲಿ ಹೋಗಿ ಸೇಲ್ ಮಾಡ್ತಾರೆ. He is a person who is actually taken as part other all the statements which are given by the witness.
Then go to the PW2 na.
PW2.
ಶ್ರೀನಿವಾಸ ರಸ 2.
It is all
ಅಬ್ಕಾರಿ ರಕ್ಷಕ.
empty category PW1 ಅದರಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಅಂತ.
Exhibit 7 is warrant, my lordship.
ಒಂದೇ ನಿಮಿಷ.
It is obtained afterwards. After the merger is conducted.
Search warrant.
After merger. This place in the is admitted with the DO itself, the FIR.
I know, slow motor. Information ಬಂದಿರೋದು.
Report itself is doubtful.
Which report?
The analysis, chemical analysis report.
ಯಾವ್ದು ಮಾರ್ಕ್ ಆಗಿರೋದು ಯಾವ್ದು ಹೇಳಿ?
P8.
P8.
ಇದರಲ್ಲಿ how much quantity of liquor has been drawn for a test ಅನ್ನೋದು ಎಲ್ಲೂ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. The report only says ಈ ಮೇಲಿನ ವಲಯ ಸಂಬಂಧವಾಗಿ ರಾಸಾಯನಿಕ ಪರೀಕ್ಷೆಗೆ ಕಳುಹಿಸಿದ ವಸ್ತುಗಳು ಸೂಕ್ತವಾಗಿ ಕಚೇರಿಯಲ್ಲಿ 38 the same answer 38 only they sent from the Kolar. Same day they received 2016 ಪಡೆದು ಅವುಗಳ ಮೇಲಿನ ಮೊಹರುಗಳು ಸಂಬಂಧಿಸಿದ ಮಾದರಿ ಮೊಹರುಗಳು ಒಂದೇ ಸಮನಾಗಿ ಮತ್ತು ವಿವರಗಳು ಸರಿ ಹೊಂದುತ್ತದೆ. The sealed covers are similar, that's all. And coming to the point of the next report which is submitted by the analysis, Highward shares whiskey 7 tetra packetಗಳು 180 ml. What is the quantity he has drawn for a testing is not mentioned here. Coming to the point of the same contradicting with the witness, the statement of a witness, he clearly says that the category which is produced before the court when he is on the walk, he says clearly that it is an empty box category. ಅದಕ್ಕೆ ಇಲ್ಲಿ PW1 ಬರ್ತೀನಿ. ಅದು ನಾನು ಒಟ್ಟು 2-3 ಸಹಿಗಳನ್ನು ಮಾಡಿದ್ದೇನೆ. ಅದು ನಾನು ಅಬಕಾರಿ ಇಲಾಖೆಯಲ್ಲಿ ಸಹಿ ಮಾಡಿದ್ದೆ. ಮುದ್ದೆಮಾಲುಗಳು ಮಹಜರ್ ದಿನ ಇದ್ದ ಹಾಗೆ ಈದೇನೋ ಇದೆ ಅಂದರೆ ಸರಿ. ಮುದ್ದೆಮಾಲುಗಳು ಖಾಲಿ ರೂಪದಲ್ಲಿ ಇದ್ದಾವೆ ಎಂದರೆ ಸರಿ. It is an entry computed even when he identifies in that before the trial court. Coming to the PW2, my lord. Statement of a PW2. Official witness law. As I said, it is very contradicting to his own statement in the voluntary statement. ನಾನು ಹೇಳಿದಂತೆ ಸ್ಥಳಕ್ಕೆ ಹೋದಾಗ ಯಾರು ಇರಲಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಗೌನಪಲ್ಲಿ ಗಸ್ತಿಗೆ ಹೋದಾಗ ಸಂಜೆ 5:30 ಗಂಟೆಗೆ ಸಮಯ ಆಗಿತ್ತು. ಗೌನಪಲ್ಲಿಯಿಂದ ತಾಡ್ಕೋಲ್ ಕ್ರಾಸಿಗೆ 15 ನಿಮಿಷದ ಅಂತರ ಇರುತ್ತದೆ. ನನಗೆ ಖುದ್ದು ಮಾಹಿತಿ ಇಲ್ಲ. ತಾಡ್ಕೋಲ್ ಕ್ರಾಸಿಗೆ ಹೋಗುವಂತೆ ಮೊದಲು ನನಗೆ ತಿಳಿಸಲಿಲ್ಲ. ನಮ್ಮ ಜೀಪಿನಲ್ಲಿ ನಮ್ಮ ಸಿಬ್ಬಂದಿ ವರ್ಗದವರು ಮಾತ್ರ ಇದ್ದರು. He says that in the voluntary statement he receives information at about 7 p.m. From the place of incident and the place where he was there was nearly about 10-15 kilometers. He is able to reach in 15 minutes. He himself accepts my lord, but he reaches the spot around 7 o'clock. And as soon as he receives the information, he reaches exactly at 7 p.m. itself. 7 p.m. he receives the information. 7 p.m. he reaches the spot incident. And he makes a merger between 7 to 8 p.m. By calling all the officials, 4 officials to the past in different destinations, from different destinations. It is very doubtful and unbelievable. Coming to the another statement, PW3 ಅವರು ಹೇಳ್ತಾರೆ, ನಾನು 2011ರಿಂದ ಅಫಿಷಿಯಲ್ ಆಫ್ ದ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಈವರೆಗೆ ಶ್ರೀನಿವಾಸಪುರ ಅಬಕಾರಿ ಇಲಾಖೆಯಲ್ಲಿ ಅಬಕಾರಿ ಉಪನಿರೀಕ್ಷಕನಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದೇನೆ. ಈ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 24/8/2016 ತಾಡ್ಗೋಲ್ ಕ್ರಾಸಿನ ಮಂಜುನಾಥ್ ಎಂಬುವರ ಚಿಲ್ಲರೆ ಅಂಗಡಿ ಒಳಗೆ ಪರಿಶೀಲನೆಗಾಗಿ ಹೋದಾಗ ಆ ಸಮಯದಲ್ಲಿ ಬೇರೆ ಸ್ವತಂತ್ರ ಸಾಕ್ಷಿದಾರರು ಸಹಕರಿಸುತ್ತಿದ್ದಾಗ ನಾನು ಮತ್ತು ನಮ್ಮ ಸಿಬ್ಬಂದಿ ವರ್ಗದವರು ಸೇರಿ ಚಾಸ 1 ಮತ್ತು 2 ಕರೆಸಿ ಪಂಚರಾಗಿ ಅವರನ್ನು ಬರಮಾಡಿದರು. Coming to the point, coming to the statement of a PW3 and the he says there are 2 witnesses which were already present before the start. ಅವರಿಂದ ನಾನು PW1 and he turned hostile. PW6 is also turned hostile. He has not been examined. ಅವ್ರು ಕೂಡ ಹೇಳ್ತಾರೆ ಸುಮ್ಮನೆ ಅವ್ರಿಬ್ಬರನ್ನು ಕರೆಸ್ಕೊಂಡು ನಾವು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದೆ ಅಂತ. PW3 ಹೇಳ್ತಾರೆ ಅಲ್ಲಿ ಯಾರು ವಿಟ್ನೆಸ್ ಇಲ್ಲದೆ ಕಾರಣದಿಂದ ನಾನು ಬೇರೆಯವ್ರನ್ನ ಕರೆಸ್ಕೊಂಡೆ ಮಾಡಿದೆ.
All the contradicting the statements made by this is not appreciated by the trial court. Coming to the melody, even that shop belongs to whether the shop belongs to the accused or not is also not proved before the trial court.
ಡಾಕ್ಯುಮೆಂಟ್ ಮಾರ್ಕ್ ಮಾಡಿದಾರೆ ನೋಡ್ರಿ.
ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಪಂಚಾಯತಿ ಹಾಕಿದ್ದಾರೆ, ಅದ್ರಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಅವರೇ ಒಪ್ಕೊಂತಾರೆ, ಅಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯಾದಂತ ಇವರಿಗೆ ಅಕ್ಯೂಸ್ಡ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಂತ ಶಾಪುಗಳು ಇರ್ಲಿಲ್ಲ ಅಂತ.
ಆ ಪ್ರಿಮೈಸಸ್ ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ ಅಕ್ಯೂಸ್ಡ್ ಅನ್ನಕ್ಕೆ ಮಾಡಿದಾರೆ ನೋಡ್ರಿ.
ನಾಟ್ ಅಕ್ಯೂಸ್ಡ್ ಅಂತ ಹೇಳಿ ಇರ್ತಾರೆ ಪಂಚಾಯತಿ ಇದ್ರಲ್ಲಿ ಲೆಟರ್ ಅಲ್ಲಿ, ಈ ಅಕ್ಯೂಸ್ಡ್ ಗೆ ಸಂಬಂಧಪಟ್ಟಂತ ಯಾವುದೇ ಮನೆ ಇಲ್ಲ
ಅಂತ ಕೊಟ್ಟಿದಾರಾ?
ಹೌದು, ಪಂಚಾಯತಿ ಪಂಚಾಯತಿ ಲೆಟರ್ ಅಲ್ಲಿ ಇದೆ. ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳಿಂದ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ತಮ್ಮಲ್ಲಿ ಕೋರುವುದೇನೆಂದರೆ ದಿನಾಂಕ 24/8/2016 ವಿಷಯದಲ್ಲಿನ ಆಪಾದಿತರ ಚಿಲ್ಲರೆ ಅಂಗಡಿ ಮುಂಗಾಳದಲ್ಲಿ 2 ಲೀಟರ್ 2.430 ಲೀಟರ್ ಮದ್ಯವನ್ನು ಭರ್ತಿ ಮಾಡಿ ಮಂಜುನಾಥ್ ಮುನಿಯಪ್ಪ ವಯಸ್ಸು 48 ಜನಾಂಗ ಅಮ್ಮವಾರಿಪಲ್ಲಿ ಗ್ರಾಮ ತಡಗಲು ಇವರ ಮೊಕದ್ದಮೆ ದಾಖಲಾಗಿರುತ್ತದೆ. ಅದರಿಂದ ಮೇಲಿನ ಮದ್ಯದ ದಾಸ್ತಾನು ಜಪ್ತಿ ಮಾಡಿದ ಚಿಲ್ಲರೆ ಅಂಗಡಿ ಯಾರ ಮಾಲೀಕತ್ವದಲ್ಲಿ ಇರುತ್ತದೆ ಹಾಗೂ ಅಪಾದಿತನಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಇತರೆ ದಾಖಲಾತಿ ಪತ್ರಗಳನ್ನು ತಮ್ಮ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಟ್ಟಡಗಳನ್ನು ಪರಿಶೀಲಿಸಿ ತಮ್ಮ ಹೆಸರು ಮತ್ತು ಹುದ್ದೆಯೊಂದಿಗೆ ದೃಢೀಕರಣ ಪತ್ರವನ್ನು ನೆನಪುರಿಸುತ್ತೇನೆ. ಅದರಲ್ಲಿ ಅವ್ರು ಕೊಡ್ತಾನೆ ಸುಮ್ಮನೆ ದೊಡ್ಡಗೌಡ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಾರ್ಯಾಲಯ. ಈ ವಿಷಯಕ್ಕೆ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ಕೋರುವಂತೆ ಮಂಜುನಾಥ್ ಅವರ ಪೆಟ್ಟಿಗೆ ಅಂಗಡಿ ದಾಖಲೆಗಳ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಗ್ರಾಮ ಪಂಚಾಯತಿಯಲ್ಲಿ ದಾಖಲೆಗಳು ಇರುವುದಿಲ್ಲ. ಸದರಿ ಮಂಜುನಾಥ್ ಮತ್ತು ಮುನಿಯಪ್ಪ ಮುನಿಯಪ್ಪ ಎಂಬುವರು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಪರವಾನಗಿ ಇಲ್ಲದೆ ರಸ್ತೆ ಪಕ್ಕದಲ್ಲಿ ಪೆಟ್ಟಿಗೆ ಅಂಗಡಿ ಇಟ್ಟುಕೊಂಡಿರುತ್ತಾರೆ. ಅದರಂತೆ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ತಮಗೆ ಮೊಹರನ್ನು ನೀಡಲಾಗಿದೆ ಅಷ್ಟೇ ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಅವ್ರದ್ದು ಅನ್ನೋದಕ್ಕೆ, ಅವ್ರ ಹೂವು ಅನ್ನೋದಕ್ಕೆ, ಅವ್ರ ಶಾಪ್ ಅವ್ರ ಹೆಸರಲ್ಲಿ ಇತ್ತು ಅನ್ನೋದಕ್ಕೆ ಯಾವುದೇ ರೀತಿಯಾದಂತ ದಾಖಲೆ.
Yes, counsel, help.
ಸರ್ಚ್ ವಾರೆಂಟ್ ಸೆಕ್ಷನ್ 54 ನಾವು ಇವ್ರು ಹೇಳ್ತಾರೆ ಸೆಕ್ಷನ್ 54 ನಾವು ತಗೊಂಡಿಲ್ಲ ಅಂತ, ಸರ್ಚ್ ವಾರೆಂಟ್ ಇಲ್ಲ ಅಂತ. ಬಟ್ ಎಕ್ಸಿಬಿಟ್ 7 ವಿಲ್ ಶೋ ದಟ್ ಸರ್ಚ್ ವಾರೆಂಟ್ 6:30ಗೆ ಅವ್ರಿಗೆ ಇದ್ರ ಬಗ್ಗೆ ವರ್ತಮಾನ ಸಿಗೋದು. ಸೊ 7 o'clock ಅಷ್ಟರಲ್ಲಿ ಅವ್ರು ಸರ್ಚ್ ವಾರೆಂಟ್ ತಗೊಂಡು 7 o'clockಗೆ ಅಲ್ಲಿ ರೀಚ್ ಆಗ್ತೇವೆ ಅಂತ. ಸೊ ಸರ್ಚ್ ವಾರೆಂಟ್ ನಾವು ಫಾಲೋ, ಎಲ್ಲ ಪ್ರೊಸೀಜರ್ಸ್ನು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಫಾಲೋ ಮಾಡಿ. 24/8/2016 ಅಂಡ್ ಇದ್ರು ಸಹ ಇನ್ಸ್ಟೆನ್ಸ್ ನಡೆದಿರೋದು ಸಹ 24/8/16.
After search has been conducted.
ಎರಡೂ ಸಹ ಸೇಮ್ ಡೇ ಇದೆ.
11:10 PM. When the accused was produced before the honorable court, the search warrant has been taken. ಇದರಲ್ಲಿ ಅವರೇ ಒಪ್ಕೊಂತಾರೆ ಸ್ವಾಮಿ. ಫಸ್ಟ್ ಪ್ರೈಮರಿಲಿ and the first information report itself, ಅವರು it is admitted by the IO itself. ಇದರಲ್ಲಿ ಸ್ವಾಮಿ FIR
ಇದು 11:30 ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ ಸರ್.
ಅಪರಾಧಿ ಕಾಯ್ದೆ ಶೋಧನಾ ಸಮಯದಲ್ಲಿ ಶೋಧನಾ ಸಮಯದಲ್ಲಿ ಸಾಕ್ಷಿದಾರರಾಗಿ ಹಾಜರಿರಬೇಕೆಂದು ನಂತರ ನ್ಯಾಯಾಲಯದಿಂದ ಶೋಧನಾ ವಾರೆಂಟ್ ಪಡೆಯಲು ಕಾಲಾವಕಾಶವಿಲ್ಲದ ಕಾರಣ ಕರ್ನಾಟಕ ಅಬಕಾರಿ ಕಾಯ್ದೆ 1964 ಪ್ರಕರಣ ಸ್ಥಳದಲ್ಲಿಯೇ ಶೋಧನಾ ಸಮುಚ್ಚದ ಆಧಾರ ತಯಾರಿಸಿ conducted the murder on the spot, and later when the accused was produced before the court, yes, taken the search warrant.
Yes. I am reading this only.
6:30ಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಬಂದಿರುತ್ತೆ 7 ಸೇಮ್ ಡೇ ಅದೇನೆ ಸರ್ಚ್ ವಾರೆಂಟ್ ತಗೊಂಡ್ ನಂತರನೇ ಸೀಸ್ ಮಾಡಿರೋದು ಲಕ್ಷ.
ಸರ್ಚ್ ವಾರೆಂಟ್ ತಗೊಂಡಿಲ್ಲ ಮೇಡಮ್.
ಇಲ್ಲಿ ನಾನು ಶೋಧನಾ ವಾರೆಂಟ್ ತಯಾರಿಸಿಲ್ಲ ಎಂದರೆ ಸರಿ ಇಲ್ಲ ಅಂತ ಡಿನೈ ಮಾಡಿದ್ದಾರೆ.
ಅಕ್ರಮವಾಗಿ ತೆರಿಗೆ ರಹಿತ ಮದ್ಯ ವಿದೇಶಿ ರೀತಿಯ ಭಾರತ ತಯಾರಿಕೆ ಮಧ್ಯೆ ಸಾಗಾಣಿಕೆ ಮಾರಾಟ ಮಾಡುವುದಾಗಿ ದೊರೆತ ಖಚಿತ ವರ್ತಮಾನದ ಮೇರೆಗೆ ನಾನು ಸಿಬ್ಬಂದಿ ಸಹಿತ ಸದರಿ ಸ್ಥಳಕ್ಕೆ ಪಂಚನಾಮೆ ಸಮಕ್ಷ ಹಾಜರಾಗಿ ಸೂರ್ಯವನ್ನು ಪ್ರಾರಂಭಿಸಿದೆನು. ಸದರಿ ವರ್ತಮಾನವು ನನಗೆ ಸಂಜೆ 6:30 ಗಂಟೆಗೆ ಮೊದಲು ದೊರೆತಿದ್ದು ಶೋಧನಾ ಕಾರ್ಯ ನಡೆಸಲು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಿಂದ ಸಮುಚಿತ ಆಧಾರ ಪಡೆಯಲು ಸಾಕಷ್ಟು ಸಮಯಾವಕಾಶ ಇಲ್ಲದ ಪ್ರಯುಕ್ತ ನಾನು ವಿಳಂಬ ಮಾಡಿದರೆ ಅಪರಾಧಿಯು ತಪ್ಪಿಸಿಕೊಳ್ಳುವ ಕೃತ್ಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಸಾಕ್ಷ್ಯಾಧಾರವನ್ನು ವಸ್ತುಗಳನ್ನು ಮರೆಮಾಚುವ ನಾಶಪಡಿಸುವ ಸಾಗಿಸುವ ಸಂದರ್ಭವಿದ್ದುದರಿಂದ ನಾನು ತಕ್ಷಣ ಸದರಿ ಸ್ಥಳಕ್ಕೆ ಧಾವಿಸಿ ಪ್ರಕರಣಾಧೀನ ದತ್ತವಾದ ಅಧಿಕಾರದ ಮೇರೆಗೆ ಶೋಧನಾ ಕಾರ್ಯ ಜರುಗಿಸಿದ ಬಗ್ಗೆ ಸದರಿ ವರದಿಯನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಒಪ್ಪಿಸುತ್ತಿದ್ದೇನೆ. ಅಂದ್ರೆ ಫಸ್ಟ್ ಕಂಡಕ್ಟ್ ಮಾಡಿ ಆಮೇಲೆ ಇಂಟಿಮೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದು ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ ನಿಮ್ದು. ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದಿರಲ್ಲ ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ ನೋಡಿ ಇದೆ. When the respondent seizing the liquors without obtaining the warrant or word ಇದೆ ನೋಡಿ, not recording the reasons under section 54 of the Excise Act, seizing the articles and thereafter registering the FIR amounts to an investigation commenced prior to registering the FIR, which is mandatory in CRPC. But here they have given the reasoning why they have not obtained the search warrant. Chances of ಎಸ್ಕೇಪಿಂಗ್ ಅಂತ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ರೀಸನ್ಸ್ ಕೊಟ್ಟು ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ಇನ್ಯಾವುದು ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅದು. ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೇಳಿ? On perusing of the above said authority, it is clear that now they has to be complied. The warrant for search and seizure should be obtained for the offences under section 32, 33, 34, 36 and 37. It is only in the event of contingency, section 54 provides for search and seizure by excise officials without warrant to prevent the offender escaping or concealing the evidence that may be found against the accused. Antide. Houda? Whatever the information that the commissioner of excise police officer received regarding commission of offence punishable section so and so. A reason ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು.
ರೀಸನ್ ಇದೆ ನಮ್ದು.
ಎಕ್ಸಿಬಿಟ್ P7 ಅಲ್ಲಿ.
P7 ಅನ್ನು ನೋಡಿದ್ರೆ ಟೈಪ್ಡ್ ಕಾಪಿ.
ಟೈಪ್ಡ್ ಕಾಪಿನೇ ಇದೆ.
ಟೈಪ್ಡ್ ಕಾಪಿ ಗ್ಯಾಪ್ಸ್ ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ ಇರ್ತಕ್ಕಂಥದ್ದು they have a ready form. What are reason has to be given. ಆ ರೆಡಿ ಫಾರ್ಮ್ ಅನ್ನು ಕೋರ್ಟ್ ಮುಂದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಕೊಟ್ಟಿದ್ದಾರೆ. Just date ಮತ್ತು ಇದನ್ನು fill ಮಾಡಿ. Even all the statements, my lord, I request your lordship to come to the statement, all serious statements. ಯಾವ್ದು ಇದ್ರಲ್ಲಿ even
ಆಯ್ತು, ನೀವು ಹೇಳಿದಿರಿ ಅದ್ರ ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಹೇಳಿದಿರಿ. ಹೇಳಿ ಮೇಡಮ್, ಇನ್ನೇನಾರು ಹೇಳದಿದ್ಯಾ ನೀವು? ಅಷ್ಟೇ, ದಟ್ಸ್ ಆಲ್. ನೋಡಿ, not the petitioner counsel and also the counsel appearing for the state. The factual matrix of case of prosecution is that on (24/8/2016) at about 7 p.m. based on the credible information of selling of liquor without any permission in the shop, went and conducted the raid. and found 180 ml 7 high watts Cheers whiskey tetra packet and 90 ml 13 high watts Cheers whiskey tetra packet. In total 2 liters 430, 2.430 liters the liquor, and Mazar was drawn and seized the same in the presence of punch witnesses and registered the case and investigated the matter and filed the charge sheet invoking the offence punishable section 32 and 38A of Karnataka Excise Act. The cognizance was taken and accused was secured. He did not plead guilty and hence prosecution relied upon the evidence of PW 1 to 5 or 6, 1 to 5 and got marked document exhibit P 1 to 8. And accused was subjected to 313 statement and not led any defense evidence. And MO 1 and 2 are also marked. The trial court, having considered the evidence of PW 1 to 5, comes to the conclusion that prosecution has proved the case against the petitioner and convicted him for the offence punishable section 32 and 38. Imposed 1.5 year sentence and 10,000 fine. In default, 5 months for the offence under section 32 and in respect of offence under section 38, 1 year with rigorous imprisonment. Rigorous, madam. Rigorous imprisonment and a fine of rupees 10,000 in case of default 3 months. Being agreed by this conviction and sentence, appeal is filed in criminal RP, criminal appeal number 28 of 2020. And the appellate court also on reassessing the both oral and documentary evidence confirmed the judgment of the trial court. Considering the evidence of PW 2 to 5, official witnesses who have deposed in consonance of official rounds at about 5:30 p.m. near Tadi Goal Cross and drawn the measure and accepted the evidence of PW 2 to 5 and confirmed the same. Being agreed by the conviction and sentence, present revision petition is filed before this court. And counsel appearing for the petitioner would vehemently contend that both the courts have committed an error in appreciating the evidence available on record, and perversity is found in the finding, since there are contra evidence in the evidence of PW 2 to 5 and PW 1, though he is an independent witness, he has not supported the case of the prosecution. The counsel also would vehemently contend that PW 2 says that when he was in official rounds at 5:30 p.m. on the date of the incident, he had participated in the raid. And according to the PW 2, credible information was received at 5:30 p.m. but raid was conducted at 7 p.m. And PW 2 to 5 are also the government officials and their evidence has been accepted. And both the courts ought to have meticulously analyzed the evidence when the PW 2 to 5 are the official witnesses and also the raiding parties. And the same has not been done and not properly appreciated the same. The counsel also vehemently contend that exhibit P8 is also cannot be accepted and quantum was sent for chemical examination is not stated. The author of the document is also not examined before the trial court and hence it requires interference of this court. Per contra, the counsel appearing for the counsel also vehemently contend that section 54 of Excise Act has not been complied with And in support of his argument, he relied upon the order passed by this court in criminal petition number 7033 of 2022. And so also criminal petition number 3398 of 2024, wherein discussion was made with regard to the compliance of section 54 of the Karnataka Excise Act. Per contra, the counsel appearing for the state would vehemently contend that the document exhibit P7 is very clear that could not get the warrant, search warrant, but reason was assigned for having conducted the search since credible information was received only at 6:30 and raid was conducted at 7 o'clock and reason has been recorded and the same was also intimated to the court. And apart from that, counsel appearing for the state would vehemently contend that evidence of PW 2 to 5 is consistent and not committed any error. And hence, both the courts have not committed any error and it doesn't require any interference. Having heard the petitioner counsel and also the counsel appearing for the state and also considering the principles laid down in the judgments record so far, and also the material on record, the point that would arise for the consideration of this court are whether the trial court committed an error in convicting and sentencing the petitioner, and also whether the appellate court committed an error in confirming the same, and both the orders requires interference of this court by exercising the revisional powers. What order? Having heard the respective counsel and also the principles laid down in the judgment report supra, it is not in dispute with regard to the compliance of section 54 is concerned. And also this court in the criminal revision petition number 7033 of 22, in paragraph number 8, discussed with regard to the compliance of section 54, wherein also it is categorically stated that when the respondent seizing the liquors without obtaining the warrant are not recording the reasons under section 54 of the Excise Act, seizing the articles and thereafter registering the FIR amounts to an investigation commenced prior to registering the FIR, which is mandatory in CRPC. In the said paragraph, it is also very clear that compliance of section 54 is also with regard to the recording the reasons under section 54 of the Excise Act for not obtaining the search warrant. And in the other revision petition, also criminal petition also in 3398 of 2024, the trial court also taken note of, this court has taken note of judgment of K.L. Subbaiah versus State of Karnataka, reported in 1979 within bracket 2 SEC 115, paragraph number 4. Also an observation is made that the entire search without jurisdiction and as a logical corollary, vitiates the conviction. We feel that both sections 53 and 54 contains valuable safeguards for the liberty of the citizen in order to protect them from ill-founded or frivolous prosecution or harassment. And also, in paragraph number 16 of the very same order, discussed with regard to on perusing the above said authority, it is clear, crystal clear that section 54 of the Act has to be complied. The warrant for search and seizure should be obtained for the offences under section 32, 33, 34, 36 and 37. First of it is only in the event of contingency, section 54 provides for search and seizure by excise officials without warrant to prevent the offender escaping or concealing the evidence that may be found against the accused. Whatever the information that the Commissioner of Excise or police officer had received regarding the commission of offence punishable under the Act. Having considered this judgment of this court as well as relying upon the judgment of the Appellate Court, it is very clear that if warrant is not obtained, reasons has to be assigned. in compliance of section 54 and having perused exhibit T7, it is clear that credible information was received at 6:30 and raid was conducted at 7 o'clock. And the region also assigned for conducting the search without obtaining the warrant, that there is a chances of escaping. And reason assigned, and hence the very contention of the petitioner counsel that there is no compliance of section 53, 54 cannot be accepted since the reason was given by the IO. And the same is also intimated to the court after conducting of the search. And these two judgments will not come to the aid of the petitioner counsel as contended. Now coming to the aspect of merit of the case is concerned. It is the evidence of prosecution that they have received the credible information. And PW5, who is the officer of inspector, who conducted the raid on credible information. And having considered his evidence, he says that immediately after having received the credible information, he called the punch witnesses, and punch witnesses given the consent to become witnesses for seizure. And thereafter he speaks about all of them went to the spot and seized the same. But evidence of PW5 is that on credible information he has secured the punch witnesses and went along with the punch witnesses. But the evidence of PW2, who is also the raiding party, in his evidence, in the cross examination, he says that except the raiding parties, that is belongs to their department employees, no other persons were there. And also he says that he was not having any credible information. But he says he was in the gust duty at 5:30. And distance between the Gaunipalli, where he was on bus duty, and Thadigold cross, distance is only 15 minutes. And he is also a party to the raid. But his evidence is contrary to the evidence of PW5. And PW5 says that he has secured the punch witnesses and went along with the jeep. But PW2 says that only the staff belongs to the department were there in the vehicle. The other witness, PW3 also, is a raiding party. And he says independent witnesses have not supported. And hence he himself and his staff, along with CHASA 1 and 2, called the CW 1 and 2 to conduct the search. But in the cross examination, he admits that CW 1 to 3 are also his co-staff. And hence it is clear that they are not the independent witnesses. And his evidence is also contrary to the evidence of PW5. And PW3 says that the independent witnesses have not cooperated. And hence called the CW 1 and 2, who are also their official co-staff. And hence it is clear that no independent witnesses were there. And PW4 is also, earlier he was also a raiding party. And at the time of evidence, he was working as PDO. And he also says that at 6:30 he was on gust duty. And conducted this search. But he says while taking the independent punch witnesses, they did not subject for their personal examination, what they are having. And the evidence of even punch witness or even the raiding party witnesses, PW 2 to 5, contrary to each other. And the very IO says he has secured the punch witnesses. But other witness PW3 says that independent witnesses have not given any consent and not cooperated and made the CW1 and 2 as punch witnesses. And they are also the co-staff of the very same department. But PW1 who has been examined before the court is an independent witness. But he did not support the case of the prosecution, but he says his signature was taken to exhibit P2. But in the cross-examination, he says that his signature was taken in the Excise department. And also he says that he was near the tea shop at the time of conducting the measure. And only on the call made by the police, he went to the spot. And hence it is clear that he did not accompany the raiding party. And inconsistent evidence available on record before the court was not taken note of by the trial court and appellate court. And both the courts have lost the sight of the answers elicited from the mouth of witnesses. No doubt, it is settled law that if the evidence of the even official witnesses also cannot be discarded, but there must be a credible evidence before the court. And having perused the evidence of these witnesses, there is no any credible evidence and contrary to each other. And even conducting the raid also contrary evidence, even IO says he has secured the independent witnesses, but other witnesses says that no, the independent witnesses have not supported, but made the CW1 and 2, who are also the co-staff of the raiding party, made them as witnesses for seizure. And when such being the case, very seizure itself is doubtful since PW1 says his signature was taken in the Excise department, not at the spot. And all these contradictions were not considered by the trial court. And no doubt, the court also cannot expect the mathematical niceties while considering the evidence available on record. But here is a major contradictions in the evidence of witnesses PW 2 to 5 with regard to the very seizure is doubtful since the evidence given by PW 2 to 4 is contrary to the evidence of PW 5. And hence, when there is no legal finding by the trial court as well as the appellate court, and also the reasoning given by the trial court and appellate court is perverse. And last sight of the material contradictions in the evidence of PW, particularly 2 to 5, the order suffers from legal infirmities and also the same is not in legality and correctness of the order, and hence revision petition is allowed and the impugned order requires to be set aside, and hence answer the point as affirmative. In view of the discussions made above, I pass the following order. Revision petition is allowed, impugned judgment of conviction and sentence is set aside, and consequently the confirmation order passed by the appellate court in appeal is also set aside, and accused is acquitted for the offence punishment section 32 and 38 of Karnataka Excise Act. The amount in deposit, if any fine amount, is ordered to be released in favor of the petitioner and proper identification. The bail bond executed by the petitioner is cancelled. ಇದ್ರಲ್ಲಿ TCR ಬಂದಿಲ್ವ ನೋಡಿ ಮೇಡಮ್, ಮತ್ತೆ ಇಲ್ಲಿ SCR ಅಂತ ಮಾತ್ರ ಇದೆ. SCR ಕೆಪ್ಟ್ ಬಿಲ್ ಅಂತ ಏನ್ 138 PCR ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ, ರೆಕಾರ್ಡ್ಸ್ ಹಾಕ್ಬೇಕು. ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿದಾರ ಅದರಿಂದ ಕ್ಲೋಸ್ ಆಗಿದೆ ಕೇಸ್. ರೆಕಾರ್ಡ್ಸ್ ತರ್ಸ್ಕೊಬ್ರಿ ನೋಡಿ. What are the material we'll see. Again, discharge application, only court has to look into the what the IO has collected, the material. Yeah. Special case here, ಒಂದೇ court ಹಂಗಾರೆ. Correct ಅದು. SCR ಅಂದ್ರೆ ಸೇಮ್ ಸೆಷನ್ಸ್ ಕೋರ್ಟ್. ಹಂಗ ರೆಕಾರ್ಡ್ ಇದೆ. TCR ಬರಲ್ಲ ಇದು. ಯಾರು ಅದರ್ ಸೈಡ್ ಯಾರು? MN ವೆಂಕಟೇಶ್ ಮೂರ್ತಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಇದ್ರ ನೋಡಿ. ಆಮೇಲೆ ಬಂದಿಲ್ಲ. ಹೋಗ್ಲಿ, ಅವತ್ತು ಇದ್ರ ನೋಡಿ. ಹೇಳೇ ಇಲ್ಲ. ನೋಡಿ. This revision petition is of the year 2021. Filed against the discharge. And counsel for the petitioner is present and counsel for the respondent is absent. If respondent counsel doesn't appear in the next date of hearing, matter will be heard in his absence. List this matter on. Yadar on date 5/3 na? 5/3.
73. G. Sukumaran.
Dr. G. Sukumaran, HCGP. An offense?
Legal Metrology Act ಕೆಳಗಡೆ. Legal Metrology Act ಕೆಳಗಡೆ 26. ಫೈನ್ ಹಾಕ್ಬಿಟ್ಟು.
Partly allowed. Accused number 1 is acquitted. This petitioner is accused number 2. Fine of rupees 50,000 in default sentence. Yes.
Alteration of the weights and measures. Whoever tampers with the or alters the any reference, standard of service, standard of working, standard of influences or increases or alter any weight or measures of the people. Decision any of the knowing or having its use to any of the society to be decision that except if there is an alteration is made for that any of the persons likely to be miscarried and error in notice to carry verification after the time of the accepted 50,000 rupees and subsequently happens to the Now, the case number 2, he is a professional doctor. He is not the owner or dealer of the that modification agency of petrol bank. And your honor, what has happened? He is an husband of A1. And the A2 also was, A1 also was not there in this thing. A2 having gone there some episode. And he has been made as an A2 without there being an ingredients that he is. What has happened? Either I should be a license holder or not the dealer. The prosecutor is actually paid to show that I am the owner or not the dealers. And because I am an husband here on and lordship and the devil. And it has been made observation in the first appellate court. I'll just take you only that portion of that. I won't go deep in the evidence also speaks. I'll get include judgment passed with page number 28. The London Council for the Appellate para 7. The London Council for the Appellate has submitted that the judgment passed in trial court is not a proper. The procedure adopted by the trial court for dispensing with the sworn statement and complaint and taking in a copies of alleged minority and the entire proceeding of initiated. There is no documents produced to show that who the owner of the petrol bank or any person responsible for allegedly tampering the vessel. According to the complaint, both accused 1 and 2 are the dealers, which is the impermissible. And it's nowhere it's coming, neither the complaint is produced, nor the PCR is produced, nor the stated out. So the accused was not at all present as in the date of alleged inspection conducted by the complaint. It is part of an evidence. So the complaint lodged IOCL, no proper inquiry has been held by the complainant and false case has been registered against the appellant. One cinemas law who had allegedly inspected the spot behalf of the IOCL along with the complaint on 17/8/2018 is not being examined. It's not being examined. Complaint itself. There is a delay more than 2 months in presenting the complaint after the alleged inspection, which is not the complainant. The mere presence of accused one at the petrol bank cannot imply that she was responsible for or in charge of it or its affair. No document is produced in this regard. There is no evidence to show that the seal were removed from the dispensing petrol and how the section 26 Act has been violated. There has been only one punch up at the exhibit P2. The marker and does not contain a signature at all. There is no specific violation mentioned in the marker, merely because of the accused one has signed exhibit P3, the name of accused number 2, only the mention that she has not at all concerned with the petrol bank in any manner. As for the exhibit P4, the letter of the supply of a petrol bank alleged tampered dispensing the pump of stock to give in the question of using same on 17/8 at the time of an inspection of the complaint cannot be believed. Oral evidence reduced a prosecution totally inconsistent, a contrary to each other. The prosecution has not adduced sufficient evidence to prove that there is any violation on section 26 of the Legal Metrology Act 2009. The finding of a trial court are not based upon the proper appreciation of an evidence, and the improved judgments, conviction, and order of sentence imposed by the appellate are liable to settle the court. Now, the first appellate court accepts the version of mine. And what has happened?
Not accepts, that is only the contention, your contention in paragraph number 7.
Well, 7.
That is the arguments in the appeal.
That's the argument I was put forth and the trial, the first appellate court also accepts it. I'll come back to you. It's my pleading before. The land of prosecution has supported the improved judgment. The finding is containing that it has been contended that the appellant has not been challenged, the framing of the charge against it, and the ground for relating a dispensing salt statement, and the complaint for taking the cognizance of an alleged offences cannot be considered at this stage. It's not a curable disease. It's a curable, what has happened? It's exhibit P5 to exhibit say as a photograph which shows that the appellant is running a petrol bank. Which appellant is not been said? They have been not demanded the machinery was installed in the safe petrol bank. There is no sanction to make PW 1 and 2. The reward the alleged grounds taken in the by court as cannot be considered. But even the statement of an accused person is recorded in the 313 statement CRPC. There is no examination of a stating that accused one is related to the petrol bank. The accused appellant is guilty of having tampered the dispensing the pump and cheated the public of the past for further supply. And this the court and the ground for a made for interfere with the judgments of the trial court. There is no merit in appeal and same is that the counsel for the appellant prosecuting the pursuit the trial court for improving whether this court the issues of plain like whether the prosecution has proved beyond reasonable doubt. And the appellant accused number 1 and 2 have committed an offence punishable under section 26 of the Legal Metrology Act 2009. Whether the improved judgment degree has called for a trial court for any interference, what's all. Answer the point 1 and 2 are partly in affirmative, point 3 in only. It is specific case of the prosecutor that the appellants 1 and 2 have committed an offence punishable under section 26 of Metrology Act, since both toddler and one of the pulsar unit of MIDCO DCU have an SI sources who were broken, cut in not a single piece as a result of a different quantity of petrol supplied to the public from the safe dispensing pump. In order to bring home the guilt of the appellant under section 26 of the Metrology Act, 2009. The prosecution is required to prove that they have tampered or altered with in any manner weight of measures with a view to deceiving any person knowledge, having a reasons to believe that any person likely to be deceived. In such a case, the only defense available to the accused would to prove that the alteration is made for the correction of any error noticed therein or verification. PW1 Kumar is a complainant who was deposed about the incident leading to the procedure exhibit before the complaint. Against the appellant exhibit report, a letter dated 7/7/2018 addressed to the Indian Oil Corporation Limited to the complainant, assistant controller, legal matter caller, bringing to this notice about the discrepancy of the dispensing pump at the seal measure being broken and not the one single piece. Magashibal Vishnu, agency IOCL petrol bank based on exhibit report, letter of PW1 and inspected IOCL petrol bank in the name of Magashibal Vishnu, agency situated in Kota Road at Bantamangala, Bangarpet Taluk, Kolar district, which is an authorized dealer under the IOCL. According to the records, the accused to MR Ingerson is a proprietor, Magavishnu agency and the dealer of IOCL, a petrol bank. On inspection of the conductor PW1 along with the Srinivas Rao, IOCL at 17/8 is the release 430p. It is noticed that the seal of dispensing pump was bearing so was tampered. But thus the Panchalama was conducted as per exhibit P2, 430p, 530p, the presence of PW2. The Gopal Krishnan and the said nozzle dispensing the pump of seals of the exhibit P3. They see the receipts issued for the PW1. Notice that the appellant accused number 1 was signed behalf of the institution would authorize dealer of a petrol bank, exhibit P3 and exhibit P1. P3 to 9. A photograph taken into the conducting of such inspection, exhibit P6, 7 clearly show that the muzzle dispensing unit of the tamper cut there relating to the less quantity of petrol supplied to the customers. During the cross-examination of PW1, admits that he has not named V. Suresh Kumar, IOCL, who was issued exhibit report letter as a witness in the complaint. He further said that the independent witness refused to cooperate when he was conducted exhibit P2. The master in the petrol bank did not agree in the punch-out. He further said that he had prepared exhibit P2. The master at the spot using his laptop. He has clarified the exhibit P6 photograph shows that the dispensing pump installed in the petrol bank and seal containing therein was cut. However, admits that there is not proving the model of a sample. A seal was affixed to dispensing unit, a petrol bank before the court. He also admits that the pulse unit of installed in IOCL at the time of commencement of a petrol bank. PW2 Gopal Krishnan witness exhibit P2, the master who was repaid with respect and aspect sees the dispensing pump even during the cross-exam PW1 as deposed about the presence of appellant number 1. Accused number 1 is the petrol bank. Admits that he has not stated about the designation and the date of the signing of exhibit P2, master though it is a normal practice. On the consideration of the oral documentary evidence adduced by the prosecutor, it is noticed that the dispensing pump of bearing so installed in one of the pulsar unit of Maharashtra agency, IOCL petrol bank was tampered, cut with an intention to cheat the customer and the supply this quantity of petrol. The appellant 2 was not taken any action by lodging any complaint with the IOCL or getting the said measures repaired. In order to show his bona fide, the unit has been seized from the said place. The appellant 2 has not taken a defense that he has not consented with the said petrol bank and has not denied that he is an authorized dealer and that IOCL. The responsibility of the dealer of the petrol bank to ensure that the sealed measures installed in dispensing the petrol through pump of a properly metered. There is also an explanation offered in accused number 2, either during his evidence while recording his statement under section 313.
Whether they have drawn the petrol lesser quantity?
No, it was broken. It was reported. They came and saw. Then the IOC said
Without drawing the petrol, how they can comes to a conclusion that it was lesser quantity in the.
It is not being supplied because there was There was some galata, the petrol bank was broken, it was existent, then they complained. Because the wife was the one that she had given a complaint to this, they did not come and repair. They put the blame on the, these people itself.
ಅಲ್ಲ ರೀ ಸ್ವಲ್ಪ ಶಾರ್ಟ್ ಇದೆ ಪೆಟ್ರೋಲ್ ಅನ್ನೋದ್ ಕಾರು ಎಲ್ಲಿದೆ ನೀವು ಏನಾರು ತಗೊಂಡು ಸ್ಯಾಂಪಲ್ ತಗೊಂಡು ಇಷ್ಟ ಇದೆ ಎಷ್ಟು ml ಕಡಿಮೆ ಇದೆ
ಅದ್ ಮಾಡಿಲ್ಲ,
ಆ ಥರದ್ ಏನಾರು ಇದೆಯಾ?
ಅದ್ ಮಾಡಿಲ್ಲ.
ಅದೇ ಮಾಡ್ಬೇಕಲ್ಲ ಮೇನ್.
ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
How you can come to a conclusion that there was a shortfall of petrol ಅಂತ? ಈಗ ಒಂದ್ ಯಾರು ಬಂದು ಹಾಕ್ಸ್ಕೋತಾರಪ್ಪ 1 ಲೀಟರ್ ಹಾಕು ಅಂತ ಹಾಕ್ದಾಗ ಅದು ಡ್ರಾ ಮಾಡ್ಬೇಕು. ಡ್ರಾ ಮಾಡಿದಾಗ ಈಗ ಲೆಸ್ಸರ್ ಕ್ವಾಂಟಿಟಿ ಇದೆ ಅಂತಂದ್ರೆ ದೆನ್ ಯು ಕ್ಯಾನ್ ಸೇ ದಟ್ there is a lesser quantity ಅಂತ. ಏನಿದೆ ನೋಡಿ ಒಂದ್ಸರಿ ಚೆಕ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಪೋಸ್ಟ್ ಮಾಡಿರ್ತೀನಿ ನಾಡ್
ಪ್ಲೀಸ್.
ನೋಡಿ ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್. This matter on Tuesday madam 25/2. ಅದೇ ಮೇನ್ ಆಕ್ಚುಲಿ ವಾಟ್ ಇಸ್ ದ ಶಾರ್ಟ್ ಫಾಲ್ ಅಂತ.
Even then, it's not been, what you rightly said it, that's
ಹಾ
not.
ಎಮೋನು ಇಲ್ಲ ಎಂತದು ಇಲ್ಲ ಕ್ವಾಂಟಮ್ ಇಲ್ಲ ಎಂತದು ಇಲ್ಲಲ್ರಿ ಇದ್ರಲ್ಲಿ.
Complaint.
Then how a appellate court?
Lordship could see that private complaint also is a way. The way just 4-5 lines you need it, and Mazen, another Mazen.
ಅದೇ ಇಂಪಾರ್ಟೆಂಟ್ ನೋಡಿ ಏನಾರು ಇದೆಯಾ ಅಂತ. This matter on 25/2.
74. Prakash K.
PCR SPP served. ಏನ್ ಮ್ಯಾಟರ್ ಏನ್ ಮೇಡಮ್?
279
ನೋಡಿ petitioner counsel is absent, HCGP is present. If counsel for the petitioner doesn't appear in the next date of hearing, amicus curiae will be appointed. 279
279 304A.
ಮೇಲೇನು ಯಾವ್ದೋ ಒಂದು ಇದ್ರ ಮ್ಯಾಟ್ರ್ ಇತ್ತು ಮೇಡಮ್, ಅದ್ರಲ್ಲೂ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಬರುತ್ತೆ. ಇದಿರ್ಬೇಕಲ್ಲ ದಿಲ್ರಾಜ್ ಜೂಡ್ ರೋಹಿತ್ ಅದ್ರಲ್ಲಿ ಇರ್ಬೇಕು 70 ಇಫ್ ಕೌನ್ಸಿಲ್ ಡಸಂಟ್ ಅಪಿಯರ್ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ವಿಲ್ ಬಿ ಅಪಾಯಿಂಟೆಡ್ ಅಂತ ಮಾಡಿ. ಮೋಸ್ಟ್ಲಿ ಇದು ಸ್ಟೇಟಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಅದ ಅಥವಾ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಯಾವ್ದ್ರಲ್ಲೂ ಮಾಡಿದೀನಿ ನೋಡಿ. ಸ್ಟೇಟ್ ಪಾರ್ಟಿ ಇದ್ದಾಗ ಅದ್ರಲ್ಲೂನಾ ಹಾ ಅದು ಅಷ್ಟೇ. ಅದ್ರ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಏನೋ ಸೂರ್ಯ ನಟರಾಜ್ ಶರ್ಮಾ ಅಂತಿದೆ ನೋಡಿ, ಅದನ್ನು ಅದಿದ್ರ ಅಲೋ ಮಾಡಿದ್ದ 71. ಆಯ್ತು ಸರಿ. ಪ್ರಕಾಶ್ ಕೆ ಇದ್ರಲ್ಲೂ ಮಾಡಿ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ವಿಲ್ ಬಿ ಅಪಾಯಿಂಟೆಡ್. ನೆಕ್ಸ್ಟ್ ವಿಜಯ ಅರ್ಜೆಂಟ್ 76 ಕುಮಾರನ್ MS ನಾಗರಾಜ. ಏನ್ ಮ್ಯಾಟ್ರ್ ಇದು? 138. Petitioner counsel present, counsel for respondent absent. If respondent counsel doesn't appear in the next date of hearing, matter will be heard in his absence. This matter on 5/3. 77 ರಾಜೇಂದ್ರ ರೆಡ್ಡಿ ಹೇಳ್ರಿ ಏನಿದು ಸುಮಾರು ದಿವಸದಿಂದ ಬರ್ತಾ ಇದೆ.
ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ, ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡಿ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ.
ಕಂಪ್ಲೈ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಮಾಡಿ.
ಏನ್ರಿ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಏನೋ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಅಂತಾರ ನೋಡಿ. ಮಾಡಿದಾರ? ವೆರಿಫೈ ಮಾಡಿ. ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸಬ್ಮಿಟ್ ದಟ್ ಆರ್ಡರ್
ಎಂಟ್ರಿ ಮಾಡಿರಾಗಿತ್ತು. 10/10/2023 ಎಂಟ್ರಿ ಮಾಡಾಗಿತ್ತು ಮಲ. 23 ಆಗಿ ಇದುವರೆಗೂ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ ಮೇಡಮ್.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ನೋಡಿ ಮೇಡಮ್.
10 lakhs 50% ಕಟ್ಟಿ ಅಂತ ಹೇಳಿ 50% ಕೂಡ ಪೇ ಮಾಡಿಲ್ಲ ಮೇಡಮ್.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ, ಅದ್ರಲ್ಲಿ ಏನಾರು ಇದೆಯಾ ಡೆಪಾಸಿಟ್ ಮಾಡಿರೋದು? ಕೊಡಿ. 10/10/23 ನಾ? 10/10/23 ನಂತರ 2,40,000 ಏನೋ ಮಾಡಿದಾರಲ್ರಿ ಅಕೌಂಟ್ ಸೇರಿಸ್ತಿದಾರ ಅಲ್ಲ. ಅದು ಡೇಟೆಡ್ 14/2/22 ಅಂತೇನ ಇದೆ. 30/10/23 27/10 ಯಾವಾಗ ಆಗಿರೋದು ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್? 10/10/23 issue attachment warrant accused to the presence before the court ಅಂತ ಆಯ್ತು. Issue to accused and sent back to RK branch. Conviction warrant. Advocate for complainant has filed an advance application and prays advance the case. Board. Arrest warrant to accused. Filed an advance application on 304 to place advance the case on today's board. Received the intimation for call for record from the Honorable High Court of Karnataka, Bangalore. For reference in criminal RP number 1046 of 23. ದುಡ್ಡು ಕಟ್ಟಿದಾರ ಏನ್ ನೋಡ್ರಿ ಏನ್ ಇದ್ದಂಗೆ ಇಲ್ಲ ಇಲ್ಲಿ
ಕಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ದುಡ್ಡು ಕಟ್ಟಿಲ್ಲ
ಹೌದಾ
ಕಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ
ಆಯ್ತು ವೆರಿಫೈ ಮಾಡ್ಲಿ ಹೇಳೋಣ ತೊಗೊಳ್ಳಿ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ ಆನ್ 10/10/23 ದಿಸ್ ಕೋರ್ಟ್ ಸಸ್ಪೆಂಡೆಡ್ ದಿ ಸೆಂಟೆನ್ಸ್ subject to condition to deposit the ಎಷ್ಟು amount 50%. 50% and the same has not been complied. Counsel for the petitioner present and he is not aware of whether compliance is made or not and hence list this matter on 27/2 whether the order has been complied or not. Reports the same. 27/2 ನೋಡಿ ಅಷ್ಟೊಳಗೆ ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಆಗ್ತದೆ. 78 Naeem Pasha. G. Balakrishna.
The respondent. This is a case wherein my lords accused has admitted the check amount. That is the liability. Therefore, my lords, nothing would survive.
Is ನೀವು ಒಂದು appeal act revision
For enhancement, my lords.
enhancement
Check amount na ಹಾಗೆ
ಚೆಕ್ ಅಮೌಂಟ್ ಮಾತ್ರ ಮಾಡೋರಾ
ಅಷ್ಟೇ ಇರೋದು. Check.
The actual amount was 2,25,000 is the amount which is
Please.
transacted.
Please.
Case ಏನಂದ್ರೆ check very frank 2/8/2014 ಗೆ 1,06,2,00,000 ಕೊಟ್ಟಿದ್ದಾರೆ. 21/10/2014 ಗೆ 20,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು ನೋಡೋಣ ಎರಡು ನಿಮ್ಮ ಇಬ್ರದು ರಿವಿಷನ್ ಇದೆ ನೋಡಿ
ಡಬಲ್ ದಿ ಚೆಕ್ ಅಮೌಂಟ್
ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಬಂದಿದೆಯಲ್ಲ
ಪೇಮೆಂಟ್ has been withdrawn by them.
Half the amount.
ನಿಮ್ 50% ಡೆಪಾಸಿಟ್ ವಿಡ್ರಾ ಮಾಡಿದಾರಾ ನೋಡಿ ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 5/3. ಯಾವ್ದು ಮೊದ್ಲು ಯಾವ್ದೋ ಕೇಸಲ್ಲಿ ಕೊಟ್ರು ಅವ್ರು ಇದ್ರ ಇಟ್ಕೊಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ. ಅದ್ಯಾವ್ದೋ ಎಕ್ಸೈಸ್ ಆಕ್ಟ್ ಮುಗಿತಲ್ಲ
ಅರ್ಜೆಂಟ್ ತೋರಿಸ್ಬಿಡಿ. 71 ಅಲ್ಲಿ ಇದು
27 ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು 77. ಫೈನಲಿ ಅಲ್ಲ.
ಕನೆಕ್ಟೆಡ್ ಬೇರೆ ಇದೆ. ಪಿಕಪ್ ಮಾಡೋದಿಲ್ಲ ಈಗ. ಇವತ್ತು ಮಾಡಿದ್ದೀರ ಅದ್ರಲ್ಲಿ ಕನೆಕ್ಟ್ ಆಗಿರೋದಿಲ್ಲ. ಅಡ್ಮಿಷನ್ ಈಗ ಚಂದ್ರಶೇಖರ ಕಾರವಾರ ಬಂದು ತೋರಿಸ್ಬೇಕು. ಏನೊಂದು ಒಂದು 10 ಪೈನ್ ಒಂದು 10 ಪೈನ್ ಇತ್ತ ಎಷ್ಟು ಅವತ್ತಲ್ಲ 10 ಇತ್ತು ಅಷ್ಟೇ. ಒಂದು 10 ಪೈನ್ ಇತ್ತು. ಅದು ಅದೇ ಕಳಿಸ್ಬಿಡಿ ಮೇಡಮ್. ಅದು ನಾವು ರೆಗ್ಯುಲರ್ ಸೇರಿಸಿ ಬ್ಯಾಚ್ ಹಾಕ್ತೀವಿ. 10 ಪೈನ್ ಇವೆರಡು ಮತ್ತೆ ಮಿಕ್ಕಿದ ಯಾವ್ದು ಕಳಿಸ್ತೀವಿ. ಇವೆರಡು ಅದೆಲ್ಲ ಬರುತ್ತೆ. ಅದೆಲ್ಲ ಬರ್ಲಿ. ಅದೆಲ್ಲ ಇವೆರಡು ಇದಿಷ್ಟ ಇಲ್ಲ ಇವತ್ತೇ ಆಗೋಗ್ತಿತ್ತು. ಅವರೇ ಆರ್ಗ್ಯೂ